on the burning topic of today's time, that is sexual offences against women.
स्टार्ट
I
हो
take
गया
immense pleasure in sharing a few lines on IPEM Law Academy, which is situated in Ghaziabad, Uttar Pradesh, India, and is a part of IPEM group of institutes under the aegis of Laksh Educational Society. On the completion of 25 years of its excellence, IPEM Group
वो
constitutes
आवाज
to build on its reputation as a premier institute offering programs in the field of not only management and information technology, but in law and education too. The fundamental missions of IPEM Law Academy is to provide its students with the knowledge, skill, and ethical values needed
हल्का
for
बहुत आ रहा
a collaborative efforts of our faculties, guest speakers, and legal scholars consistently endeavor to the development in the students as a sense of responsibility to serve the society in the field of law by developing skills in advocacy, judicial, and other legal services, to impart high quality legal education and to develop overall personality of the students in a disciplined environment. To prepare lawyers of tomorrow for handling legal issues
बस
not only restricted to the national boundaries but also complex cross-border transactions by developing legal skills in core specialized
हाँ
areas such as
नहीं
business laws, cyber laws, and trade laws. To organize lectures, seminars, and conferences for the dissemination of legal knowledge and to make law and legal process efficient instruments of the social development. IPEM Law Academy considers aspects of teaching and assessment where the students are given different choices and flexibility. It adopts different teaching methodologies for imparting knowledge, for instance, through lectures, discussions, problem solving, role play simulations, debates, etc. There is always a regular evaluation which improvises the quality of course and teaching. As we all know that light and brightness has always been equated with the positivity and motivation. With this auspicious note, I would like to invite the patron of IPEM Group of Institute, uh, Mr. Anupam Goel. This is the, I would like to invite the director and advisor of IPEM Law Academy, Professor Dr. B.P. Sehgal, sir, Dean, Outreach, International Affairs, Dr. Dolly Phillips, ma'am, Director of IT Department, Dr. Naveen Kumar, sir, Principal of Center of Teacher Education, Dr. Nishi Sharma, along with the Principal of Law Department, Dr. Meenakshi Gautam, to please come on the stage and do the last writing.
honors. The theme of today's seminar is a highly deliberated topic in almost all countries, regions, cultures, and communities. Today, we are here with an esteemed gathering amongst us who will be presenting their research papers on the topic sexual offences against women. To elucidate more on the theme of today's session, I would like to invite the Director and Advisor of IPEM Law Academy, Professor Dr. B.P. Singh Sehgal sir, for the introduction of the theme.
Good morning, ladies and gentlemen. I extend a warm welcome to all the participants from India and abroad who have joined us today to discuss the status of women and the offences which are committed against them, not only in India, but in various societies. I am grateful to all the participants, especially Professor S.C. Srivastava, who has joined us from San Francisco, USA, Professor Manjula Batra, former Dean of the Jamia Millia Islamia University, Colonel Dr. Mahendra Jang Shah, Judge Advocate Colonel from Nepal Army, Kathmandu, Professor Dr. Muhammad Abdul Ali from Rajshahi University, Bangladesh, Dr. Prannam from Brampton, Canada, and many other my colleagues from different universities in India and as well as from NCR area. The subject regarding the status of women has been a subject matter of discussion right after independence. Before that also, but after independence, we enacted so many legislation from time to time for the emancipation of women. But it's very strange that still after 70 years of the working of the Constitution, and despite so many legislations enacted from time to time by the Parliament of India as well as by the state legislatures, still we are talking about the reservation for women, her status regarding education, employment, domestic status, so many issues. And so many crimes are committed against women, which are highlighted in the press from day to day. So it's very strange thing that why these laws, which have been enacted for the last so many years, are not functioning properly. Is there any defect with the laws, or is there any defect with the mindset of the people of the society? These are the issues which we have to discuss today in the various academic sessions of the seminar. I will just give a brief introduction about the issues which we are facing today. Women who constitute almost half of the world population and enjoy equal status with men folk as per the constitutions and statutes of respective countries as per the guidelines laid down in international instruments. They are contributing equally to the growth and development of the national resources. In India especially, despite the working of the Constitution for the last about 70 years, guaranteeing equal rights to women and various social welfare legislations for the emancipation of women, still we talk of reservation for women in parliament, state assemblies, local bodies, etc. Still we discourage the education, employment of women, especially in the rural areas. Though there have been big changes during the last 70 years, but still we find in rural areas, the women, they are not encouraged for going for the higher education, for employment, and other things. Even nowadays, in many rural areas, the role of women is confined to household, bearing and rearing of children, and her status is identified with the dowry which she brings at the time of marriage or the number of children she bears, especially the sons. Her education or other qualities become secondary. We have plethora of laws and statutes dealing with emancipation and protection of women, but still we talk of discrimination and raise issues for her protection. This discrimination with women cannot be changed with laws until we change our attitudes towards women and encourage her education and employment both in rural areas as well as in urban also. Her role in nation building and development must be given more importance. Despite her contribution in the life of individuals, human beings, she still belongs to a class or group of society which is in disadvantaged position on account of several social barriers and impediments. The face and style of women exploitation has changed from visible to invisible. However, the quality and extent is unchanged. Today, women are playing multitasking roles. A working woman nevertheless has to be all-rounder. She has to be constantly keep in mind home, fulfill its requirements first before she leaves her house. Still, women are dominated, suppressed, harassed, ill-treated, subjected to mental and physical violence, and sometimes even denied of their basic human rights. They are the ones who are made to sacrifice and suffer without any right of complaining for it. Violence against women is rampant in all corners of the world. Such violence is a human rights violation that manifests itself in a number of ways, including violence against women in custody, acid attack, bride burning, physical, emotional, economic, and psychological abuse, domestic violence, female genital mutilation, human trafficking, dowry death, honor killing, human rights violations based on actual or perceived sexual identity, sexual assault and harassment at workplaces, rape, kidnapping and abduction, molestation, gender-based asylum, importation of girls, etc., are rampant not only in India but at global level. A central theme in the women's movement all over the world has been violence against women, both in their home and outside. The first categories of violence focused on were rape and murder of young bodies, young brides for dowry. Rape is a crime not only against the person of a woman, it is a crime against the entire society. Dowry in the sense of bride's price or bridegroom's price spread like a contagious disease and ultimately became a regular practice. We know that we had an incident known as Nirbhaya rape case, where the victim, she was not only brutally gang raped, but as well as subjected to torture, and ultimately that led to the death of that young girl. And there was a lot of protest throughout the country, as a result of which the government of India constituted a Justice Verma committee, which was requested to go through all the laws relating to the protection of women and make a recommendation. Justice Verma submitted a report in January 2013. It made recommendations on laws related to rape, sexual harassment, trafficking, child sex abuse, medical examination of victims, police, electoral, and educational reforms. On the basis of this report submitted by Justice Verma Committee, the amendments were introduced in the Indian Penal Code, and some new sections were also added in this Indian Penal Code. The first recommendation that was made that the punishment for the offense of rape has been increased. Now this goes up to the life imprisonment. Besides that, new sections have been added. Some new crimes have been identified, which have been introduced in Indian Penal Code. For example, Section 354A has been added, which defines sexual harassment, including physical contact and advances, demand or request for a sexual favor, showing pornography, and making sexually colored remarks. This is a new section which has been introduced, new offense has been identified. Then we have section 354B, which defined assault or use of criminal force to women to disrobe or compelling her to be naked. This is also a new offense which has been added. Then section 354C has been added, defining voyeurism, including watching and capturing the image of a woman engaging in private act in circumstances where she would usually have the expectation not being observed by anyone. So that is also a new offense which has been introduced in the Indian Penal Code. Then a new section was added, section 354D, defining stalking, whereby a man follows a woman and contacts to foster personal interaction despite a clear indication of disinclination by such women or any other mode, or monitors the use by a woman of internet, email, or any other electronic mode. This is also a new offense which has been added. Then section 366A has been added, that is procuration of a minor girl with intention of force or seduce to illicit intercourse with another person. Section 366B also has been added regarding importation of girl from foreign country under the age of 21 with intention of force or seduce for illicit intercourse with another person. Similarly, section 370A has been added regarding exploitation of a trafficked person and engaging such person for sexual exploitation. Section 376A has been added, where the punishment for rape has been increased to life imprisonment, and some new crimes have also been identified connecting with rape. That is section 376A, where punishment for causing death or resulting in persistent vegetative state of mind shall be rigorous imprisonment for a term not less than 20 years or may be extended to life imprisonment. That means a person who had intercourse with a lady who is in vegetative position, who is not in her senses. If a rape is committed on that woman, that in the new section which has been added, the punishment for that is 20 years or may be extended to life imprisonment. Here, life imprisonment means the whole of the remaining natural life. The accused has to remain in jail for whole of the remaining natural life for committing this offense. Similarly, section 376B has also been added regarding sexual intercourse by husband upon his wife during separation. If there is a separation between husband and wife, and husband commits sexual intercourse, that is also an offense. That is just to create awareness among the communities. Then section 37C, sexual intercourse by a person in authority in fiduciary relationship, public servant, superintendent or manager of a jail, remand house extra, or on the management or staff of the hospital. Rigorous imprisonment has been provided for the offences committed under this section upon the victims which are under the custody of a public servant. If that public servant commits an offence of rape upon a victim which is under his custody, maybe in the position of a hospital superintendent, maybe this jailer, police officer, if they commit such an offence, then a rigorous imprisonment of life imprisonment and or the whole of the remaining natural life, that person has to remain in jail. Then section 376D has been added, that is gang rape. Punishment is rigorous imprisonment for a term not less than 20 years, which may extend to life imprisonment. And in case a person is a repeated offender, then the punishment is imprisonment for life. So these are the new sections which have been added into the Indian Penal Code on the recommendation of Justice Verma Committee. But what is the response? What we are going to get out of these amended laws? Do you think that we are going to achieve the purpose by amending the laws? I am going to throw light on this issue also. An unresponsive law and order mechanism inhibits women from filing complaints at work or with the police. Even for as serious a crime as rape, a police officer will often advise the victim to withdraw the complaint and instead strike a compromise with the rapist. This is happening in our society. The police officer gives a piece of advice that you go for a compromise, you get some compensation from the accused and close this case. This mindset has to be changed. According to a survey conducted by Indian Bar Association in 2019, as many as 70% women said they did not report sexual harassment by superior because they fear the repercussions, because they may be turned out of their job. Because of this fear, they don't report such cases of sexual harassment. Sexual offense against women is not an exclusive problem for the police or criminal justice system of any country as such. In fact, sexual offense is an outcome of a particular mindset of some erring individuals who develop a wrong perception towards women folk during the course of their socialization. Stringent legal measures with their strong enforcement may definitely be useful in controlling such behaviors in society, but that cannot achieve the desired results unless legal measures are supplemented by a wide range of extra-legal preventive programs developed in mutual cooperation and with the assistance of government organizations, concerned professional associations, community organizations, research institutions, etc., in close collaboration with the police and other law enforcement officials. There is a need to reform the images of women in society that have been created over by centuries by the history, mythology, and social custom. Women must be considered as individuals who are equal to men in their own right. There is no dearth of laws for reducing sexual crime against women in any country. What is lacking is their proper implementation. There are many reasons for their inadequate enforcement. Some of the prominent ones are inadequate infrastructural facilities, lack of training and orientation of functionaries, lack of awareness among the victims, indifferent attitude of the community, etc. Therefore, instead of creating more laws, all efforts should be directed to enforce the existing ones. There should be a meaningful discussions between the police, lawyers, judges, legislators, and the representatives of women organizations at regular intervals. Conferences, seminars, and workshops should be frequently organized and mutual experiences should be exchanged. Recently, the Supreme Court on 18th March last month, 2021, pronounced a very important judgment where the judges said, where the Supreme Court judges said that judges of the lower judiciary must desist from misdiagnostic and patriarchal stereotypes by commenting upon the dress, behavior, past conduct, or morals of the survivor of gender violence and strongly disapprove the courts suggesting marriage between an accused and a survivor as a compromising rape or molestation cases. So our judges nowadays, they don't rely upon the laws or facts or evidence. They have also become socially forward politicians. Rather, instead of giving punishment to the accused, they give their suggestions for mediation. They comment upon the dress of the women, why you are wearing jeans, why you are wearing this skirt, why you are wearing this type of dress. That is none of the function of the judges. Mindset has to be changed. If an accused has been produced in the court of law, this is the duty of the judge to punish that accused on the basis of the law, facts, and evidence, not to make these types of comments. Emphasizing a need to avoid trivializing a survivor of gender violence, a bench of Justice A.M. Khanwilkar and Justice R.S. Ravindran Bhatt said, judges can play a significant role in the society, rejecting harmful stereotypes and have an important responsibility to base decisions on law and facts in evidence and not engage in gender stereotyping. It said reinforcement of such typification in court utterances or orders extraneous to the case would impact fairness of the court proceedings. The Supreme Court directed the judges to undertake a course on gender sensitization. So now these types of views have come from the Supreme Court. These are very important, and hopefully these will be followed by the subordinate judiciary also. The Supreme Court judges also mentioned that the subordinate judiciary should undergo a training on gender sensitization. So today during various sessions, we are going to discuss all these issues in our various technical sessions. The papers have come on all these issues which we will discuss. The papers will be discussed in the 4 technical sessions. The first is on sexual offences in general. Second is sexual harassment at working place. Third is rape and physical assault on women. And fourth is on sexual assault on women. I hope that we will have very fruitful discussions. So thank you very much for giving a patience hearing to me. Thank you very much.
Thank you, sir. The next segment of the inaugural ceremony has been scheduled as the welcome address by Director General Sir of IPEM Group of Institutes, Colonel Dr. A.S. Malhotra. However, due to some unavoidable circumstances, our Director General Sir is unable to attend this session. He sends us his good wishes for the success of all. On his behalf, I request Associate Professor Dr. Neelam C. of the IPEM Law Academy to give the welcome address.
Thank you so much, Raghunath. On the behalf of our patron, Mr. Anupam Goyalji, our Dean Academic, Professor Dr. Sugandha Goyal, the management, faculty, staff, and students of the IPEM Group of Institutions, welcome you all who have joined us on Zoom or YouTube, and wish you a very good morning or appropriate greetings as per the time zone in the area from where you are participating today in this international e-seminar on sexual offences against women. We are indeed privileged to welcome our national and international speakers. Professor Dr. S.A. Srivastava, former Chairman and Dean, Faculty of Law, Secretary General, National Labor Law Association, presently in San Francisco, USA. Dr. Manjula Batra, former Dean, Faculty of Law, Jamia Millia Islamia, presently Professor, School of Law, North Cap University, Gurugram. Colonel Dr. Mahendra Jamshah, Judge Advocate General, Army from Nepal. Dr. M. Abdul Alim, from Professor, Department of Law, University of Rajshahi, Bangladesh. Dr. Tarannum Khan and Ms. Sumitra Chaudhary from Brampton, Canada. Dr. Seema Singh, Faculty of Law, Delhi University. We are also privileged to welcome the paper presenters who have submitted their research paper for sharing the same at this international e-seminar. We are greatly appreciate their efforts. We are happy to state that there has been an overwhelming responses from the academicians, research scholars, and practicing professionals for submission of papers both from India and abroad. We are grateful to all of you for your participation. We also welcome all those who are attending this international e-seminar on this very important and unrelenting theme and subjects. I'm sure all of us will gain a lot. All the papers have been checked for plagiarism and reviewed by the experts, and only the selected papers are being presented in this e-seminar. So I request all the participants and attendees to please remain connected through Zoom or YouTube as the case may be throughout the proceedings of the seminar. Now, for the benefit of our international and national participants from other parts of India, I would like to say a few words about the IPEM Group of Institutions, which is hosting this international e-seminar. The institute is located at Ghaziabad, adjacent to Delhi, the capital of India, and comes under the National Capital Region. The institute was established by late Dr. B.S. Goyal with over 55 years of teaching and respective research experience in 1996, and now we are in our silver jubilee that is 25th years of existence. The institute is ISO 9001-2015 certified, NAC accredited, and research center of the university. The institute conducts professional undergraduate and postgraduate courses in the areas of management, information technology, education, and law, with all the approval of the confirmed professional bodies and affiliation to the university. Ever since its inception, the IPEM is known for its student-centric approach in teaching and discipline. Also, has had very good results and placements, thereby ranked among the top few institutes in the NCR. As we are aware, the COVID-19 has affected all of us across the world, and the education sector is no exception. However, we are happy to state that the management faculty, staff, and students at IPEM took it as a great challenge, despite many limitations to ensure all activities that were being carried out pre-COVID are also carried out during COVID-19 period with all safety measures, so that the students do not suffer. Regular classes, sessional tests, university exams, competitions, presentations, quizzes, guest lectures, cultural activities, meetings, mentoring are being held with the innovative use of technology by following the guidelines issued by the government and its bodies. As mentioned earlier, we at IPEM have been holding webinars, workshops at regular intervals through professional experts. This international e-seminar is a continuation of the same. Based on our experience of conducting international e-seminar and conferences in physical form as well as through electronic modes, we feel that the electronic mode is likely to stay as the mode of conducting such international seminars in future. Finally, I would like to once again welcome and convey our best wishes to honorable international and national speakers, paper presenters, and attendees from across the world, and all those who worked hard behind the scene for the success of this international e-center. Thank you so much. Jai.
Thank you, ma'am. Moving on with the event, I take immense pleasure in welcoming Professor Dr. S.C. Srivastava sir, who is presently settled in San Francisco, USA, and will be joining us from there. Professor Srivastava is an advocate, legal consultant, and a distinguished academician affiliated to various prestigious law colleges and universities. He is also the Secretary General of National Labour Law Association, New Delhi, member of the Advisory Committee at Child Labour, V.V. Giri National Labour Institute, member of the Advisory Board at Center for Labour Law, National Law University, Bhopal, member of the Governing Council at JIMS, Greater Noida, member of the Faculty of Law at Aligarh Muslim University, as well as at Indian Law Institute, New Delhi. So please join us to give the keynote address for today's event.
Yes, I deem it a privilege and honor to have been invited to deliver the keynote address in the International E-Seminar on the sexual offenses against women. Ladies and gentlemen, as you are aware, that violence against women is one of Yes, can you hear me?
Yes, sir.
Okay, fine. So, see, as I was mentioning, that sexual violence affects not only the victims or survivor's life, but also her parents, friends, partners, children, spouses, even classmates or co-workers. And the effect of the violence can remain with women and children for the lifetime and can pass from generation to another, one generation to another. The term sexual violence is often used to describe the violence that pertains to the range of unwanted sexual contact. Sexual violence may take place in the form of rape, sexual assault, kidnapping, abduction, acid attack, stalking, trafficking of women and girls for commercial purposes, and sexual harassment of women at workplace. My starting point is Nirvya's case, I think, about which Professor Sahgal has discussed in detail, and therefore I do not want to discuss, to say what was the impact of the same, and is also referred to Justice J.S. Verma's committee's report, and see which I want to skip for that purpose because I do not want to repeat what Professor Sahgal has pointed out. And the most important change brought out by 2013 Amendment Act was the definition of rape. Thus, the definition of rape include non-penetrative sex. Further, the act has increased the sentence of rape convict to life and death, as mentioned by Professor Sahgal in his speech. Now, there is one point which is extremely important, and that denotes to what we call as Protection of Children from Sexual Offences 2012, what you call is POSCO, that also seeks to protect the children from the offense of sexual assault, sexual harassment, and pornography, and provide the establishment of a special code for the trial of such offenses and matters matters connected therewith. Recently, the government of India has notified the Protection of Children from Sexual Offences Rules 2020, which enables implementation of the recent amendments to the Act, under which the provisions of the punishment for child abuse has been made more stringent. Here we would like to mention that the Supreme Court on January 27, 2021 has suspended the controversial Bombay High Court judgment, which held that there had to be a skin-to-skin contact for the offense to constitute a sexual assault under the Protection of Children from Sexual Offences Act. Let us now turn to examine the law relating to sexual harassment of women at workplace. As you are aware that the Supreme Court in Vishaka versus state of Rajasthan ruled that each incident of sexual harassment of women results in violation of the gender equality and the right to life and personal liberty. According to the court, it is a clear violation of the fundamental rights guaranteed under Article 14, 15, and 21. One of the logical consequences of such an incident, according to court, is the violation of the victim's fundamental right under Article 19(1)(g) to practice any profession, trade, or business. The Apex Code, in the absence of the domestic law on the subject at that time, formulated the guidelines to check the evils of the sexual harassment at the workplace. The court added that the protection against sexual harassment and right to work with dignity are universally recognized. Now, in order to comply with the directions made by the Supreme Court in Vishaka's case, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 was enacted. This act seeks to protect the women against sexual harassment at workplace. The act also provides for prevention of sexual harassment, redressal of grievances, and also matters connected with this. Coming to the working of the act, what we find it that although the law preventing the sexual harassment at workplace has been in operation for the last 8 years, it has not yet succeeded in preventing cases of sexual harassment at workplace. Indeed, it doesn't fully address the problem of enforcement. It has been reported that there has been 51% rise in the sexual harassment cases from 469 to say 714 in 2015. Quite apart from this, as per the statement made by the Parliament in July 2019, there is no centralized data relating to the cases of sexual harassment at workplace. Coming to the inbuilt uh, internal mechanism under the so-called Sexual Harassment Act, what we find is that in order to prevent sexual harassment of women at workplace, what we feel is that there should be inbuilt internal mechanism so that any instance of harassment faced by the women can be conveyed in a confidential manner to the senior women superior officer, and therefore the internal complaint committee should be constituted to ensure that such instances are nipped to the bud at the inception itself. This is particularly important considering the fact that the number of working women has increased and they are occupying the various posts in different sectors and are contributing financially to the economy of the country. There is another aspect of the Sexual Harassment Act, and that relates to Section 10 of the Act, which stipulates that on receipt of the complaint of sexual harassment, conciliation may be attempted. This provision of conciliation is in violation of the mandate prescribed by in the Supreme Court in Vishaka's case, which was a direction to the state to ensure a safe working place in the educational institution. In this context, even Verma committee also pointed out that an attempt to get justice cannot be muscled at the attempts in the conciliation. There is one more aspect relating to sexual harassment provision, and that is under Section 14 of the Act prescribes punishment for false or malicious complaint. This provision is likely to be abused, and as pointed out by Justice Verma committee, that such a provision is completely abusive provision and is intended to nullify the objective of the law. Well, this brings me to the trafficking of the women, and we all, as you know, that Article 23 of the Constitution very clearly say there is a provision which prohibits trafficking of the women at work, and also we have the Immoral Traffic Prevention Act and Criminal Law Amendment Act. Here, I would like to mention one of the very important judgment of Vishal Jeet versus Union of India, where the Supreme Court, while dealing with the problems of trafficking of women and children for sexual abuse and exploitation, gave directions for the protection and rehabilitation of those who had fallen victim to the forced prostitution. However, it is unfortunate that law relating to trafficking of women had not delivered the desired result, and therefore more stringent measures are the crying needs of the hour. There is another issue which is very important, and that is regarding the acid attack. The incidence of acid attack has been the increasing phenomena in India, where most of the victims of the offense are the women. To meet such evil, amendment was made in the Indian Penal Code, and two sections were added, namely section 326A and 326B in the IPC. But in Lakshmi versus Union of India, the Supreme Court directed that the minimum compensation of rupees 3 lakhs be given to the acid attack victim by all states and union territories. Further, no hospital or clinic can refuse treatment by making excuse of lack of specialization facility And if any private hospitals or government hospital refuses to provide such facilities, then legal action be taken against them. Stacking is another very important issue. Of course, there was no provision for punishment. It was only later that Section 354D was added in the Indian Penal Code, which provided for the same. We now come to the impact of Criminal Law Amendment Act 2013 and the amendment in the protection of children from sexual harassment and also sexual offenses. As per the latest report uh, of the National Crime Record Bureau, which has been published very recently on April 9, 2021, India recorded 88 rape cases every day in 2019. And out of the total of 32,033 reported rape cases in the year, 11% of them were related to the Dalit community. According to the report, Uttar Pradesh, uh, the maximum rape cases were reported from Uttar Pradesh and Rajasthan. And quite apart from this, there is alarming statistics of atrocities of women, girls in Hathras is a clear indication how the provisions for harsher punishment have not deterred perpetrator. It is therefore necessary to take a stock of the implementation of the provision which Professor Sehgal has already mentioned. Now, the reason what I have tried to identify that there are low rate of conviction is one of the important issues which needs to be addressed. And what I could, it is such a thing. In 2018, conviction rate was 43%. Likewise, non-reporting of cases is another very important area which needs to be tackled. Non-recording of the FIR is another issue which, despite the orders of Supreme Court and the principles laid down by the Supreme Court, it is not being observed. Standard of proof beyond reasonable doubt in required in the case of sexual harassment of, say, sexual offenses cases also need to be looked into. And another issue which is extremely important, and that is inadequacy of the number of judges. As in April 2018, about 3 crore cases were pending across the country in India, and that is the real cause of this. Then another issue which is in regard to this is the problems of witness protection, and that is what was pointed out even by the Supreme Court in Mahendra Chawla versus Union of India in 2018 Supreme Court case. I think these are the cases which are really creating problem. And then what is required for that purpose is that recording of the FIR is another very important issue. And this has also been pointed out by the Supreme Court in Lalita Kumari versus Government of UP, which is reported in 2014, where it was laid down that it is duty bound that they to register the case. But whatever may be the situation, there are number of report, say press report release that in number of cases it has not been reported. Thus, there is a need to review the situation. The medical treatment of the and examination of victim is another issue which needs to be addressed. And here it is felt that the provision of the practice, particularly, it is not strictly followed. Then medical procedure, which is been condemned, say, which is even two finger tips test has been, this has already been abandoned, but still at some places it has been reported that it is still going on. Then the protection of witness during the investigation is another very important issue because there is a possibility of tampering the evidence, and I think there is a need to relook the concept. Compensation of the victim to victim of survivors of is another question for consideration is whether it is a legal duty to award compensation irrespective of the conviction or the acquittal. This is all the more so when the state fails to identify the accused or fail to collect and present unacceptable evidence, victim expects mechanism for rehabilitation measures, including monetary compensation. Speedy disposal of criminal cases, particularly those relating to sexual offenses, need to be given. And for that purpose, what is required is special court need to be set up. Technology can be the major driving force for improving justice delivery. Digesting of all courts record and the national judicial data grid must be expedited. And the practice of online courts and e-filing was accelerated during the COVID pandemic, and that may continue for even later also. And this would, I think, would be would improve the situation. We would like to mention that delay in the matters of rape has in recent cases also invited the attention of the apex court in the reassessment of the criminal justice system in response to the sexual offenses. Let me conclude with the following observations made by the Delhi High Court in Ruchika Singh Chhabra versus Air France India, reported in 2018. I quote, even today, the world over is rocked by the horrific tales of all forms of sexual harassment of female co-workers at varied workplace. Decision makers, parliament, courts, and employers are to be ever vigilant in ensuring that effective policies are swiftly and impartially enforced to ensure justice and to see that no one is subjected to unwelcome and unacceptable behavior. So thank you so much for the patient hearing. I think these are the few submissions which I wanted to make.
You are mute.
Okay.
We have Dr. Mandala Bhatta, former Dean Faculty of Law, Jamia Millia Islamia, presently a Professor of Law, North Cap University, Gurugram. It's an honor for us to be with you today, ma'am. I cordially invite you to give your inaugural address.
Thank you so much. Very good morning to everybody. First and foremost, I'd like to thank Professor Sehgal for giving me this opportunity. Not only Professor Sehgal, but the entire team that has organized today's program for giving me this platform to speak on a very relevant topic of sexual violence against women in India. Professor Srivastava, former Chairman and Dean, Faculty of Law, Aligarh University. Mahendra Jangsha, Judge Advocate Colonel Nepal Army. Dr. M. Abdul Alim, Professor, Department of Law, University of Rajshahi, Bangladesh. Professor B.P. Singh, Sehgal, Director, IPM Law Advisor, IPM University. And Colonel A.S. Malhotra, Director General, who is not here. I would also like to address him. All the faculty members and my dear students. Much has been spoken on sexual violence against women today already. I think Professor Sehgal gave a very detailed paper on, the different sections that govern sexual violence against women. He has given the historical perspective. And Professor Srivastava has also talked about, all the reasons that lead to sexual violence against women. He's also mentioned about the different incidents of sexual violence that has occurred in our country. There is no doubt that there is a lot of gender discrimination in our country. Women have been subjugated and oppressed, as well as suppressed for centuries. If we go back to ancient India, or we go back to the Vedic system, there are two schools of thought. One school of thought says that the status of women at that time was at par with men. All the religious rituals that happened, a woman was a party to it. She was the better half of the man. She was respected. Women were allowed to educate themselves. Women were allowed to choose their own partners. But there is another school of thought which does not agree with this ideology at all. Now, as we move forward in the post-Vedic period, we have seen that there was a decline in the status of women, economically, socially, politically, culturally. Very soon, social evils emerged in the society, and the woman was confined to the house. We see it in the post-Vedic period. We see it in the British period. We see it in the medieval period. We see it in the British period. And then, of course, we come to contemporary India. Now, in the medieval period, there was a lot of invasion into the rights which pertained to women as such, okay? And the women were scared of the invaders, and practices like Johar, Sati came into existence. Even though they did not have any religious connotation, we find that later on people attached it to religion. Again, a wife was expected to commit sati, to die on the funeral pyre of a husband, okay, because she didn't have a life of her own. If she became a widow at a young age, when there was a child marriage and a child became a widow, she couldn't marry for the rest of her life. She had to live with a bald head. She could not wear attractive clothes. She could not do anything which would attract men. She could not be a participant in religious rituals. She was considered an outcast. This continued for decades. The status of women fell dramatically and to a degree drastically. Now, these customs which prevailed, whether you take Bengal, or you take the southern India, you talk about the Devadasi system, okay? We talk about sati practice. Okay, there was Raja Ram Mohan Roy, along with other social reformers who had fought for the abolition of sati. But we have seen in post-independent period, during our own times, when we were young, Diurala village, a woman committed sati there. And it was only later on that we had the central legislation which prohibited sati and the glorification of sati. We have the Devadasi system. Again, when a woman is supposed to be married to the priest, or she has to serve the people at the temple, it was nothing but prostitution in disguise. So the status of women has also always been a question mark. It has never risen. Attempts have been made in the post-independence period through various legislative reforms that her status should improve. We have seen the changes in the criminal law. We saw the change in the criminal law in the rape case, in the rape laws after the famous Mathura case, when there was an open letter written to the Supreme Court of India in the Mathura rape case, that how can a woman who goes to a police station and is raped by the policeman and it's considered that she gave consent. So the law concerning consent of the woman changed to a great extent. And a law which said if the prosecutor said that she was raped, that should be accepted. And if she said there was no consent, it should be accepted as truth. But we are seeing over a period of time, we've seen it in the Nirbhaya case, we've seen it in the Hathras case, we've seen in the Kathua case, we've seen in the Unnao case, we've seen in the Hyderabad rape case, that there is insensitivity towards a woman who is subject to sexual violence. There are a number of sexual assaults committed against women within the family and outside the family. Within the family, we are aware of wife beating. Wife beating cuts across all classes, barriers, caste, creed, religion across the globe. This is the inherent aggression towards the women which comes out. Masculinity is associated with sexual aggression of a man. If a man does not dominate a woman, he is not considered manly enough. The patriarchal mindset, which is deeply rooted in our society, initially began with the kinship which existed in ancient India. It was at that time that the head of the family was a patriarch. He was considered the karta of the family. All the members of the family, his wife, his children, brothers, sisters, domestic servants, extended family, everybody had to listen to him. This very concept of the karta was translated into unequal power relations between men and women, today which we define as patriarchal notions existing in our society. This is the power relation which is actually determining the discrimination that we see against women at every stage. It is during the activities when she goes out of the house, whether she goes shopping, whether she is in a high post in a university, whether she is an IS officer, whether she is an IFS officer, whether she is a political leader, whether she is a school teacher, or she is simply a housewife. She is subjected to all forms of discrimination. The laws are in place. We have seen the Constitution of India. The Constitution of India, through the fundamental rights, through Article 14, which promises equality to all women, yet it is a dream for us. We have not been given substantive equality. Equality is there. We do not want equality, which means sameness. We want substantive equality where we get respect, we get recognition for our work, we are not humiliated, we are not ridiculed, we are not looked upon as not as good or not as capable of working as men. So this attitude or these biases, these prejudices which are prevalent in our society must be overcome. And these can be overcome only by changing the mindset of the citizens of this country and also across the world. It's not that patriarchy only exists in our country. It exists everywhere. When a little girl is born, before she is born, still the woman has to go for a sex determination test. It has been banned by the law, but the members of the family force her to go. And the doctors, even if they can be penalized for the same, use indirect methods of telling the woman or the members of the family whether it's a boy or a girl. They will say, oh, it's Wednesday, or maybe some other weekday to signify that it's going to be a boy. Or they say some other day to signify that it's going to be a girl. So this mindset which is there even in women, why is it there? It is because women have been made to feel that they are less important. So since their birth, they are considered to be, I am sorry to say, second sex, though I would not like to use this phraseology. Okay, and being a law person, a law teacher, I hate to use this phrase, but I know what it is to be a woman and to suffer discrimination. There is only a very few percentage, I'll reiterate, in our country that enjoy the benefits which are given equally to men as much to women. We have Article 16 of the Constitution. We have Article 15 of the Constitution, which says that there will be no discrimination on the basis of sex, caste, religion, place of birth. We have Article 15, subclause 3, which says that the state has a responsibility to take up affirmative action, okay, to reduce the gender gap, to create special laws, to create special policies for women. I'm not saying that it has not been done. There have been many legislations that have been created, that have been enacted. The Domestic Violence Act, which was given to us after many, many years, after we had ratified CEDAW, is an example of how slow our legislature moves. It moves. I am not saying it doesn't move, but it is very slow. We have the Domestic Violence Act in place today to control wife beating at home or violence in different forms. It covers sexual abuse. It covers economic abuse. It covers verbal abuse. There are women who are married, unmarried, who suffer taunt in the family. There are women who are married, and what happens? The husband says, if they don't cook properly, there have been cases where thalis have been thrown on the women, and the man has said, you have not cooked well. Or a woman is said, you are not attractive, you're fat, you're ugly. First of all, why did you marry her? Secondly, is this the criterion on which you're going to base a relationship? We don't want a relationship which is only based on physical attractiveness. It is something more we want. We want that we as qualities that are inherent in a human being, those qualities need to be accepted, which we see that they are not being so recognized in our society. Okay, when we talk about the Domestic Violence Act, we also talk about sexual abuse. Sexual abuse today, if I consider rape, yes, it's an offense. And we have an expanded definition of rape after the 2013 Amendment Act, through the Justice Verma Committee report. What very important aspect which the Justice Verma Committee report had mentioned was the incorporation of marital rape as an offense in the IPC. But that was dropped by the Parliament. Why was it dropped? Because they said that Indian society is not ready for marital rape to be made an offense. Again, it is the mindset which is coming in. They say that the Parliament does not want to enter the private sphere of a woman's life. When the Parliament has entered the private sphere through Domestic Violence Act, because they saw that women were being subjected to violence for years together, and they were quiet for many years, the legislature did not come up with the legislation. Then when marital rape is also a problem these days, and matters have come before the Supreme Court, matters have come before the High Court, they come before the NGOs, but the judiciary has still not passed any judgment on this, because they feel that the institution of marriage would be affected. Why? I just want to question everybody that when a woman gets married, does her right over her body, does her autonomy over her body end? If she's raped when she's unmarried and there is no consent, it's considered rape. Why not when she's married? So we have to dwell upon these aspects. Justice Madan Lokur gave an excellent judgment in Independent Thought case when he said that any girl who is so-called married below 18 years of age, it would be considered as marital rape. It was a very encouraging judgment. The Supreme Court has empowered women and girls in various ways through their judgments. They have not been insensitive, but in some situations, yes, they've been insensitive. When you take the case of the High Court of Andhra Pradesh, it's saying that, okay, the man had molested the woman, let him tie a rakhi and we'll give him bail. My God, you are actually diluting the offense of molestation. When the sections are there which make a particular conduct as a sexual offense, it should be taken to its logical conclusion.
Excuse me, ma'am.
Yes?
Ma'am, you are telling that marital rape should be considered as a law in parliament, but our young generation will be so much afraid if marital rape is considered as law, because there are many chances when man can be, you can say, man can be molested in the law or can be cheated. You can understand this thing. So there may be chances when the society will become isolated and there will be no marriage system like there it is in Western countries. So can you consider marital law as requirement in our Indian society?
I think the question which you've asked me emerges from, again, the mindset which is prevalent in our society. I am not saying that you make marital rape as an offense without guidelines. Guidelines will be incorporated. We have to work on that. Okay. And there are many countries in the world where marital rape has become an offense. You know, during pandemic, the domestic violence cases had gone up tremendously. And when the judiciary, transferred all the cases to virtual mode, because physical appearance was not possible because of the pandemic, domestic violence cases or sexual violence cases against women were not given the same priority, and these cases were not being heard. I think Justice Geeta Mittal, in taking so moto of situation when she was the Chief Justice in the High Court of Jammu and Kashmir, she passed a slew of measures, a slew of directions that domestic violence has to be controlled even during pandemic. It's violence against women and it's crime. So when you talk about domestic violence, marital rape is also kind of domestic violence. But though it comes under sexual abuse, and Domestic Violence Act is a civil law remedy, there is no jail for the person. And if respite is to be given to the woman, she would get a protection order from the magistrate under the Domestic Violence Act. All right. But there have been situations which you may not be aware yet. But if you look at the statistics, many cases are unreported. The conviction rate is low in many sexual offenses cases in our country. Marital rape is a reality. Okay.
Ma'am,
Yes.
ma'am, say there are so many false cases which are coming in domestic violence cases. So if marital rape is considered by our Indian society, then our society will be destroyed. Our family system will be destroyed, and there will be no the young generation will be so much afraid of marrying with a girl. So you can
No.
consider this thing.
No. Here is where it's the mindset. It's the fear. It's the psychological fear which is there also. Okay, this is not true. Why would you think that a woman would want to break a marriage? Why do you think that? Everybody would want to live happily in a married life. Let me tell you very clearly. And there is misuse of law in every situation. It's not only that Section 498A of IPC is being misused by girls and women. It is not that marital rape, if it becomes an offense, it is going to be misused. Look, very small percentage of women, to their advantage, in any case, would misuse anything. Even men misuse the law. There is this is a fear. A fear. For example, in domestic violence, you say there are many cases which are false. I do not agree with you. There are many cases which are not reported. The women have no access to justice. They are scared. They can't go because at every stage of the proceeding, beginning from the stage that she files an FIR till the adjudication stage and post-adjudication stage, she suffers humiliation and ridicule. Why is it that the High Court of Delhi has passed orders, directions in a particular judgment? I don't have the citation right now. I can give it to you later, where they said that the investigation procedure in rape cases is very faulty in our country. First and foremost, the FIR is not lodged by the police officer concerned. Even in Hathara's case, okay, the police was reluctant to file an FIR. In any case, in wife beating case, I have done my PhD on crimes against women within the family. And let me tell you, when I went to collect data, I had empirical study also to do. I went to the various women's cells. I discovered that over there, the police personnel were saying that they would always encourage women to go back, that okay, their husbands have beaten them, but they also love them. But what is love? Love is not only physical relationship. Love is beyond that. It is much more. It's the concern. It's the love that you feel for a person. You don't beat the person you love. You don't humiliate the person you love. You don't taunt the person you love. It is a wrong notion. So the mindset has to change. That is what I'm saying, that when you say that if marital rape is made an offense, the institution of marriage will collapse. That is not true. We still have our sanskars. Most of the girls who marry would want to remain in marriage. There would be a certain percentage who maybe have extramarital affairs, like men are also having. This belongs only to the city, to the cities. We look at the rural area. We still find women are docile. We still find women are suppressed. When a woman is raped, she is scared to go to the police station. Okay, why is she scared? Because she's scared of being questioned over there. Why is it that the High Court has written in the judgment that an advocate should be present right from the moment that a woman files an FIR, right? And the same advocate should be there till the end of the case, because they've seen it. Why is Ravindran Bhatt come with that judgment now? That these stereotypes notions, these patriarchal notions in our society must be stopped. And they must not be put into practice by any stakeholder in the criminal justice administration. At least the Supreme Court has done this and given directions to all the courts, including the judges, the police, the medical professionals, and everybody that is involved in investigating cases of sexual violence against women. Basically, the mindset has to change. The evidence is compromised. If you do not take the woman for medical examination in time, the evidence disappears. Then how do you prove the case? And where there are special laws for women under CRPC, under Evidence Act, under IPC, those special laws are also not implemented properly. When it is said that where it's a case of sexual violence committed against women, her statement should be believed. But when the woman goes to the police station, he's reluctant, the police officer is reluctant to lodge an FIR, even though she says so. Do you think a woman would lie? I am saying only one or two, few women would lie. I don't rule that out, but every law is misused. Every law is abused. Not only sexually, not only sexual violence laws, all are abused. Tell me which law is not abused. And it is a fact that when a murderer kills a person, he finishes the life of that person. But when a woman is raped, her soul is affected. She lives that trauma throughout her life. And she lives it at every stage of the investigation, right to the time she is rehabilitated also, if at all. We have examples, live examples before us. We can see it. We saw it in the pandemic. It was only after the judgment was given by Justice Geeta Mittal that everybody woke up. There were so many cases before different high courts that domestic violence cases were not being heard. The perpetrator of domestic violence was at home with the woman. The woman could not go out because of lockdown. At least earlier she could have gone out, met her people, met her friends, met her family, gone for work if she was working, but the pandemic stopped all that. The lockdown stopped all that. It is not that it only happened in our country. It happened across the globe. And one good point I would like to say is that the state of UP, the police at that time, and it was encouraging that the police of UP at that time said that the helpline for domestic violence cases would remain open even during lockdown. And it was the first state and only state that said at that time, though the maximum cases of rape I find are there in UP. And the police have been insensitive in Hathras case and other cases. But it was also true that the police said that the helpline would be open during the lockdown for domestic violence cases. So there are sexual violence cases everywhere, within the family and outside the family, even at the workplace. There is no difference that the people understand between what is harassment and what is sexual harassment. Our people in India need to be sensitized on that. A whistle when a woman walks in at the workplace could be sexual harassment, okay? Because you're whistling, because the way you're whistling has a sexual connotation, which is again an offense under the sexual harassment of women at workplace. And there should be no limitation of time, which I would like to address, for women to come up wherever, whoever has been actually exploited sexually. Because women will take time. The conduct will vary. Every woman will not react in the same manner. Women are suppressed. They also have their reputation. They will not come forward. We have seen in families, we see every day how a girl child is brought up. There is discrimination. In most of the families, the boy is given food first and a girl is given later on. And the mother would say, let the boy take from the table. I will serve you in the plate. We have seen that. Maybe educated families don't do that, but largely the discrimination is there. Her mobility is controlled. She is told you be back by 6 o'clock or 7 o'clock. When I was young, I was told by my mother that you cannot stay away at a party till beyond 6 or 7. I was not allowed to go for an evening show with my friends. I've come a long way. You understand? I was a very protected person. But I've also fought, I've seen, I've grown. But I have to encounter taunts on roads, remarks on roads when I'm driving, even today, because I'm a woman. So the biases and prejudices which are inherent in our society have to be changed. What we require is actually deconditioning of the mind. Okay? When deconditioning of the mind is there, we have to rewrite everything. And that can be done not by segregating men from women. We need support from men also. We have to do it together. You youngsters have to understand. You have to change your attitudes towards your friends in colleges, in schools, at home, towards your sisters, towards your mother. A mother does so much of household work all her life. She's beaten up. The son sees it. The daughter sees it. She thinks it's accepted. When she gets married, she keeps quiet. So somebody has to break this vicious cycle. Only when you break it will change occur. Even one slap can be detrimental to a woman who has been brought up in a family that has given her space. So violence is also relative, but violence should not be accepted in any form. In any form. Once we change our attitudes, once we change our mindset, once we become open-minded, once we accept that a woman, a girl is equivalent to a man, she has the need to live happily like we have. She has a right to live with dignity, a right to develop, a right to freedom at the workplace, a right to freedom to speak. Okay, all these rights have been written down in various judgments by the Supreme Court of India. They have empowered women, whether you take in family law matters, whether you take in property matters, whether you take in sexual related matters also. But still, the mindset of some parts of India, I'll say some high courts, judges, because again, they are part of the same system of the society. They have grown up with a certain mindset. And they could be a progressive judge, they could be a conservative judge. They could be a progressive police person and a conservative police person. And a medical practitioner also subjects the woman when he's examining to a lot of humiliation. So this has to stop if we want sexual violence to be addressed, so that the conviction of the persons who actually commit, they are brought to book and they are punished. And the offense is not diluted through judgments like tie a Rakhi or marry the rapist. This is not the answer. This is totally unacceptable. And I think the judgment given by the Supreme Court on 18th of March is an excellent judgment, and it paves the path for permeating the mindset of the judiciary, the sensitivity of the judiciary at the grassroots level, and there will be a ripple effect. Thank you so much. I think I've taken a lot of your time. There's a lot to talk about on this matter, and maybe it'll be some other time. Thank you very much.
Thank you so much, ma'am. Before we move forward towards the event, IPEM Law Academy would like to seize this day by releasing its book and annual journey to the esteemed dignitaries who have taken their valuable time to be with us today. Last year in June 2020, IPEM Law Academy organized a national e-seminar on the topic Center-State Relations under the Indian Constitution, which has now been published by Universal Academic Books. I request Professor Dr. V.P. Singh Sehgal sir, Director and Advisor of IPEM Law Academy, Dr. Dolly Phillips ma'am, Dean Outreach International Affairs, Dr. Naveen Kumar Singh sir, Director of IT Department, Dr. Nishi Sharma ma'am, Principal of Center for Teacher Education, and Dr. Meenakshi Kamal Ma'am, Principal of Law Department, to kindly come on the stage and release the book. Annual Journal. I request the dignitaries to do the honors and release the latest edition of the same. Jacket of the book, likely to include the papers presented in the present international e-seminar on sexual offences against women, is also ready, and I request the dignitaries to release the same.
Against women. Our first technical session comprises of an esteemed gathering, which includes the eminent speakers of today's event. It will be chaired by Professor Dr. S.C. Srivastava sir. The speakers for this session are Colonel Dr. Mahendra Jamshah, Judge Advocate General of Nepal Army, Director of Human Rights Directorate in matter of Lucknow University and Jamia Millia Islamia, Delhi, a women activist and a prolific writer on women issues, a senior academician working in Delhi University, Dr. M. Abdul Alim, Professor, Department of Law, University of Rajshahi, Bangladesh, Dr. Tarannum Khan, who is an award of excellence winning career strategist. She is highlighting the issues relating to the status of women in a popular name, especially in Brampton, Canada. And Ms. Sumitra Chaudhary, who is practicing senior advocate in the Supreme Court of India, highlighting women issues from time to time. It is requested to all the speakers to take the time limit of 5 to 7 minutes for the same. I now invite Professor Srivastava sir, the chairperson of the technical session, to kindly join with the speakers and take forward the session.
Thank you. Thank you so much. I welcome you on the first technical session. We have 4 speakers, and I think the time schedule is, we have to stick to the time because, hello?
Yes, sir, you're audible.
Hello. Hello.
Yes, sir. You're audible.
Not,
We can hear you.
not hearing. Hello.
You're not audible. So please unmute yourself.
Yes, can you hear me?
Yes, sir.
Okay.
So please continue.
So I welcome you to the first technical session. In this session, we have 4 speakers, as pointed out earlier. To begin with, I say the time schedule is between. It would be better if we say we have the 1 hour session, and therefore we have to see we have to keep timings for even for discussion. So I think 5 to 7 minutes has already been pointed out. We should try to confine up to 5 to 7 minutes. And I think to begin with, I will invite Mr. Mahendra Jang, Mr. Mahendra Shah, who is a judge advocate, Colonel, say, to kindly present, make his.
Thank you. Thank you so much, sir.
Yes,
Thank you so much. Can you hear me, sir?
yes, certainly.
Yes. Respected President, distinguished presenter, and intellectual participant, I am privileged and honored to be as a participant and eminent speaker of this seminar. Without due delays, I would like to enter my presentations. Now we are talking about the sexual offense against women in the modern legal societies. Society. My presentation has focused on the concept, standard of women, sexual offense initiative against sexual offense against women, and I have some recommendations, and will be in the conclusions in the end. I'll be happy if any questions from the participants and distinguished personalities. Fortunately or unfortunately, we are talking about the God-gifted element, which is the sexualities and sexual relations. All my presentations is based on these crimes, which is the behavior that violate the law. In my presentations, law means in the criminal law. We are talking about the criminalities, which is the quality of state of being criminals and criminal activities, unbound criminalities. We are talking about the criminal law, criminal law, which is the system of law concerned with the punishment of individual who commit the crimes. And we are talking in the criminologies, which is the science of the study of non-legal aspect of crimes and delinquencies. And we are also talking about the criminal justice. These are the things which guide to all my presentations. Presentation. The concept. I already mentioned mentions the sexualities, sexual relations. These are the God-gifted element. But the God-gifted element in the context
Sorry to
of
interrupt, sir.
God-gifted
So,
element,
please
we
share
are
your
also talking against the God-gifted elements, elements, elements which occurred
So
by
we
the
request you
human
to
beings.
please share the PPT.
Sorry, ma'am.
So we request you to please share the PowerPoint presentation.
PowerPoint presentation.
Well, I think
PPT, the PPT.
I will share later, ma'am.
all right. Go ahead, please.
And
I think you are muted.
I'll share later, sir.
All right.
Good. If you talk about because of the God-gifted element, and it is started from the human civilizations, I would like to say that the very brief histories of sexual offense in the context of human civilizations. If you read in the history of Mesopotamia, women could buy, own, sell, and properties. And if you talk about the history of Egypt, the women are equal but depend on the social classes. And if you talk about the Greeks, certain freedom of movement had allowed to women. And if you talk about this, talk about the Rome contest, women, they are for men. And if you talk about in the ancient China, women are inferior and subordinate to men in the Confucius law. If you talk about the rituals and religious context, some religious context, I do not want to mention the particular religions, but some religious books, uh, they restricted the women, and some religious books provided the limited right to women. Fortunately, if you talk about our contest in the period of Vedic period, Vedic period, women are equal to men. Women are equal to men. Because of that, the situation of ancient times, women, they are behaved like that. One American journal, Social Issues and Humanitarians journal, highlighted these women positions. English women has favor ground for divorce than men until 1923. Husband controlled the most of their wife property until 1882. Children were husband properties, and wives lacked the crucial feature. This is the situation of women in the history. Because of social movement, the Renaissance came and provided the humanitarianism, and then the concept has been changed. And the question of gain, the question of entitlement, question of rights came into the surface. After that, after Renaissance and 18th, 17th century efforts and 18th, 19th centuries efforts, the modern contest has been come into the surface accordingly in the context of women, in the context of sex, in the context of sexualities, in the that comes into the equalities and equities.
Mr. Mahenjan, I'm sorry to intervene.
Yeah.
Let me tell you, kindly, because the time is already you have taken 10 minutes. And
Okay.
I think you have to identify the issues. And
Yeah,
what suggestions, kindly summarize it within 3 minutes.
30
You've
minutes.
already taken 10 minutes.
Sorry, sir.
We have a ground rule for.
Okay, I'll try my best. Equality and justice, fairness and access, empowerment and inclusiveness, and governance and protection. And right, the concept has been changed in the context of the right. It goes to the women right, and children. After that, the standard of women, that is converted into the two arena. In the international context, there is no word today. There is no word of international. It is the global village. In the global village, there is some sort of concept and instrument are there, such as international humanitarian law, international human rights law, United Nations establishment, United Nations Universal Declaration of Human Rights, ICCPR, like that. There is also international rational instrument, African Union, European Court of Human Rights, and Inter-American Court, like that. In the other side, if you talk about the national side, there is a constitution, which is the liberal democratic constitutions, or we can say that is called the right-based constitutions. In the constitutional standard, there is some sort of laws that they are made by parliament, and some regulations they are delivered by the executive, and some cases decided by the Supreme Court on the basis of constitution and basis of parliamentary law. But in some cases the judiciary has the activism. They, the judiciary try to maintain the gap between the societies and law. Society is always far ahead from the society. In the name of the activism, judiciary has played a significant role. In the constitutions, in the liberal constitutions, always based on the human rights, civil liberties, and political freedom. Which means is that the liberal democratic constitution is a right-based constitution. Under the standard of the liberal constitutions, there is no definition of the sexual offenses. If you talk about the sexual offenses in the context of the parliamentary legislation, there are so many legislation, so many offenses which are occurred against the women, since from the adoption to abduction to the rape. If you talk about the international community, global village, the global village and global instrument, they provided the sexual offense against the women, such as domestic violence, sexual exploitation, sexual abuses, harassments, human trafficking, like that. When we are talking about the particular or specific sexual offenses which are mentioned, is the iptaging, rape, stalking, adoption, kidnapping, molestation, acid attack, trafficking, and sexual harassment in our context. If you talk about, when we are talking about the sexual offense against the women in our context, iptaging, the root cause of iptaging is our family, our social attitude and values. It has some sort of the element which is declared by the legislations. It is bononious and violent culture of work, lack of participation.
Please
Okay.
conclude it.
Okay, sir. Well, thank you, sir. Iptaging is described the stalking, passing comment, and inappropriate physical touch, including tight restrictions on girl mobility, inabilities to attend the schools, or girls being blamed and causing the family problem. If you talk about, it is very famous and very historical offense that is called the rape. Rape has the three types of the rape. Traditional rape. In the traditional rape, there is a sexual relation without illegal means and method. If you talk about the modern rape, there is a criminal act, criminal intent, causations, harms, lack of consent, and illegal consent by the victims. If you talk about the statutory rape, carnal knowledge of the sexual intercourse, women below the certain levels, below the certain age, and both elements are there. And if you talk about the stalking, there is certain elements which are course of the conduct and behavior, the presence of threat. Okay.
I'm sorry to intervene. See, there is a time limit. There's already.
Okay, sir. I'm going to.
No, I think we have to. I must give opportunity to others also.
Okay, sir.
And
thank you,
we
sir.
have 1 hour duration. This session is confined to 1 hour.
Okay, sir. Just 1 minute, sir. I would like to finish my presentation on the voice of the two prominent women speaker. The woman is not born woman; she is made of once. Simone de Beauvoir, and God rapes, he rapes, and demons rape, Sexina. And but in the conclusions, we have the certain legal regimes which are based on the supremacy of law, supremacy of constitutions. We have the liberal democratic constitutions. There is the sexual offense. They are preventable offense. We can prevent the offense by awareness, by education, by training, and etc. Today we need, when you are prevent the sexual offense, we need the women governance. Thank you very much, sir. Because of time, I could not
No, no, I think I can. Thank you so much. I think Mr. Mahenjan has tried to focus mostly for starting with the history. He has tried to focus on the human rights, the constitution, which is supreme law of the land. And then he has tried to say about the legacy, the right to equality, and right to personal liberty is the area which needs to be addressed. I think if we try to make that one and we read it along with the legal provision, perhaps we can look the problems from that angle. So thank you so much. Now I invite
Thank you, sir.
Dr. Seema Singh, Faculty of Law, Delhi University, kindly make her presentation. She kindly confine, say, I think, well, see, my request is that you try to identify the issues and then you try to address it. And please confine yourself limited to the time which has been prescribed. Yes, Dr. Seema Singh. Yes. Yes, please go ahead.
Thank you so much, sir. And sorry, my mic was mute, so I was not able to speak. And first of all, I extend my thanks to Professor Sahgal, Professor Malhotra, their entire team, Professor Suresh Chandra, and all the co-speakers. And I extend my thanks to invite me and to allow me to express my views over such a relevant topic for me. And my topic of discussion is jurisprudence of reproductive rights of women. Yes, of course, I am listening so many speakers, and because only 10 minutes have been allotted to me, so I'm just going to keep my views in a very precise and in a very concise manner. Reproductive rights are essentially realization of all human rights, the encompass from right to health and life, to right to equality and non-discrimination, privacy, information, and to be free from torture or all kind of ill treatment. Undoubtedly, there is a lots of discrimination against women, and perhaps we don't realize one thing, and that important thing is women's have right to, has power to reproduce. So this power of reproduction, this is the gift of the nature, which should be celebrated and which should be respected by each and every individual, because we all are here just because of our mothers. Our mother have capacity to procreate, and that is the reason of our physical existence. But unfortunately, India has a range of reproductive rights issues. I'm just going to mention few one, like the maternal mortality rate, unsafe abortion, poor quality of post-abortion care, lack of access to the full range of contraceptive methods, child marriages, substandard female sterilization, lack of information and education on reproductive, on sexual and sexual health. We should also keep this thing in our mind that India is a signatory of several international treaties and conventions which prohibits all kinds of discrimination against women and which talk about the protection to the reproductive right of the women or the mothers. And the Constitution of India also talks about right to equality and no discrimination on the basis of gender. Now, there are so many legislations. I'm not going into the legislation. I'm just going to put some important judgments which has been pronounced by the Supreme Court. And specifically, I'm going to mention three judgments. The first judgment is of the Punjab and Haryana High Court, where the Punjab and Haryana High Court has decided women's right to reproductive autonomy by dismissing a suit filed by a husband against a doctor who had performed an abortion without the consent of the husband, saying that it is a personal right of a woman to give birth to a child. Nobody can interfere in the personal decision of the wife to carry on or abort her pregnancy. So this is something why I'm highlighting this judgment particularly here, because remember, in a matrimonial relationship, All the family members are basically going to share a bondage. They are going to share a bond among themselves. There is a husband, there's a wife, there is a children, and they all are connected to each other with the bond of emotion. But why this judgment is important? Because in this judgment, the High Court has clearly said that this is the personal right of a woman to give birth to a child. So only she can decide that whether she wants to continue with the pregnancy or not. There is another important judgment, and that judgment is the case of Joseph Shrine, which is a very celebrated judgment in which the Supreme Court has struck down Section 497 of IPC, which talks about adultery. 497 of IPC allowed husband to prosecute them with whom their husbands to prosecute men with whom their wife had sex. The court held Section 497 unconstitutional and violative of the fundamental right to sexual privacy and sexual autonomy. I am mentioning this particular judgment because in this particular judgment, in a matrimonial house, the Supreme Court is talking about sexual privacy, that is fine, simultaneously about the sexual autonomy. This is something which is very much important, because now in a matrimonial relationship, earlier only the men were allowed to go for extramarital affairs, and now the females are also allowed. So in this particular judgment, the Supreme Court is emphasizing a lot about the sexual autonomy. Now, there is one more very important case, and the name of the case is Notesh Singh Johar versus Union of India. And in this case, the Supreme Court has declared that homosexuality among the consensual adults is decriminalized. It is not a crime. Why I am putting these three important judgments? I am putting these three important judgments because of all of you, because remember, family is a very sacred institution. And through these three judgments, the Supreme Court is interfering in a matrimonial house where on one hand, they are talking about sexual liberty of both the partners, and on another hand, the birth of the child, which should be a collective decision of the husband and wife, they are giving complete autonomy to a woman to decide that whether she wants to carry the pregnancy or she wants to abort the child. I want to bring one important point from United States of America, where liberal feminist movement was very much celebrated. And what it says, it particularly talks about or advocates right to control the biological bodies and its reproductive resources. Choice therefore symbolizes women's control over their reproductive destiny. Now here the important thing is, in a matrimonial house, one man and one woman, they are going to enter, they are going to plan a family. The woman is naturally, obviously, that is a blessing of God, that she is the procreator and she can reproduce the child. But through the judgments, not only in India, but across the globe, we have seen a new kind of thing. And that particular thing is, we are talking about individual liberty in a family system. Whatever husband wants to do, he is supposed to do that. Whatever wife wants to do, she is supposed to do that. So in a family setup, we are talking about individualization. Undoubtedly, there is a lots of discrimination. There is a lots of torture against the women, and the reproductive rights of women is not celebrated. If we talk about the Bharatiya philosophy, and if we go in the history of India, then obviously women were allowed to remain single. If they wanted to get married, they were allowed to get married. And if they wanted to produce child, they were allowed to produce child. But simultaneously, it was very, very important that in a matrimonial home, a woman should receive all sorts of respect. That's why if you just take the example, and obviously that was a matriarchal society in a way, because once we take the example of Mahabharata only, then Kaunteya is Arjuna, Radhe is Karna, Ganga Putra is Bhishma, means they all are famously, even Devaki Nandan is Krishna. So they all are acknowledged by the name of their mothers. So this reflects the importance of mother in a particular family system. Once we talk about the natural law of justice, what I personally believe, where the problem lies here, we stop considering ourselves as a part of the nature. We are not able to identify our respective roles. It is very much important that it is, and it should be respected, that the women can procreate, but simultaneously this procreation is also treated as a weakness for a woman. So not only in Indian society but across the globe, once a woman is financially independent and she is working in a particular setup, once she gets pregnant, she start receiving threats from the employer that now she cannot perform her work properly, she cannot focus over her work, so either she will have to abort her child or she will have to leave the job. And remember, this problem is seriously faced by women in developed countries, and the same thing is happening in the case of India. Now the problem is, if she is not financially independent, she is not receiving respect at the matrimonial home. If she is financially independent, then she is going to face discrimination at the workplace and simultaneously at her home. Now the problem is how to balance all these things. Once we talk about the jurisprudential development about the rights of the women, then we
Kindly summarize, please.
Yes, sir. Yes, sir. Then we can reach on this particular conclusion that we have discussed a lot about the liberty, a lot about the liberation, but there is no discussion either on the part of the lawmakers or on the part of the judiciary that how to save family as an institution, how to save marriage as an institution. And we should realize it that being a social animal, we cannot live without family. I have seen several cases of divorce in last 8 to 9 years, around 50 cases I myself have seen. The problem is we are giving everybody right to go out of the matrimonial house, but what happens after that, nobody is ready to talk about that. And that is the reason that in the developed country, they are going to face a very serious problem. So I think this is my humble suggestion, that being the academician and being the part of the legal educator, we should focus upon this thing, that now there should be a discussion that how we can save the family values and the family system of this country. Because as one student was asking a question to Manjula Batra ma'am, it is definitely going to happen in the future that our next generation will be least interested in entering into the matrimonial house. So the important thing is, the best part is to give respect to each other and to give ample respect to the privacy of each other. It is not about who is superior or who is inferior. It is about the equality. So it is better to talk about the human rights of both the genders, because this is naturally proved that we cannot live without each other. And unless and until they are going to give respect to their dignity, we cannot save the family system. With this humble submission, I just close my address.
Thank you very much, Dr. Seema Singh, for the excellent presentation. I think the one thing I would like to add, that what you say, that the tendency in India towards the at the time of matrimony or other, see, even so far the maternity benefit is concerned, recently a lot of amendment has taken place, which is in the interest of the women itself. Quite apart from this, we have the municipal corporation case, which is a Supreme Court decision, where they've tried to look to the interests of the women. And I think it is not that, see, at the one time, knowing the scene, what we see, the Air India judgment or other cases where it was held, but the situation is completely changed. You can find that a number of reforms have been made in this regard. And I think the legislation and the country, whatever labor legislation has come in this regard, particularly in the 2017 amendment, a number of relief has been given through Maternity Benefit Act. So it is not the, and even in the other case also, when such discrimination was made, the Supreme Court held it to be arbitrary. So I think the India situation is entirely different than what you are comparing with the other countries. Yes. Yes, I think you are mute. Yes, please. You want to say something? Yes, please. what happened?
Sir, I just
Can
wanted
you hear me? Yes,
Yes, sir. I just wanted to draw attention of all the panelists and all the audience on a very serious issue. As per a recent data, the rate of divorce in India is supposed to touch to the 50%. And in itself, it is a very serious situation because there is no study in India
No,
that
I entirely agree with you so far as the family, whatever you're trying to say. But what I have added is that your remarks so far the labor law and the see even on the
yes, sir, yes, sir. Very much.
sign of
India
presidency.
has done
I think
India has done
that
much,
has
much more in
yeah,
comparison to any other
yes,
country.
yes.
Yes,
So
sir.
you cannot compare. Say yes.
Thank you.
Please, may I now invite Dr. Abdul Alim. He is from the University of Rajshahi, Bangladesh. May I request him to make his presentation? Kindly adhere to the time, please.
Thank you. Thank you so much, Professor Suresh Chandra Srivastava, inviting me to talk something about the issue. And my topic is preventing masculinity and sexual harassment in higher educational institution for sustainable development. And as we know that university actually is a place, and this place is for to create knowledge, to cultivate knowledge, and disseminate knowledge. I think you will agree with me that this conference like that is a conducive platform and to share something about this thing. And I also like to express my profound gratitude to IPEM Law Academy and Professor Singh Segal, Professor Manjula Batre. And as you know, the sexual harassment the women's education that is a significant impact on family income and development, and the males in household activities are also absent, and women's activities are entertaining guests, preparing foods, and take care of the older people and cooking something. And actually root causes is the gender discrimination and gender inequalities, and sometimes these laws are making the woman helpless in also in the higher educational level. And sexual harassment in public universities in Bangladesh, we have conducted research with the United Nations Women, and in our university, my university name is Rajshahi University, and it says that the highest proportion, 76% of women, they reported that never telling anyone about their experience of harassment that happens by friends or the teachers. And actually, we know the masculinity that is not fixed entity embedded in the body or personality traits of an individuals, but rather than it is configuration of practices that are accomplished in social norms and social actions. And I cited a judgment that Vishakha case in India, and another case, Apparel Export Promotion Council versus A.K. Chopra. In that case, it was held that sexual harassment is a form of sex discrimination, and that projected through unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct with sexual overtones, whether it may be directly or indirectly implication, and particularly when submission to or rejection of such conduct by the female employee was capable of being used for effecting the employment of the female employee and unreasonably interfering with her work performance, and had the effect of creating an intimidating or hostile working environment for her. And I also write down some background of this research, that male dominant society and perceived social norms and hierarchies, and that developed in our family. Actually, family is the institution, is the and family actually masculinity. It's also originated from residence or houses, and is a notion that embedded in the social hierarchies. And it is often committed by parents, sometimes peers, in laws, relations, and strangers, and teachers, co-workers, and workers in the public places, also private spheres and public political spheres. And sexual entitlement and fun have been identified as the predominant justifications for man's sexual violence against women, and gender inequalities attitudes and practices stemming from problematic and harmful practical norms are widespread among men and women. In Bangladesh, another survey was conducted by ICDDRB. It says that 55% from urban area and 57% from rural area, they reported they have been harassed in their lifetime and experienced with physical or sexual violence with their intimate partner or friends. Moreover, about 60% of men's attitude in our context in Bangladesh, that is that one survey that they agreed in. That survey was conducted by UN Women and our university. That women's at the times, they justify, actually men's justify their attitude that to beat the woman, that is the simple thing and that is legal things, and they perceive those things. And measuring masculinity and violence against women, and we know that masculinity embedded in social hierarchies, and UN Women and the UN multi-country study on men and violence in Asia and Pacific defines masculinity that is the ways of living for men, both identities and patterns of practices, and associates with the positions of man in various gender system. And hegemonic masculinity, and that is the hegemonic masculinity is red marker of man's individual's identity and manners and beliefs. And another masculinity is marginalized and subordinate masculinities, and such as sexual minorities groups, the gay, transgender, and socially and environmentally conscious man, and other who think in terms of different forms of masculinity are there. And how the gender based and these masculinities and discrimination and violence that happening in our higher education, and that makes a problematic situation to students to continue their study, and because it has a psychological effect. In university, a female at any point in her education may desire for consensual sex to ensure that she will receive a deserved high grade in class, or maybe a worker to get for a promotion or a pay raise on a job. And those opportunities force her for sexual offense, and pervasively a woman or girl may consent to undesired, unwanted, and unwelcome sex because her material security depends on it, her grades depends on it. So teachers are taking these advantages sometimes. And categories of physical, sexual, psychological, and economic harassment that causes harms or injury to body or to the mental condition of a person. And economic harassment includes denying a woman access to or control over their basic resources in classrooms, also in participating in cultural events, sports, and it also includes denial of funds, refusal to contribute financially to household expenses, denial of a lot of areas are there. In Bangladesh, in 2009, Supreme Court Bangladesh actually High Court division has passed an order and about sexual harassment, and it says that in every and each institution and universities or colleges there must have a sexual harassment prevention cells, but those cells are not working at all. There are actually law, the judgment and law practices are different thing, and the UGC, University Grant Commissions, are not working or functioning well. When a woman tries to get justice for sexual harassment, and actually she remains silent to talk it about to their friends or teachers or the complaint in the harassment prevention cell. She has to face a lot of harassment again if she complain. And the lingering of the investigation process, it takes years and years time. And there is shaming in society and in classmates and in the educational environment, lack of willingness from the university authorities. And I faced a lot of problems from the vice chancellor and the registrar of university and also the syndicate, because of there is a political linkage. The perpetrators, the teachers are involved. They have the muscle power or something else with the power relations, and so vice chancellor do not like to tackle down these issues, and they can settle in privately, but they did not take legal actions against the perpetrators. And investigating authorities of the university, there is a problem, and women, and to compare what and to take some initiatives against this masculinity in university. Obviously, awareness is one of the things that it is very important to find out the women's education and its allocation of budget, the investigation and psychotherapy and counseling. A lot of things are needed, and in a confidential confidential rooms we needed. And in America, they know that in every university, the safer campus movement, they make the campus voluntary with these groups.
Yes. Mhm. Yes, please. Please. Please unmute it.
Sorry to interrupt, sir. So please unmute yourself.
Okay.
Thank you, sir.
Will you please say?
Yeah, are you listening, Professor? Professor S.C. Srivastav. Sorry, I'll say last few words within 1 minute. I'd like to speak it. Anyone help me? Are you listening to my words? Oh, sorry, I can't.
We can hear you, so please continue.
Okay, okay. My last word is like, you know, the law is not an antique, and this is
Yes.
not to be taken down and not to be dusted, or just we are admiring the laws and put back on the shelf. It is not like that. And law is rather like a tree, having its roots, its history, and we should nurture, we should develop and change our society and social concepts and values. We should grow up, and justice should be done towards the women and also the man also. So this is my last speech.
All
Thank
right.
you,
So
everybody. Thank you all.
thank you. Thanks very much. Well, I think, may I now invite Dr. Taranum and Dr. Sumitra Chaudhary. I think Dr. Sumitra Chaudhary is there. I can see her. Will you please, I think your topic is women, see the ruthless violence targeting women in India. I think, will you kindly make your presentation and be brief? Thanks a lot,
Sure, sir.
please.
Thank you so much. Thank you for the opportunity, sir. And I am presenting this paper along with Dr. Taranum Khan. And we both researched on the topic of custodial rapes, which is quite pervasive these days. And we've seen a lot of incidents on this. And that's why we decided to do a research on this particular topic in India and for Canada. So I'll be comparing the situation in India and Canada on behalf of both of us. We've seen that violence against women have been alarming, and it is nothing new. 1/3 of the women globally experience violence at least once in their lifetime. And there are so many obstacles when it comes to access to justice, and which is the main reason for having this widespread violence. So, rapes is one kind of sexual offense that is so pervasive, and it is so it is happening every single day. So for the last decade, we've seen that rape is one of the fastest growing crimes in India. When we see NCRB data, the National Crime Records Bureau data, whether by age or by religion, the analysis shows that every 16 minutes a woman is raped in India. And this is the data that comes from the registered crimes. So those which are not reported, the numbers are huge. So we can see that almost 80% of the sex crime victims, whether in Canada or in India, are women. It is also well-known fact that most of the rapes go unreported because of the victim's fear for retaliation and humiliation. So there is insecurity at each and every level. Women are harassed even when they go to the police station to report a crime. Coming to custodial rape, it is even more heinous and serious because this is a category of rape which involves the abuse of power and authority by people who are responsible to protect and promote the rights of women. So at present, it is one of the greatest threats faced by women who are already a victim of some kind of a violence, and they have approached the police, and police doing an atrocity and executing a custodial rape is an aggravated kind of a violence that the woman has to go through. So in custodial rape cases, mostly the rapists are persons in authority, and these incidents are highly unreported because the victims experience a fear that the rapist will definitely torture them to the highest level, and they will never get justice. These cases don't reach the courts. These cases are not reported. The victims are scared to report these cases. The abusers here are in dominance, and the power and the authority that they have, they try to misuse that. So in very rare scenarios, if such a case of custodial violence even reaches the court, then either the victim gets intimidated or the witnesses turn hostile. So there are very, very bleak chances that a victim will get justice in such a situation. Coming to the word custody, the Supreme Court has in a lot of cases tried to define what custody would actually mean, so that it is not just the custody of the police, but it is basically the custody of any person to whom carekeeping, charge, or safekeeping of a body corporal is given. As in, I will define it. I'll define the expression custody as defined by the Supreme Court. So, custody must be a lawful custody. So, the same may arise within the provisions of the statute or actual custody conferred by reason of an order of a court or law or otherwise. So, in a definition given by P. Ramanatha Iyer's law lexicon, the term custody means carekeeping, charge, imprisonment, judicial or penal safekeeping, defense from an enemy, preservation. So we are talking about custodial rapes. So where all can custodial rapes happen other than police stations? So it can happen in the hospital. It can happen in those homes where either women or children are kept to be protected in adoption centers. So these are basically the places where we are looking at having, cases of custodial rapes which may not get reported. So even in Canada, as recent as October 2020, there was an annual report which was tabled in the Parliament by the Office of the Correctional Investigator. So this report actually highlighted very important points. The report highlighted various aspects of the prison sexual violence, which is a systemic problem and it has been ignored for too long, as we are speaking for India too. So sexual victimization exists in the shadows of penetraries and is largely ignored and dismissed as an inevitable consequence of incarceration experience. That is what we are speaking about, that the victim getting even more victimized. So it is largely by virtue of the silence of the victim, not to report. And it's also the organizational culture which is basically contributing to this. So prison rapes often go unreported, and inmate victims often receive inadequate treatment for the severe physical and psychological effects of the sexual assault. So prison rape not only endangers the human rights, but it also endangers the public safety of the inmates. So there's a lot of human rights violation that happens when it comes to custodial rapes. Talking about the penal provisions or the criminal code in India, which deals with custodial rapes, I would refer to the case that Professor Manjula ma'am had also referred to, the Mathura rape case, because this was the case which led to an amendment in the criminal law, and section 376(2) was added in IPC, and I would just want to read out the section 376(2), specifically the part which talks about custodial rape. So in 376(2) of IPC, custodial rape was defined as whoever, being a police officer, commits rape within the limits of a police station to which he is appointed or in the premises of any station house, whether or not situated in the police station to which he is appointed, or on a woman in his custody or in the police custody of a police officer subordinate to him. So this is clearly said that, any police officer, if he does an act like this, then this definition also has whoever being on the management or on the staff of a hospital takes advantage of his official position and commits rape on a woman in that hospital. So the law has identified the places where such an incident could have happened, where lawful custody of a person is given to another person, taking him to be the protector. But then such a heinous crime is committed against them. So sexual assault in Canada is also defined in their Canadian criminal code, although it is although custodial rape is not specifically provided for, but there the definition of sexual assault is divided into level 1, level 2, and level 3. And level 1 is an assault committed in a circumstance of a sexual nature such that the sexual integrity of the victim is violated. So level 1 involves minor physical injuries or no injuries to the victim. Sexual assault level 2, which is section 272 of the criminal code, that deals with a weapon, threats, or causing bodily harm. Then the aggravated sexual assault, which is level 3, that has in itself a sexual assault that results in wounding, maiming, disfiguring, or endangering the life of a victim. So they've kept it very simple, as in they only have 3 levels, wherein the level of torture, based on the level of torture, the sexual assault is defined. Unlike India, where in India we have very specifically defined the custodial rapes. Now, in contrast to this, many other countries like the UK Sexual Offences Act has a definition of rape, assault by penetration, sexual assault, and then causing person to engage in sexual activity without consent. So even they do not have a specific provision for custodial rape. New Zealand Crimes Act 1961 also has section 128, which defines rape as essentially penetration without consent, while a sexual violation is normally unlawful sexual connection without consent. So when we see a lot of these countries who are developed and who are very progressive, even they do not have a definition of custodial rape, as in custodial rape has not been recognized as a offense which is, which is infringing upon the human rights. So here, instead of talking about only one gender, I would say it is infringing about human rights, because it is not only the women who are subjected to custodial rapes, many a times it is the men also. Further to this, I will just take you to the statistics or the major amendments. So like how the Criminal Code of India was amended, similarly, there was a major amendment made in Canadian Criminal Code. And this was made in 1983 and 1988. And based on these amendments, there was quite a few things which was added. So distinction between men and women was done, wherein previously rape could have only been committed by a man against a woman. Now the sexual assault is an offense which could be committed both by men and women. Marital rape is still not recognized even there, because marital exception has been given. So in accordance with this exception, no provision used to be made for the offense of sexual assault between spouses. But now today, sexual relation between spouses should be consensual is what is said, but there is no discrete recognition of marital laws. So when we compare the crime data of Canada and India, the data for sexual assault and other offences, they suffer from severe underreporting, as I've already discussed about. But in rape statistics, Canada is ranked 28th, while India is ranked 3rd. And rapes per million, so Canada is ranked 47th, as in 16.88 per million, and India is ranked 46th, so that is 18.39 per million. Considering the population of India, even though we may be somewhere nearby in this ranking, but then we are way, way, way ahead in number of rapes that is happening in India. So in Canada, every 17 minutes, a woman in Canada has intercourse against her will. 80% of sexual assaults happen in victims' own homes. 62% of victims are physically injured in attacks. 98% of charges laid for the least severe form of assault, and 2% of sexual assault offenders are sentenced to jail on an average. So
will you please suggest what you want? See, actually, will you kindly make your suggestions?
No problem. So
What
I'll make a
is to be done?
suggestion. What we had come to a suggestion was, when we looked at the situation of both the countries, we thought that there is a need for introduction of a legislative measure which would endorse a zero tolerance and preventive approach to sexual abuse and violence behind the bars. So in the United States, there is a law by name Prison Rape Elimination Act, and this was introduced in USA almost 20 years ago. And it was because at that time it was felt that there's a systemic need to address the problem of custodial rapes. So we are also probably looking at a situation, at a law like that for India and for Canada, wherein prison rapes gets eliminated. So this kind of a sexualized violence, which is a systemic problem, gets eliminated. So with this,
thank you. Well, thank you so much. I think there are two issues which need to be addressed. One is, so far as law is concerned, in 2013 Criminal Amendment Act, Criminal Law Amendment Act, and also under Section 114E was added to the Indian Evidence Act, where the certain presumptions have been made in that regard. Quite apart from this, it is also suggested that whenever there is a complaint in a custodial rape case, the inquiry should be made by independent authority. I think these are the suggestions which perhaps one may like to say when you look to it. The real problem is, I think Professor Saigal started with the issues of enforcement. And I think the real problem is the enforcement of law. We have the law. I think we have the effective laws, even under the Indian Penal Code and the Indian Evidence Act, where certain presumptions are made. But I think we have to address the issue from the enforcement point of view, how to make our enforcement. And one suggestions which have been made is that whenever any complaint is made, then such inquiry must be made through an independent body and not by the police authorities. Suppose any suggestion is made against any report, and then another issue which you need to consider it, where the victim is alive, but the perpetrator is not found, not available, or the police is not able to find him, then the question of what the law commission has suggested is the compensation aspect need to be examined so that she may be rehabilitated. I think these are the issues which perhaps need to be addressed while dealing with the cases of sexual harassment. Thank you.
Thank you.
Yes, I think now see we have, I think, let me conclude. I think, is there any issues, anybody? It is open for debate. I think we can give him 5 minutes, 5 to 10 minutes time. One or two questions I would like to take up. If anyone wants to clarify, seek any clarification from any of the speakers. Yes. Well, I want that, let it be, if there is anyone who wants to raise any issues regarding the presentations which have been made.
Sir, may I
Yes.
ask? Sir, may I ask one question?
Yes, please.
Sir, if you talk about the, share the knowledge to wisdom, wisdoms. We have to, in my opinion, is when you are talking about the particular issues, for example, the presenter comparative study between India and Canada.
Yes.
But I think I need to say that if you convert to knowledge to wisdom, you need to compare the holistic. You need to use the holistic approach to gain the knowledge. We have to know that the standard of legislatures of India and standard of legislations and in Nepal, standard of legislation of in the Bangladesh, what judgment given by the Supreme Court of Bangladesh and what judgment given by the Indian Supreme Court, what judgment given by the Nepalese Supreme Court, what judgment given by the United Kingdom judgment, what judgment given by the United States Supreme Court. Then after we can reach in the conclusion and we can find the gap between understanding, gap between knowledge, gap between legislation, gap between precedent, gap between residency, what difference between obiter dicta like that. Is it correct, sir?
Yes, I think you like to respond. I think.
But if you talk, about a particular issue,
would you like to respond to?
If you talk about the particular issues decided by Indian Supreme Court, and what will be the way to find out, and what will be the issues to find out, what will be the gap to find out, there is no solution, sir, in my opinion. If you study the holistic approach, all the things put in the box, then you take out from the one solution that will be better for the society, for the nation, for the organizations, for the individual also.
Well, I think the problem is more about the enforcement. I think we have to look that angle also.
Yes, law.
We have
Yes,
the law, we have the law.
we have.
See, yeah, I think it's better not to have a law, that a law which is more in breach than in observance.
That is why. That is why, because of the, sir, the society is very fast than law. The aspiration of faster and fast, that is the aspiration of ahead, the aspiration of faster, the aspiration of fast, that is guided by the activism which is given by the court.
True.
Right?
I think see, the Supreme Court has in India also. The Supreme Court has taken, see, in judicial activism, have brought number of things within the even the where the law is not there. They have tried to law and even incorporated the international convention. But the real issue is, despite all these laws and all these amendments, what we say is that we find still a number of cases which have been either not been reported or the enforcement is the real issue.
That is why, sir. That is why, sir. There is a different. There is a gap between the society and court. There is gap between the gap between the national instrument and international instrument. We need to take that in this situation. We need to take then another part. We should give the awareness to the society. We should give to the this to the society. We make such kind of environment to take and to observe the standard of international communities.
Well, I think yes, you are right. Yes. I think we have to change the outlook and the attitude towards the custodial rape and other crimes, crimes against sexual sex. And there's a need to sensitize even all the bodies, like whether or any other organization.
Yes, sir. Thank you, sir.
Well, I think if there is any other question, otherwise, let me thank the organizers for providing me this opportunity. And I must speakers for the learned speech, and they addressed all the issues. There are 4 issues which have been, I think, to begin with, Mr. Mahendra Jang Shah has discussed about the sexual offences against women in the modern legal society. I think we have to take here, we have tried to look into from the various perspectives and how law has changed from time to time to meet the needs of society. Coming to Dr. Seema Singh, she has raised very the excellent presentation on the jurisprudence of women's reproductive rights. She has cited number of Supreme Court decisions for this, where such matter has been taken. I think there is a need to look into the a new jurisprudence is coming in regard to the reproductive rights, and perhaps she is right to say that the family aspect must be taken into account, and only if you leave it only to the whip, I think there is a likelihood of disunification. Then Sir Abdul Ali, he has from Bangladesh, he has made, referred to number of issues relating to sexual harassment in the higher education. Perhaps we may look into the point from the various perspectives, namely we have to see how there are 3 elements so far as the Constitution is concerned. One is equality, second one is privacy, privacy to be addressed. And quite apart from this, we must look whether there should be some internal committees which they can have not through legislation. Otherwise, I think that may help to meet the situation. And coming lastly to Dr. Sumitra Chaudhary, I think she has tried to make a comparison between Indian and Canadian laws. I think both have got some cultural differences. We have to look to the law, and things is that Indian culture, and there most of the women, they are illiterate, they are not they have been brought up in a different setup, and we cannot, when we try to compare it, we should also look to the cultural thing at Canada as also whatever we have in India. And perhaps if we look from that angle, we will be able to better analyze and better compare the situation. Because we are comparing, perhaps we have to keep the situation in India and the situation in Canada. And if we look in from that perspective, perhaps we may be able to evaluate in a better manner. So thank you so much for your presentation, and I must thank all the speakers and the organizers for giving me this opportunity to share some thoughts.
Thank you
so much. I hope I have tried to complete it within the time schedule allotted to me.
Thank you, Professor Srivastava, for sharing the session. And I am grateful to all the speakers also who share their perceptions with us. Thank you.
So, Professor Sahgal, may I take leave? Say it is. If you permit, yes.
Okay, sir.
Okay.
Thank you so much, sir. On behalf of IPEM Law Academy, I thank Professor Dr. S.D. Srivastava, Dr. Mahendra Jamshah, Dr. Seema Sen, Dr. M. Abdul Aleem, Dr. Tarannum, and Mr. Mitra Chaudhary for sharing their views with us. Sir, ma'am, I have a further request. Just put on your videos on so that we can have a group photograph. I request all the speakers to please put the cameras on for a group photograph. Please open up the videos. Please open up the cameras. I insist to please open the cameras for a group photograph. Dr. Sona Sinha, I request to move the camera. Dear all, please switch on the camera. You are not visible. Thank you so much. Moving forward on to the second technical session of the event. This session is chaired by Dr. Naveen Jamshah, and the speakers for this session are Ms. Alisha Sharma from the University of Jammu, Dr. Monica Naran, Assistant Professor of the Law School, Jammu University, Ms. Sonam Parashar, Research Scholar, Jammu University, Dr. Beenu Sahayam, along with Dr. Bhuvaneshwari, Dr. Manveri Singh, Dr. Rashmi Khurana, Mr. Abhay Kumar. I request Dr. Naveen Jamshah to please take the session.
Thank you. Thank you so much for the conducting of these sessions. There is some significant points which must be followed by the presenter. The one thing is always be aware about the times, and second is highlight on the issues and give the solutions. And considering the time for questions, there are three main points for the presenter. I would like to request Mrs. Elisa Sharma for your presentation.
Good afternoon, sir.
Good afternoon.
Am I audible?
Yes.
With your immense permission, may I start?
Yes, of course.
Good afternoon, one and all. Present here, presentees, moderator, and IPEM Law College. Myself, Alisha Sharma, Law Department, Jammu University. And the topic of my research today is the trauma of sexual offences against women in India, practice and prevention. Sexual offense is a crime rooted in control and patriarchy, and it is a life-threatening problem not only against a woman but a serious problem for all of our society. One of the main causes of the issue of the dominance in our Indian society is the disparities among the society and among the men on the basis of gender. Women are still the objects suppressed and silenced under violence. Such a violence or abuse is impact badly mental and physical health, which may committed by intimate partner. And next, we throw some light on the cyber crime. The woman is not facing such a violence in the indoor or outdoor, but on the outside also. When she moved to the social media, cyber crime is here among us the best of example of crime against women, such as rape, cyber stalking, and image-based abuse, which is very harmful and based on the trauma in the mind of the women. So, the pornography likely to be born to die. Mentally disabled girls are also sexually violent, and cultures from time to time is being reports and special women officers are appointed to write a first information report on this such abused girls of the disabled girls. And next, we will move that when we have the research that there are many women who are the victims of gender violence, which takes place in the different aspects of their life, and rape is highly gender violent behavior where women become easy part of it. Sexual violence occurs throughout the world, and it is the most of the countries the research related to this problem has been conducted. As we found that the women are the victims at a very long time. It is a patriarchal. The consequences of sexual assault are very high range of risk in reproductive health issues. When you talk about trauma, it is defined as a realization of one worst fear that every human being would not want to have such experience. And sometimes we saw that there is a re-victimization, means that unwanted sexual contact, physical abuse, and psychological maltreatment. A person who was sexually abused is a minor and faces gender risk of further abuse in the adulthood. There are three phases when a girl should feel that sexually abused from very childhood, when she feels at the very minor age, then at adulthood, and after marriage also, still she faces the same abuse, and which is known as a marital rape at last. So there is no word to say no by a woman. She always has been suppressed under the command and dominance of the men. Sexual harassment or unwanted sexual advances, including the demanding sex favor in return. Rape or sexual abuse of mentally or physically disabled person. And sexual assault or abuse of children. And we move forward to the international and the national legislative framework. There are also declarations, ILO discrimination, employment, occupation, international covenant on socio-economic, cultural rights, United Nations Convention on the Elimination of All Forms of Discrimination Against Women. There is a lot of platforms to come forward, and the major amendment in India, the Criminal Amendment 2018, which has amended our legislative laws so that strictly action should be taken against them. There is sexual harassment, assault, or the use of criminal force, women with intent to disrobe, acid attacks, use of attempt to throw acid attacks, stalking, and on the IT Information Technology Act 2000, the cyber crimes. There are the media platforms. Everybody is concerned about it, but city also we are not safe even on the social platforms. Section 67, India, it penalizes any person for transferring obscene material in nature. Now, there is a case law of which state of West Bengal. It is granted the patriarchal interest of determining obscenity and have that only new things shall not come to the ambit of obscenity. There is an analytical view with the resolution approach. Considering the law has been amended.
Hello. Hello.
Miss Anisha.
Miss Alicia.
See, I insist on the time limit. The maximum time limit is 2 to 3 minutes.
Oh,
Alicia.
so may I continue?
Yes. You can take the 2 or 3 minutes.
Yes, sure, sir. There is a preventive fears. Every society has its own set of laws to prevent and the laws to control variety of sexual offences.
Excuse me, just you can highlight on the trauma from the sexual offense against women.
Sorry, sir.
Can you highlight the trauma?
Hello.
Hello, Elisa.
Hello. Yes, sir.
Can you highlight what are the factors, what are the significance, what are the problems uh, uh, occurred the sexual offense against the women?
Yes, sir.
Just to highlight on this point, highlight on this issues.
Am I audible?
So sexual offenses are faced by women at every
Am I audible?
of their life.
Elisa, is it okay?
Sorry for the interruption, sir. Am I audible? So can you get into the next please?
Elisa, Elisa, can you finish your presentation?
So please, may I announce the second participant? The second presenter is Dr. Monica Naran. Ma'am, we request you to present the paper.
Hello. Can you hear me?
Elisa,
It's Monica Naran.
Monica.
Myself, Monica.
Be aware about the time. I would like to request to Dr. Monica Naran for your presentation.
So much, sir. Thank you. Can you hear me?
Yes, I hear.
Just wait a minute. Just wait for 1 minute. Is it visible?
Yes, it's okay.
Okay. Thank you so much. So, good afternoon to all of you. It's a great pleasure and honor for me to present my views to this platform in the International Peace Seminar on Sexual Offences Against Women. First of all, I thank Professor Sagar, who is my teacher, my mentor, and all the dignitaries present in this program at above all, the organizers for giving me this privilege. The topic of the presentation is Victorious and Sexual Offences Against Women, a critical analysis of current framework. Okay. Yes. Victorious is a time in which any person saw on the face of a victim or on the body of a person, mostly women, with the intention of misbehaving. The most common kind of used to be the sulfuric acid, along with sulfuric acid, puric acid, carbonic acid, caustic soda, caustic gas, iodine is also recorded in India, usually as an act of sexual violence against women. What are the causes of acid attack? In India, it has become a gender-based crime. Excuse me, I think based on my voice. Can you also answer the or shall I close my video? Stop my video. I stop my video. So the causes, they are the gender-based crime and they generally targets women. Majority of acid attack incidents on women are for refusal to marry, rejection of love, or for any personal causes. The vitriol that is thrown over the victim is an inexpensive acid that is very easily accessible and has thus become an ideal weapon against women as the vitriol attack really kills the human being, but it causes severe physical scarring, disfiguring the face of the victim, and thus the perpetrators take the revenge of rejection. Then there are many girls who have died or they have disfigured because of this heinous crime, and there has been a tremendous increase of such acid attacks on women, despite of the fact that there are strict laws framed to curb this heinous crime. This attack that mostly aims at the face of the victim causes burns and damages skin tissue. The acid that is thrown is so strong that it can lead to blindness and that even dissolve the bones. Scenario after 2013. Even after the passing of it was already being discussed in the House that the amendment in the criminal law in 2013 and the guidelines which were given by the apex court that not even the other offences but the acid attacks relating to acid attacks also, where there are the maximum number of acid attacks not only in India but the world. Our legal system has it has been proven to be very weak while dealing with such cases. But even after all the amendments brought up in our criminal laws, the incidents of acid throwing they are not decreasing. So our legal system is probably facing lacunas because of which we are not able to see any improvement in the present scenario. Current scenario is getting worse compared to the situation that was before 2013. There's no doubt that acid attack is one of the serious problems all over the world. What are the effects of acid attack on the lives of women? Their life it becomes worse than death. Effects include burning of skin, flesh, enormous pain, irreversible injury. It also eats the layers of the skin, goes into the fat, and then muscles underneath can even dissolve the bone. Most of the acid attack survivors they face mental trauma. They during the even during the times of recovery, also the victim they suffer psychological trauma, feeling constantly conscious regarding their appearance. Victim suffers from the psychological problems, including the insomnia, nightmares, depression, fear of facing the world, headache, tiredness, fear of other acid attacks also. Then the legal perspective. It is to be noted that in India till there is till present there is no
words till 2-3 minutes or over.
Okay.
Please conclude it.
Okay. So the law that is that is under the Criminal Law Amendment Act 2013. Although there are the sections 320, 322, 325, 326, and 307 of the Indian Penal Code, but not as they are helping as per the offence, but on the recommendations of the Justice T.S. Verma Commission in 2013, amendments were passed in the section 326A and 326B was introduced under the IPC.
Can we have the next section?
Yes,
section 3 presenter, please.
Yes.
Ms. Sonal Parashar.
She is my co-speaker. I'll be presenting
Dr. Bhuvneshwari.
Let me conclude my presentation. Hello? Can I conclude?
Yes, please.
So my point was just regarding this acid attacks that as such, no, we are having these amendments, but there is no specific provisions which are dealing with this acid, literal rage or the acid attacks. We have the various judgments also. We have some of the Supreme Court rulings too. But I would like to conclude with some of the suggestions, like the acid should not be, the sale of this acid must not be as per, it should be freely available. Then acid attacks victims they must be included under the category of persons with disabilities for the purposes of extending benefits under various schemes of the government. Both should be they should take rehabilitation and welfare measures for the victims of acid attack, and the reconstructive cosmetic surgeries must be provided to the victims by the government. Then proper records of the stock, sales, supply, acid must be there. Psychological cosmetic surgeries must be provided to the victims by the government. So these provisions should be there. And I have also made a survey that acid is being sold in the market so freely that there is no say binding on them that they are freely they are being sold in the market. So just because of that, that they are easily available, and that is also very low charges, and the perpetrators, they can procure that and they can do that offense of acid throwing. So thank you so much. Hello.
Ma'am,
Hello.
can I
Yes.
start, ma'am? Bhuvaneshwari here.
I would like to third presentators, Dr. Binu, and along with Mr. Bhu- Bhune-
Bhuvaneshwari.
Bhunas. Yeah.
Thank
Yes,
you.
yes. Over to you,
Please.
Bhuvaneshwari.
Yes, sir. I am canceling my screen. Give me 1 second. Sir, is my screen visible?
Okay.
Okay, sir. Okay, this is about very dark acts of violence against women in India. I'm presenting with Dr. Venu Sahaya from VIT University, Chennai. Okay. So this is the introduction. Violence against women is the most pervasive yet least recognized rights violence in India. Country like India, where patriarchy is deep rooted, find themselves in a quandary where whether to rebel or reconcile, facing an existential threat wherein freedom means loss of security. In this paper, the violence against women is studied focusing on individual, interpersonal, institution, community, and public policy. This model provides better understanding on the factors associated towards the rape cases and the strategies to focus on possible intervention in addressing the plight of the women on the whole. So the objectives of the study are to have a better understanding of the prevalence of violence against women in India, to investigate women's socio-economic and ethnic characteristics in India who have been victims of different types of abuse, and using a biopsychosocial approach, investigating the causes of violence against women and devise methods to reduce the prevalence rate. So the need of the study is, despite India's rapid economic growth and progress, violence against women has increased. Rape, kidnapping, dowry death, domestic violence, verbal assaults, and molestation are some of the issues. There's a need to understand the causes and the factors contributing to high violence rate. So, according to the National Crime Bureau, one woman is raped every 20 minutes in India. Violence against women in India has been rising despite faster Indian economic growth and development. The most common forms of rape are rape, kidnapping, dowry death, domestic violence, verbal abuses, molestation, etc. Despite increasing prevention measure, many abuse cases are happening daily. There is a need to understand the violence against women and the factors associated with these increased violence rates in India. Thus, this article explores the reasons for violence against women in India that have been reported. So, this is a literature review. So methodology is, the study focuses on case study methodology to understand the current situation and get an in-depth understanding to plan viable interventions in addressing women's plight in society. The case study method is a qualitative approach. It involves close and comprehensive observation of a social unit, a person, a family, an institution, and a cultural group, or even the entire community. Thus, a case study is essentially an intensive investigation of the particular unit under consideration. The case study method aims to locate the factors that account for the given unit's behavior patterns as an integrated totality. In this study, 15 case studies were discussed and collected from newspapers, online, e-papers, and these articles help to understand the rape cases faced by women with the case studies in India. This study provides a platform for understanding and tackling the sexual offenses existing in India. Okay, this is a socio-ecological model and its implications. So this is developed by sociologists associated with Chicago School. This model is tailored to show that the different levels are constantly interacting with each other to influence violence against women. Many things influence the perpetration and victimization of sexual violence. Therefore, preventing sexual violence is more complicated than other public health issues, and this is why our prevention efforts must reach people on multiple levels of the socio-ecological model. So in the dimensions, there are 4 different dimensions: individual, interpersonal, community, and public policy. The strategy that can be done by individual dimension is changes in behavior and attitude. So every individual must have a change in their behavior and their attitude should be encouraged. And preventive method is sorry, provide informative sessions on a range of subjects relating to women's abuse. Interpersonal, by modeling positive communication and behavior, you may encourage others to do the same. Peer or bystander programs. Preventive methods are peer or bystander programs offer adolescents the resources they need to shift the environment in their social networks by refusing or intervening when they hear or see behaviors that support violence, sexism, or other forms of oppression. Community plan an ambitious initiative to enhance the community environment by focusing on procedures or policies. Preventive methods, creating awareness campaigns in educational institutions, businesses, villages, encourages a holistic understanding of women's rights security. Public policy, supporting sexual freedom and healthy relationships by strengthening social norms, policies, and rules. And legislators should concentrate on preventive measures and disciplinary proceedings against those who have been found guilty. Okay, discussion. The case studies give give a summary of women's abuse in India. Our results confirm the importance of female literacy rates, female paid workforce participation, and a female-male ratio in understanding crime. We find that these commonly used socio-economic variables have non-linear effects on crime against women. Our findings improve upon earlier results that have not explored either spatial distribution or non-linearity in India. These findings could have significant implications for the policies aiming to CAW. So the above case studies provide an overview of the violence against women in India. The case studies look into the socio-economic and demographic background of these women who faced various forms of violence in democratic India. Based on these case studies, the rapes belong to various types such as opportunistic rapes, planned rapes, partnered rapes, gang rapes, that they are gang rapes, and rapes by people victims are an acquaintance with. So in conclusion, violence towards women has high social, health, and economic costs for both the women and the community. Forcing women into a subordinate role in comparison to men is violence against women is one of the most important social mechanisms that society uses. The most serious result of these rape cases is the infringement of human rights and basic freedom. Violence, actions, and threats instill fear in women, leading to widespread feelings of vulnerability in women's societies. This apprehension causes women to become immobile, preventing them from exercising their basic rights by preventing them from participating in basic tasks and restricting their access to opportunities. There are prevalent myths in society towards sexual offenses towards women. Women's way of dressing and their attitude towards a society where their confidence is labeled as arrogance is that women's independent and individualistic nature is observed as causes of violence towards them. Their way of dressing is seen as an invitation. Their confidence shakes the menfolk, and their independent attitude is perceived as an arrogance to be controlled through the act of violence alone. These myths are to change by educating society via awareness programs and building more co-educational institutions rather than single-gender educational institutions like college for women and men. So final words, the Wall Street Journal's India Bureau explored the plight of India's women in great deal in the past 12 months. These stories in this e-book show how the social blight evident in the Delhi rape is a phenomenon across the country in various forms. What the crimes chronicled here have in common is the failure of society in general and the government institutions in particular to protect women in vulnerable situations. It is not primarily a question of inadequate laws, but of incompetence or venality in their enforcement, says Krishna Pokhrel in Crimes Against Women, the three tragedies and the call for reform in India. So these are the references, and thank you for the opportunity. Sir, you have been muted, sir. Can't hear you.
Ma'am, I will conclude and I will have some remark for you. But because of the times, I will let you know in the after all presentation of technical session 2.
Sure, sir.
Now, without due delay, I would like to the both presentators, Mohabendra Singh, on the topics of challenge in prosecution of sexual offense and institution involved in administration of justice. Presentator 4.
Dr. Manveen Singh.
And highly requested to be aware about time.
Thank you.
Mr. Mohabendra, are you ready?
Yeah, good afternoon, sir. I'm ready.
No, okay, go ahead.
Just a minute. Good afternoon, everyone present here. I'm clearly audible. I'm clearly audible.
Yes.
Yeah. Good afternoon. Good afternoon, everyone present here. My topic of this particular conference is challenges in prosecution of sexual offences and institutions involved in administration of justice. Okay. So, I'm looking at that everyone is talking about the production of sexual harassment. Boys is increasing. Just a minute. Yes. So, basically, everyone is talking about the sexual assault and the offense against women, and that is a very common problem from the beginning of the once we are not having a legal system. Still, that type of offenses occurred. But right now, in the present scenario, we are progressing with the human rights. We are talking about the general laws of the gender equality and anything that is related to the gender protection. But right now, after the recent era of the recent example of this 2013 Nirbhaya rape case, we found that still there is a lot of lacuna in the criminal legal system regarding the offense involved to the offenses against women. For that purpose, there is a one specific committee also there, the late Chief Justice Verma committee, and the recommended number of different perspectives that talks about the speedy trial, that talks about the different scenarios and the problem concerned with the women. That include the stalking, gang rape, enhancing the punishment, and different things. But still, the problem is that we are having a very strong legal provisions. We are having a lot of legal provisions and a lot of law cases over there. But the problem is that regarding the prosecution, and this prosecution challenges prosecution started from the side of the victim, not from the side of the accused. First and foremost thing is that the victim is not going to register the complaint. And the reason behind that, the society, the societal pressure. Because of the societal pressure, because of the society, and because of the social stigma, that is very, it's very tough to the victim to just go and approach someone. And if she is just trying to approach someone from maybe from family or maybe from outside the world, they said always don't go for this. Otherwise, your reputation on the stake. So that is the first and foremost challenge in front of the victim. And because of this reason, the registration cases are not so much frequently going to be enrolled as an FIR. Another challenge is the registration of FIR. We are having section 54 of CRPC. We are having a provision that the informant have a free copy of the particular FIR. And we are having a lot of very clear and specific provisions. But once we come to the picture, once we come to the reality, we found that it's very tough. Because police is also not going to register FIR generally, in a very general manner. The reason is that Because of the registration of this FIR, the crime rate of the concerned police station has been going to be increased. This is a problem to the police station. And maybe the particular concerned SHO or DSP under the scanner from the government to the state government. So because of this reason, because of this logic, because of this bad logic, people are not going to lodge FIR over these issues because they all are sensitive issues. And this reason, because of this reason, cases again there is a victimization of the victim. So this victimization of victim and the other issue concerned over there, there's a problem. This is the problem. Another challenge is that we are not having any such type of specific helpline or any such type of mechanism where this particular thing is very simple or easy or crystal clear to the women or the concerned victim. Whether that matter related to EU teasing, whether this matter related to the rape cases, whether it matter related to the stalking, whatever the matter. So that type of challenges we have. In spite of that, the definition of victim given by the CRP under section group, it is very wide. The definition is wide, and that is a very good approach by the 2013 amendment. But still, the lacuna is there that people are the problem is mindset. Because of this mindset, people are not going to approach, victim are not going to approach over the specific issue, and that is the reason. That is the real reason. So for that purpose, apart from the law, the society will come into the picture, and society will take a step forward just to increase, just to support the victim at the first instance. Once the society is not come with their proper mindset, it's very tough to tackle with the problem. We are having laws, we don't require any law, we don't require any amendment, we don't require any change. The only requirement is that the social mindset. And because of this, the prosecution has been effective. Maybe people are not agree with me, but that is my personal opinion. That I just gone to the different police station over this particular issue because I done one of my project regarding the
Dr. Mohendra.
Yes, Manvendra, Dr. Manvendra.
Manvendra, yeah. I am Mohendra. That is why.
Yeah. I know, sir.
But you put significantly the challenges, right?
Yes.
But what are the solutions? Can you give in the points?
Yeah,
1, 2, 3, 4, 5, 6.
Exactly. So solution is first solution is that society will help the victim from the beginning. And another challenge is that another issue is that right now we are also tackling with the problem. Position has been increasing. Just look at the police station. In police station, we are having the lady police constable in a very frequent manner right now. Obviously, we are not having. But after this 2011 or 13 era, we have found that we are having sub-inspectors or lady inspectors in the police station. So it's very easy to the lady to communicate their problem to that lady. Another thing we can do one thing that we can just play some ads or some commercials over the cinema.
So you are please to conclude
the different platform where we can just give awareness about these issues.
Can you conclude?
Yes, sir. So my conclusion is that this is only possible once we have to reform the police, the little bit policing system, because our policing system is completely belong from the British system. Okay, so they require human rights aspect of the society and the police. Once they are having the human rights aspect of society and police, then it's very easy to the victim to talk about these issues and tackle the situation. That is from my side.
Thank you so much, Dr. Mohendra. Thank you so much.
Anyone can ask me also. I'm available.
Sorry?
Any question or any query? So
it's okay. I'll let you know in the when all the presenters finish their presentation,
Definitely.
then I will tell you
Definitely.
something. And
Definitely.
thank you so much.
Thank you.
May I call the next presenter, Abhay Kumar?
Yes, sir.
Okay, go ahead.
Audible, sir?
Yes.
Sir,
Go ahead.
please allow me to speak, sir.
Sorry?
Please allow me for sharing screen sharing.
Okay. Okay.
If it is visible, sir?
Not visible.
Visible?
Yes, yes, yes.
Okay, sir. Now, firstly, I would like to special thank you for this institution for providing me golden opportunity to share my all the views related to sexual offense and against women. Now, I'm going to deals with this. I'm taking, yes. Now, yes, this is the abstract which especially talks about the my paper. The paper is basically based on analyzing the sexual harassment on a different state and all over the India. This paper is include the rape, sexual assault, mental illness, and offences. Now the introductory part, which is related to Indian and all globalization. Now I'm going to focus the impact on the society. Every crime in the India, apart from the India, the most important part is the society. Society plays the most important role to sharing the offenses. Any kind of offenses, I'm talking about this especially to the sexual offense, any dacoity, robbery, or any kind of things. Now, the aim of this paper to better understand the domestic violence against women's and investigations a victim, like how after the offenses has done, then what is the life of a victim and how they face to the society in the society. Now I'm going to make the research methodology which is priority single all the topic, scope the study, and to focus of the violence against the women's, and the study review also the raise the current situations, what is the sexual offenses. Now you can see the data which is I mentioned in the this PPT. The most of the rape were registered in the Madhya Pradesh, Uttar Pradesh, and again the Maharashtra. This is the most highlighted state in the India where the case were registered in the data 2014, 15, 16, as well as the very wider concepts. Now again we have according to United Nations all over the rape which is all over the country. You can say that the data crime against women 2002 to 2020. Now the orange line which is indicate the rape, and the blue line is indicate the crime against the women including the rape. Now in 2020, day by day the crime is increases. What is the most five I mentioned in the according to the data 2011 census, there is 940 females for every 1000 male. This is the vast difference between the male and the female. That's the reason the sexual offenses increases very fastly. Now you can see that in this PPT the state-wise list. Now the left side 50 data is showing that the 17-year the data. Now Goa is the high most state in India which is show the percentage of the sexual offense, and the right side data shows that the Madhya Pradesh, Uttar Pradesh, Rajasthan, Kerala, these are the states where sexual offenses are very high in the worst situation in
Now I'm going to move the second most important provision, which is the talks about the constitutions generally providing the equality, fundamental right, PHP, direct and so many provisions there. Now Article 14, which is basically talks about the women's equality before the law, and the Article 15 one clause is mentioned there that there is no discrimination on the basis of caste, sex, religion, place and birth, and also IPC play the most important roles under the sexual section 375 to 377 is mentions so many things which is related to the rape and women, and who will be involved with these offenses. Now in this data I would like to mention the front of all the present here, the neighbor, friends, relative, employers and unemployment workers, women are not the most of the neighbors were involved in this activities in the heinous crime, we can say that. And again this which is talks about the case laws. Now the most important case law, as you might be aware of, the Delhi crime case law, which is known as the Nirbhaya. The full citation case is the Mukesh and another state contested Delhi. Final judgment come in the 20 March 2020, which is
Am I
held
audible?
at yes ma'am. Yes ma'am.
Please conclude.
Yes ma'am, give me 1 minute ma'am. Now the causes of the sexual offense is mental illness, illiteracy, additional alcohol consumption, so many things will directly impact to the offenses. Now there's some suggestion and solutions we have mentioned in this 50. The suggestion which is improve the laws, and the second we are going to run some programs which is based on the offenses, why the offenses increase day by day, and what is the importance essential try to understand in the society. The conclusion is based on the material which we have to understand the human behaviors and everybody's equal rights. Mention the gender, we need to understand the male and female gender gap between and so many things. And again we have reference and the last we have. Thank you everyone.
Thank you so much.
Thank you sir.
Ma'am, this one is the last, right? Excuse me, ma'am. Excuse me, ma'am. Excuse me, ma'am.
Sir, yes, sir, you're audible.
Yeah. This one. The next one is last, right?
Yes, Himanshu Singh.
Yeah. Okay. The last presenter, Himanshu Singh. I would like to request to take his presentations on the topic of sexual offense against the women, a menace to societies. Himanshu Singh.
Am I audible to?
Yes.
Am I audible to?
Yes.
Okay.
Right. Go ahead.
I'm Himanshu, follower of Gautam City, Greater Noida. I'm glad to be the part of this National Seminar of Sexual Against Women. Hello.
Yes. You are okay.
Am I audible, sir?
Yes, you are okay.
My paper title is Offences Against Women, Menace to Society. Sexual offences against women occupy a significant place out of all the crimes. That is a crime which shows conscience and the root of the society. And that is the most heinous crime nowadays. That is rape. This is only a crime where the victim is socially oppressed and morally degraded, with a lifelong stigma on her dignity and a character. The family of a victim also faces mental torture, and the agony is unbearable. In such a state, the victim tries to get a justice by applying the code, holding the provision of penal laws close to her heart, and hoping against hope that justice will render to her. India does not have a sexual law that specifically deals with the definition of sexual offense. Thus, it becomes a mandatory to refer the legislation of the other countries, which have a similarly enacted legislation in this regard, like UK Sexual Offences Act 2003, which deals with the concept of sexual offenses, way to prevent them, protect the children, harm to causes sexual and other connected offenses. Now I come to the definition of the sexual offenses. Like, the definition of the sexual offenses varies from country to country. For instance, if the definition of the sexual offense we talk about the UK or in Ireland, applicable to the sexual exploitation, sexual abuse of a children, sexual grooming, as well as child pornography. And here, sexual act means an act that consists of the sexual intercourse, an act which is, if committed without consent, would constitute sexual assault. Now, I would like to discuss the consequences of sexual offense. The consequences is very much important part of this paper. The sexual offenses are not new to the Indian society. They existed in the past, they continue to exist in the present. If not controlled on time, they may lead to the serious consequences for the future as well. Now we talk about the role of the judiciary, the dynamics of the judiciary, the gender justice, worldwide problem. The causes are many, but it is a duty of the every human being to protect the rights of a victim from human rights violation. As according to the justice norms, the court finds the law and interprets it. The judges have at time applied the discretionary power in order to provide better sense of justice to women in the light of her socio-economic conditions. Judiciary has also played an active role in enforcing and strengthening the constitutional mandate by protecting the rights of the woman. Judiciary also provide a mechanism for the effective settlement and resolution of between the parties under the doctrine of separation of power. The function of the judiciary is not make laws only, as it prerogative of the legislature in a plenary fashion, or not it enforce law which is against the responsibility of the executive, but rather interprets the law made by the state, applies it to facts as of the case before it. Now I conclude my topic. To combat the problem of sexual offences, it has to be taken by the very state organs. The laws related to the crime and the punishment has to be very much adequate, as well as the process of implementation of the laws should be very much strong, and the implementation agencies in the government has to include economic opportunities for the potential victims and improve infrastructure facilities to provide the minimum services they are required immediately to the victims of such offences. Now I provide some suggestions. As per looking at statistical data provided by the NCRB as well as the news published broadcast of the evident crime against women journal, in particular sexual offences are increasing. There is no bar of caste, color, creed, age, but only the womanhood, which is adversely affected, and it is very dangerous that after independence we have established many schools, colleges, universities, more newspaper, TV channels are also established. All the religions are developed with the latest technology in their place of worship, but at the same time we have also enacted many laws. Crime rate in also increasing. This is very painful and dismal sign of future country. So it requires to change the mindset of the people and the moral of education. Then they only we need to say to prevent our children, sisters to be safe. The need of the time is the total reconstructing which is required in the administration of a criminal justice in India. The establishment of the more courts, adequate judges is procedural and the substantive law is required. Like in the evidence of the CRPC, there is an urgent need to be for suitable infrastructure to cope up with the demand of the quick remedial actions. Like we have a fast track courts, which deals with the offences committed against the women. The long delays in the processing of cases obtaining the convictions have resulted in loss of faith in the enforcement agencies, and the purpose of the constitution to provide the access to justice to all the citizens is somehow lacking behind. The faith need to be restored, and implementation of the various recommendations and the suggestion given to the government from time to time. That's all from my side, sir.
Thank you. Thank you so much. Thank you so much. Ma'am, can I conclude the session 2? Excuse me, ma'am. Excuse me, ma'am.
Yes, you're audible.
Yeah. Uh, can I conclude the technical session too?
So we have a next contestant also, Miss Neha Garg,
Oh, Neha Gaur.
IPEM Law Academy. She's right there, sir.
Oh, I'd like to request the next presenter, Neha Gaur.
Thank you, sir. Good afternoon to everyone. My topic is different faces of sexual offenses during the age of a female, a burning problem of Indian society. It is sad, yat nari pujate, ramte tat devta, where women are honored, divinity blossoms there. Means कि जहाँ नारी की पूजा होती है वहां पे देवता का वास होता है. This month from Smriti clear show the high place of respect for women in the society in ancient India. Even so, the status of women in practical aspects was not clear. But later on, because of social, political, and economic changes in the society, women lost their status and divine position in Indian society. Many evil customs, traditions, and practices stepped in society which confined the women and restricted them within the boundaries of the house. In scripts, the woman's status was so high, but practically it was low because women were prohibited to take part in making decisions in internal matters and as well as external matters, even in the matters of her own life, like marriage. Before marriage, women are dependent on their parents, and after marriage, dependent on her husband. Right from the time of her birth, or even before a girl could become victim of a crime or target of a crime, let's look at different phases of sexual offenses in a woman's life and discuss them briefly. Just as the space vary, nature of crime vary too. I'm here highlighting some important aspects of the issue, like the 2019 National Crime Record Bureau Report of India. States are reported crime rate of 62.4 per 1 lakh rape cases, in which rape rate is 7.6%, and the rate of domestic cruelty by husband and his relative are 30.9% per 1 lakh cases. Here I am going to discuss some stages which are faces by a female during her age, like stage 1, foeticide and infanticide, where there is an economic or cultural preference for sons. The pregnancy diagnostic tools can lead to female foeticide. School going age, stage 2. Many girls are not given the access to and completion of proper primary and secondary education as compared to boys, and otherwise may also suffer from discrimination at the hand of parents and teachers in their upbringing. Stage 3, that is youth. Many youth girls become victim of sexual abuse, both on internet and otherwise exploitation and violence, acid attacks, rape, early marriage, etc. Stage 4, marriage. Many women are tortured physically, economically, and emotionally after their marriage by their husband and in-laws. Stage 5, motherhood. Women are sometimes not provided proper medical care and healthy food during and after her pregnancy. She is often compelled to abort a female fetus. Stage 6, that is last, workplace. Often women suffer from exploitation, unequal pay for equal work, lack of promotion despite merits, and physical, economic, and emotional abuses. All these stages, woman quietly suffers, or even if raises her voice, it is silenced or suppressed. She neither knows she has right to fight these crimes and what remedies are available in law to protect herself. It is time women rise to protect themselves. In its first ever gender gap study covering 58 nations, the World Economic Forum has ranked India a lowly 53 rank. The report titled The Women's Empowerment, Measuring the Global Gender Gap, measures the gap between women and men in 5 critical areas like economic participation, economic opportunity, political empowerment, access to education, and access to reproductive health care. The report is based on United Nations Development Fund for Women's finding on global patterns of inequality between men and women. The low ranking reflects a large disparity between men and women in terms of economic participation, education, reproductive health care, access to education, and access to reproductive health care.
Ma'am, you're not audible.
Hello. Hello. Ma'am,
Yes, sir.
can you conclude?
Okay, thank you, ma'am. Sir, I think we should end up this session.
Ma'am, thank you so much for all presentators. But I don't have the personal comments on the presentator that given by the individual. But I would like to add some things regarding to the topics, the sexual offense against the women. First, the presentators need to highlight on the victim-based justice systems. You know, if you talk about the sexual offense against the women, we need to we need to talk about the victim-based justice systems. Victims should get the reparation. Victims must feel that they are getting the justice. That is one thing. And another thing is we need to, if the government and our relevant organizations must try to the women governance. After that, they will get the the offense can prevent from the various aspects. But we think we should think that the societies and development, they are going together, and also crime also, development, societies and crime, they are going together. We need to separate them, separate crime from the society and development. That is the one thing. Next thing, and another thing is there is a international instrument are there and national instrument are there. If if we are not understanding and we are not studying between international instrument and national instrument, we cannot find out the problems and we cannot provide the solution. We need to study the comparatively and reach the in the conclusion by the analytical means of the study. Another things, and next thing is that we have we have very sufficient standard because we have the liberal democratic constitution, we have the separate law. But the law enforcement agencies, because of the law enforcement agencies, the result of crime against the result of the women governance is poor now. And another thing is that that because of our the justice system, legal systems, we have some sort of the blind investigations. Blind investigations. Based on the blind investigations, the authority use the forced persecutions, and under the blind investigation and forced persecutions, justice delivery system is became like the dictatorial tribe. We should also consider about it. Thank you so much for this time, and congratulations for presentators. Thank you so much, ma'am.
Thank you, sir. The next session, that is the third technical session, has been categorized under the sub-theme Sexual Harassment at Workplace. The chairperson of this session had been scheduled as Dr. M. Abdul Alim, but he is unable to join us due to certain technicalities. The participants who will be presenting the papers in this session are, let me first call Dr. Upasana Sharma.
Good afternoon, everyone. Am I audible?
Yes.
Okay. A very good afternoon to the organizers as well as all the participants and to the respected chairperson. This is Dr. Upasana Sharma from the Law School, University of Jammu. And the title of my paper is Complaint Machinery and Mechanism, a major stumbling block in the achievement of the avowed object of the sexual harassment of women at workplace, that is the 2013 Act, 2013 Act. Am I audible?
Yes, ma'am.
Okay. All right. Thank you. Thanks a lot. So in this paper, as the title suggests, I have focused on the loopholes in this 2013 object, 13 Act, sorry. There are many loopholes in this Act, which I have pointed out. And along with pointing out the loopholes or the lacunae, I have also suggested certain measures in order to, contain or in order to control the loopholes. The first loophole which I found while studying this Act is that the sexual harassment, definition of sexual harassment, as is mentioned in the Act, it does not take into account the subtle forms of sexual harassment. Like, if we go by the definitions, physical contact, advances, sexually colored remarks, showing pornography, such like acts are included. But the subtle forms of sexual harassment, like in which a female is compelled or she is persuaded to sit close to a head of the institution, such type of acts, or in which a female is made to stay back after rest of the staff has left against her willingness, or female is made to stay back to share a cup of tea or have snacks with the head of the institution and certain other male members when she is not willing to do so. Such kind of acts have not been mentioned under the Act. There is no single example where such type of acts have been included. Secondly, there are certain circumstances that have been mentioned in the Act. Such circumstances, if they occur along with the acts of sexual harassment, they are also included in the definition of sexual harassment. When we study these circumstances, we come to know that in all the circumstances, either expressly or impliedly, there has to be a threat of unfavorable treatment or a promise of favorable treatment. But no single act which frustrates a female, like I exemplify, changing her duties frequently, even if the burden of the duty remains the same, demeaning her work, not giving her work according to her caliber. Such kind of acts, they frustrate a female if she is capable enough and in the working environment, she is promoted or she is being presented like an incompetent, and all this just to secure sexual favors from her. She is being compelled by creating a frustrating working environment for her. Such type of circumstances have not been included, or at least there is no example of such kind of acts in the Sexual Harassment Act. Then another loophole which I found, and which is a very big loophole, that is the way this complaint machinery is to be constituted. As the title of the machinery suggests, it is internal complaints committee, meaning thereby it is internal to the institution or the organization or the company in which the act of sexual harassment has taken place, meaning thereby everything is going to be settled within that institution or within that organization, and no outsider is coming to know about it. First thing which is negative about it is that the internal complaints committee is to be constituted by the employer. The act says so, that it is to be constituted by the employer. And if we go by the act, employer means the head of the institution or the company or the organization. So I fail to understand that how come the lawmakers, they became ignorant to the fact that many a times and lot of times the employer or the head himself may be the perpetrator. He may be the one who is sexually coercing, or who is sexually exploiting a female. So if it is left to the head of the institution to constitute ICC, and if he himself is the perpetrator, many a times and most often he either delays or he either refuses or adopts delaying tactics to constitute the ICC. Secondly, it is provided in the Act that the members of the Internal Complaints Committee are to be nominated by the employer himself. So again, if the employer or the head of the institute himself is the perpetrator and the Act has given him power to nominate the members of ICC, he will obviously choose members of his choice, and the chosen members will obviously give statements or give inquiry report in his favor. And this has happened in number of cases. I'll cite, like it has happened in the case of Linda Eastwood versus Union of India. It has happened in the case of I'll cite certain cases. It has happened in the case of Dr. Kasturba versus National Institute of Technology. It has happened in the case of M. Rajendran versus M. Daisy Rani. It has happened in the case of Rashi versus Union of India. And all these cases are latest cases, 2013, 15, 17, and 19. So if we are leaving the constitution of Internal Complaints Committee and the nomination of members of the committee in the hands of the head of the institute, so we are failing to take into consideration a very basic fact that many a times, and it does happen, that the head of the institute himself may be the perpetrator or himself may be committing the act of sexual harassment. Another loopholes which I have found are that the two other members, they are to be nominated from among us the employees. If they are to be nominated from among us the employees, then the employees, supposing, let's take the case of Rashi versus Union of India. In this case, the perpetrator was a secretary level official. Secretary level official means the topmost official. And if two other members of the employees are to be chosen from the same department, it means the members are going to be subordinate to that higher official. And in this case, they were subordinate to the secretary. So whatever the secretary desired, whatever statements he wanted, he extorted from those members, and the members tried to please the secretary level official. And in this way, the report which ICC gave, it was a biased report, and it was pointed out by...
Sorry to interrupt, ma'am.
Yes.
Ma'am, please conclude this.
Okay, I'm concluding. So I'll just point out the various loopholes which have pointed out. And the other loopholes are that there is no mechanism, that has provided no mechanism to ensure compliance of the natural justice principle. Again, this was pointed out in Rashi versus Union of India. Then only one member of ICC is independent, which is again not a very sound thing done by the Act. Next, it is not mandatory for the independent member to attend all the meetings of the ICC, and because of this, many a times the independent member, he doesn't attend the meetings, and in this way, the inquiry committee is a complete biased. Inquiry committee acts in a complete biased manner. Other loophole is there is no time frame for completion of inquiry by the ICC. Neither the Act nor the rules have provided so. And it is nowhere provided that it is mandatory for the members of ICC to record reasons for absence from meetings. So when the members, they feel that the inquiry is being held against their seniors, so they make themselves absent from such inquiry reports or inquiry committee meetings, and they refuse to sign the report of the committee. So in this way, through my my paper, I have tried to highlight that although the act is there, but the way the act has provided for the constitution of ICC and the way the ICC work, it itself has failed the act, and the act is failing to achieve the desired object. Thank you. Thanks a lot.
Thank you so much, ma'am. Our next speaker is Mr. Dev Kumar Yadav, Institute of Legal Studies.
Yes, ma'am.
Yes.
Ma'am, am I audible?
Yes, yes, you are.
Okay, ma'am. Good afternoon, everyone present here. Myself, Dev Kumar Yadav, pursuing BLLB from Institute of Legal Studies, CCS Campus, Meerut. Today, I am here to present my paper on the topic acid attack, a burning issue in India. Acid attack. Acid attack may be a worldwide problem for all, regardless of age, caste, and
Mr.
faith.
Dev,
Yes,
am I
ma'am.
audible? Please
Yes,
open
ma'am.
your camera.
Ma'am, it is not working.
Oh,
Ma'am, I have tried.
okay, so continue.
It is the foremost kind of gender-based violence against girls. Despite the prevailing laws and prohibition over the sale of acid, this crime has been on the rampant rise in India. Women represent a vital half within the society, and we need to secure the vital half of the society. National Commission of India outlined the acid attack as any attack of throwing acid or mistreatment of acid in any type of victim with the intention of or with the information that such person is probably going to cause the opposite person permanent or partial injury which occurs for a lifetime. Law Commission of India in its 226th report stated what are the factors affecting the acid attack. That maximum victim of acid attacks are girls, particularly young girls, for rejecting proposal of weddings, denying dowry, etc. The assailant can't bear the fact that he has been rejected and seeks to destroy the body of the lady. What are the effects of the acid attack? Attack incorporates a devastating impact on the physique, typically for the good blazing the victim. The after being the shortcoming of to try and do several everyday tasks, operating and even mother life, etc. Physical effect. Acid fair though lasts 2 years on the skin, that is the fat and muscle beneath it. Typically not solely fair through the bone, however, even dissolve the bone. The deepness of injury entirely depend on the strength of the acid and also the length of its contact within the skin. Once thrown on person's face, acid chop fare into eyes, ears, nose, eyelids, etc. Inhalation of acid vapors will produce respiration issues in two ways: by inflicting a toxic reaction within the lungs and by swelling the necks. And the second effect is psychological effect. Psychological effect. Acid survivors face several psychological states upon a recovery. Acid violence victims are reportable with the high level of tension, depression, thanks to their look. As per the Rosenberg scale, the lady is reportable down self-worth and executive self-consciousness. And third effect is social and economical. Acid attacks sometimes leave victim unfit way, rendering them upset with their partner or family for everyday activities like ingestion and running errands. They face a time period for discrimination from society. They become lonely. Some infamous cases of acid attack are Lakshmi case, Hasina Hussain case, Sonali Mukherjee case, Preeti Rathi case, and many more. National Crime Report Bureau reported 45 cases of acid attack in 2014. 2,249 cases were reported in
Mr. Dev,
2015.
am I
Yes,
audible?
ma'am. Yes,
Thank you
ma'am.
so much. Thank you so much.
Okay, ma'am. Thank you, ma'am.
Our next speaker is Ms. Priyanshu Saxena.
A very good afternoon to all the present dignitaries and my fellows attending the e-seminar. And thank you IPEM for giving us the opportunity. So my research paper does not travel around the bird, but it revolves around our own culture and country. I will not talk about the already talked and discussed
rules, laws, regulations, amendments, etc. But I will definitely try to analyze what is the actual impact of these crimes on the mentality of a woman. I will keep it very basic and raw so that even a layman can understand what I am looking for and trying to analyze through this research paper. The term sexual harassment, it is defined under section 354A of the Indian Penal Code. Let's not go into the bare language. Directly talk about the real experiences of sexual harassment. Once a 5-year-old female child was going in a market with her father, a laborer came from behind her and touched and pressed her buttocks. People here might feel sophisticated and offensive by my straight language, but it is the need of the hour if we want to remove this stigma from our society. Another example is a girl is going to school. She is in class 12. A male around the age of 23 or 24 comes from nowhere on a bicycle and say, "I love you" to her. And she starts crying. A college-going girl of 21 years of age was in an exhibition. A group of boys comes around her, create a false smoke chaos, and touch her breast or pinch on her buttocks. These are all our real incidents heard from family and friends. The issue is we no often talk about these serious things. In Gita, it is mentioned that there will be a time when a girl of 5 years will start getting pregnant. Now, let's analyze how. The human life expectancy these days has decreased now with 64 years as an ideal life expectancy. The menstruation cycle age in females has gone down due to climate change, our lifestyle wrongs, etc. So there will be a time when this thing will happen. I don't know when, but it will. Why am I mentioning it here? It is just that if you will not educate them, your kids, about these things, time will and people will with wrong information. There are a few suggestions which I would like to mention. Remember, change begins from home. The first suggestion which I want to contribute is that educate your kids about sex. If you will not educate them with the right info, someone else will do with the wrong information. Second, instead of praying us, the ladies, the women, as a deity, just try to give respect to us, our existence. Let's not objectify our things. People again may feel offensive here in our male-dominating society. Our bra is just an inner wear. It is like your vest. We also have a right to dry them under the sun, right? So tell the males that it is just a piece of clothes. It is try not to objectify our things. We often talk and talk and talk. Let's talk and take an initiative this time of bringing in change. I will not take more time, and I will urge all of you to take a pledge. Being a law person, let's take a pledge to educate our kids about these things and talk about sex, periods, etc. openly from them with them. Educate children about the dignity of women and teach them how to respect, and you should make them aware about the law of the land and repercussions of doing a criminal act. In a country like India, where we have books like Kama Sutra and temple like Khajuraho, how can we avoid these kind of discussions? And further, this kind of discussion also decrease the rate of impotency and help people in procreation of children. So knowledge, if good, will make your life. That's what I think. And I will close my presentation here just because of paucity of time. It was a really wonderful opportunity by the IPM. Thank you so much.
Thank you, Ms. Priyanshu. Our next speaker is Ms. Nancy Sharma.
Good morning, ma'am. Good afternoon. Ma'am, I am audible?
Yes, you are.
Good afternoon to one and all present here. I would like to suggest some views on the very relevant topic of today's era, that is sexual harassment at workplace. Sexual harassment. Before we start, we should know the meaning of sexual harassment. Sexual harassment is a want of sexual desire from women. Sexual harassment is a form of sexual behavior which is offensive and unfavorable. At workplace, women are forced by their male colleagues, we can say, by male colleagues about their sexual desire. So, sexual harassment includes variety of things like eve teasing, sexual looks and gestures, sexual unwanted touching, and etc. and many more. If you ask me, every girl should encourage having right to complain against such offences. These offences are widespread in today's era, in nowadays from few decades. It is not compulsory that these offences are verbal, but also they are non-verbal and in written form. So, preserving women from such offences, there is an act of preserving women, that is prevention sexual harassment act 2013, which is also known as POSH Act, Prevention of Sexual Harassment. This act came into existence because of Vishaka guidelines in 2013. After the Vishaka incident, this act passed in both the houses of parliament in 2013, 22nd April 2013. In this act there is a section 14 which includes a committee for disposing such cases, internal complaint committee, ICC. The member of ICC includes a presiding officer, should be a woman at senior level at workplace. If a woman is not there at senior level, so it could be called from another unit or administration. By concluding, I would like to say that this is a social barrier for women, in every field, for their success. So please stand up for there is a humble request from me. Please stand up for yourself, for your justice. Thank you.
Nancy.
Yes, ma'am.
Next, thank you so much, Nancy.
Okay, thank you, ma'am.
Our next speaker is Ms. Navya Rachia, former faculty at IPEM Law Academy.
Am I audible? Ma'am, am I audible?
Yes, ma'am.
Ma'am, please allow for the share screen.
Okay, ma'am.
Okay. Good afternoon, everyone. I'm Navya Rachia, and I'll be dealing with the topic sexual harassment of women at workplace. Now, as Barack Obama has rightly said, people need to show women the respect they deserve and recognize sexual assault and to do their part to stop it. Now, in ancient India, the woman has always held a high respect in the society, as mentioned in the Rig Veda and other scriptures. Volumes can be written about the status of our women and their heroic deeds from the Vedic period to the modern times. But later on, because of social, political, and economic changes, women lost their status and were relegated to the background. Many evil customs and traditions stepped in, which enslaved the women and tied them to the boundaries of the house. Now, sex-related offenses are a universal phenomena which takes place in every part of the society. Sexual offenses aptly take the form of sexual violence, which sometimes cause severe and irreparable damage to the physical and mental health of the victims. Its impact on mental health can be equally serious as that of the physical injury. Now, with the rapid industrialization, economic development, and modernization in various spheres of our society, the employment of women has also increased rapidly. Globalization has led to steady increase in the employment of women in different fields of the organized sector. In India, if we see, the central government and the state government have taken several steps to protect women through enactment of legislation and the prosecution of those who perpetrate violence against women. Thus, there is a need to protect women at workplace. Now, sexual harassment at workplace has remained one of the central concerns of the women's movement in India since the early 80s. Before 1997, women experiencing sexual harassment at work had to lodge a complaint under Section 354 and Section 509. Although now there are certain other things also involved, like the law of 2013 that has been faced. However, that is also not yet enough for the betterment of the women or the condition of the women at the workplace. Now, if we see at the initiatives of the National Commission for Women and National Human Commission, many programs have been organized in collaboration with the government, university departments, and prominent voluntary organizations, which have many outreach programs that provide women information to women, including victims, about the gender roles, human rights of women, social health, legal, economic aspects of violence, etc. Now, if we go for the definition of sexual harassment at workplace, the Supreme Court guidelines have defined sexual harassment, which includes such unwelcome sexually determined behavior as physical contact, demand or request for sexual favors, sexually colored remarks showing pornography, any other unwelcome physical, verbal, or non-verbal conduct of a sexual nature, for example, leering, telling dirty jokes, etc. Coming to the case of Vishaka and others versus state of Rajasthan, is one of the landmark cases in the history of law, we say. Now, it is a case which deals with the evil of sexual harassment of women at her workplace. It is a landmark judgment case in the history of sexual harassment, which are being decided by the Supreme Court. Now, sexual harassment means an uninvited, unwelcome sexual favor or sexual gestures from one gender towards the other gender. It makes the person feel humiliated, offended, and insulted to whom it has been done. In disposing of the writ petition with directions, it was finally held that the fundamental right to carry on an occupation, trade, or profession depends on the availability of safe working environment. The right to life means life with dignity. The primary responsibility for ensuring such safety and dignity through suitable legislation and the creation of a mechanism for its enforcement belongs to the legislature and the executive. When, however, instances of sexual harassment resulting in violations of Article 14, 19, and 21 are brought under Article 32, effective redress requires that some guidelines for the protection of these rights should be laid down to fill the legislative vacuum. Now, there were certain guidelines from this case that I'll go in a little brief. Like the definition has been put forward regarding the sexual harassment. Apart from that, there has been employers or other equivalent authority duty, measures for prevention, appropriate disciplinary action, redressal mechanism, redressal committees, spreading awareness, etc. Now, all these guidelines were formed in this case. These guidelines were framed in order to protect the women at workplaces and provide a secure environment. These were a set of procedural guidelines which are to be used in India and were superseded by the 2013 Act. Now, after 16 years of Vishaka, the sexual harassment of women at workplace was enacted in 2013. This was enacted with the objective to provide protection against sexual harassment of women at workplace and for the prevention and redressal of complaints of sexual harassment and for matter connected therewith or incidental thereto. This act defines sexual harassment as unwelcome acts of behavior, namely physical contact and advances, demand, or request for sexual favors, making sexually colored remarks, any other welcome physical, verbal, or non-verbal conduct of a sexual nature. Now, this act also provides for certain circumstances which may amount to sexual harassment, like implied or explicit promise of preferential treatment in her employment, implied or explicit threat of detrimental treatment in her employment, implied or explicit threat about a present or future employment status, humiliating treatment likely to affect her health or safety. Now, the important feature of this act is that it envisages the setting up of ICC, that is the Internal Complaints Committee, at every office of the organization or institution having more than 10 employees. Where the number is not 10, there has to be a local committee that has to be set up in every district by the district officer. Now, this committee has to complete the inquiry within a period of 90 days. The committee can give certain interim relief to the aggrieved woman during the pendency of the inquiry. The non-compliance of these provisions of the Act by the yes.
Yes, ma'am, please conclude this.
Yes, sure. Now, the Act, this non-compliance of the provisions of the Act by the employer may result in fine, which may extend to 50,000 rupees and can also lead to cancellation of his license or withdrawal or non-renewal. Coming to the conclusion, as we can say, in the present scenario, the violence and the increasing crimes against women is witnessed by everyone across the world in some or the other manner. It indicates the enormity and pensiveness of the monstrosity perpetrated against women in recent years. However, there is an exigency of more strict and stringent laws so that any person intending to commit such crimes couldn't screw up the courage to act in furtherance of his intention. Thank you so much.
Thank you so much, ma'am. Ms. Sangeeta Malik from Modern College of Law.
Ma'am, am I audible? Ma'am, am I audible? Ma'am, am I audible?
Ma'am, you are.
Okay, thank you, ma'am. Ma'am, can you share a screen, please? Ma'am, I'm requesting you to share a screen.
Okay, okay.
Okay, thank you. Is the screen visible? Ma'am, can I start? Ma'am?
Yes, ma'am, you are audible.
Okay, ma'am, thank you. Good afternoon to everyone. My paper deals with sexual harassment of women working in informal sector in India, how law fails them. That's how our law, this POSH Act 2013, has failed the woman, is quite not successful in protecting women who are working in informal sectors. I mean, we all know that there are Vishaka guidelines, but these are mainly for the women working in the formal sector. And then this law was, these Vishaka guidelines, which were formed by the order of Indian Supreme Court in 1997, and they were superseded in 2013 by Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act, which we know as POSH Act, POSH. Pre-1997, we all know there was section 354 of Indian Penal Code 1860 that dealt with the criminal assault of women, of women to outrage women's modesty. And section 509, उसमें हम ये सारे complaints register करते थे, which were like sexual harassment of women at workplace. उसके बाद में then this Bhavri Devi case happened, and there was this Vishakha versus state of Rajasthan. In 1997, then the Supreme Court passed a landmark judgment in the Vishakha case, laying down guidelines to be followed by establishment in dealing with complaint about sexual harassment. Vishakha guidelines were stipulated by the Supreme Court of India. Then in the court decided that the consideration of international convention and norms are significant for the purpose of interpretation of the guarantee of gender equality, right to work with human dignity in Articles 14, 15, 19, 1G and 21 of the Constitution, and the safeguards against sexual harassment implicit therein. Then we proceeded from these guidelines to the act. With the act, which is like Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Then we talk about the women in, but how this act is not able to protect women working in the informal sector from who are the women working in the informal sector? They are like street vendors and factory workers, domestic workers. I mean, there are studies which which say that over 95% of Indian women work in the informal sector, and some work on the seasonal basis, some work on the daily basis, and the others are like permanent workers, but they are still not registered somewhere. So how is the informal sector is defined? Informal sectors can be defined as an enterprise which employs like family members. Then there are employees which employ one or more employees on a continuous basis. Women working in the informal sector, how women work in the what kind of work are available to women in the informal sector? They are construction laborers, most common. We see them almost every day. There are domestic workers, against most common category, and again we have a lot of newspapers reporting that on the harassment of domestic workers. There are garment workers. Again, we have lot of reports which say that women and children are employed in the garment factories, and they are not given they are not even given proper food and remuneration. Then there are street vendors and sales girls, and these are the most common categories of informal sectors of the women working in informal sector. And all of them are like liable to, are very vulnerable to sexual harassment. All these are quite, because they depend on their employer for their job security. How post law fails our women, how this act 2013 act fails to protect women in the informal sector against sexual harassment, because act requires employers to create an internal committee at each office with 10 or more employees. For the establishment with less than 10 employees and for women working in the informal sector, the state government's district officer or collector is required to form a local committee in each district. These committee handles complaint and recommend actions ranging from a written apology to termination of employment, providing an alternative to filing a criminal complaint with the police. But we all know that studies show that many of these local committees simply do not exist, or when they do, there is no publicly available information on how to access these committees. Most women suffer in silence until it becomes unbearable, and then they just try to get another job, or they just leave the job. They do not want to tell their families either because they are afraid, or they will be prevented from working. This is the condition of the women who suffer sexual harassment at the place of working, at workplace. Domestic workers are especially at risk. We all know that for domestic workers, the POSH Act says that local committee must refer the case to the police, leaving no civil remedy. The Indian government should amend the law to ensure that domestic workers have the same access to time-bound justice through the local committees as other workers, Human Rights Watch said. While most private sector companies have internal committees, many exist merely on paper to show compliance without any commitment to improve the workplace culture. Employer do little to fulfill their other duties such as prevention, raising awareness about what constitutes sexual harassment and consequences of such behavior. What is the significance of Violence and Harassment Convention 2019 number 190? The process behind these instruments began in 2015, and with the recent global outcry against violence and harassment, their adoption could not be more timely or more relevant. The convention is strong and practical. Convention number 190 provides a clear framework for action and opportunity to shape a future of work based on dignity and respect, free from violence and harassment. The right of everyone to to a world of work free from violence and harassment has never been before clearly articulated in an international treaty. It also recognizes that such behavior can constitute a human right violation or abuse. International legal obligations. Okay, ma'am. Just give me 2 minutes only. India ratified the United Convention on Elimination of All Forms of Discrimination against Women, which has been interpreted to prohibit sexual harassment of work as a human right violation in 1993. India in June 2019, the International Labour Organization adopted a landmark treaty that establishes the new global standard to prevent and respond to violence and sexual harassment of the in the world of work. The Indian government, representative of government, Indian Workers Group, and representative from Indians employers associations all voted in favor of the convention, but India is yet to ratify the treaty. Then there are the key recommendations. I'm just concluding. Recommendations are like enforce the sexual harassment of women at workplace. This act, including monitoring the creation and effective operation of committees. Publish data on an annual basis on the number of sexual harassment cases filed and resolved by internal and local committees. Ratify and implement the ILO Convention on Violence and Harassment 2019 number 190. Conduct a nationwide audit on local committee and publish the result. Increase cooperation and dialogue with workers, organization, and civil society group to address sexual harassment as a key workplace issue, and partner in information campaigns and reporting on effective enforcement of the law. Thank you very much.
Thank you, ma'am.
Welcome.
Our next speaker of the session is Ms. Poonam Tyagi, research scholar, along with Dr. Mohammad Imran, assistant professor at Shobit University. Ms. Tyagi and Mr. Imran are able to connect with us today, and on behalf of them, Ms. Mridula, student of IPEM Law Academy, will be presenting their paper. I request Mridula to please join the Zoom link.
Oh. Hello.
Yes, Mridula, you're audible.
So, myself Mridula Tripathi, and today I'm here to talk about on a very serious, a very heinous crime, which is sexual harassment of women at work. So, it's a very serious topic. Everyone here, people, professors, have discussed like very overwhelming that how things are going on nowadays on this planet, and it's a very difficult part. So in the context of present time, sexual harassment is very relevant one and all. What is sexual harassment? It is a heinous act committed largely against children and women. This act actually violates the inherent rights of equality illustrated under Article 14, 15 of Indian Constitution, and it directly interferes with the right to life and the right to live with dignity illustrated under Article 21 of the Indian Constitution. If I talk about the statement of the problem, women provide an equally important role in a nation building by enhancing the economic fortune of family, society, and country by supporting in all three fronts like economic, domestic, and emotional health. Hence, workplace should be made a safe and secure environment for her. Because of sexual harassment at workplace, several women's jobs and earnings are affected with influence their social and psychological behavior at workplace. The objective of this study are listed below. If I talk, there are mainly two objectives here. Showcase the reasons that leads to sexual harassment against women at workplace, make some proposals that can prevent sexual harassment against women at workplace, and the basic reasons that why does this sexual harassment occurs or gets conducted by few people by so the first reason here is male dominance. Second is lower job positions. Then the third reason is aggressive nature of male gender. Fourth reason is a belief that women are friendly in nature, which should not be taken in a wrong way. Fifth reason is higher academics with less job opportunities. And if I now here we go with the suggestions and recommendations. Suggestion is every organization, whether it's public or private, should educate their employees about the sexual harassment and its legal outcomes, whether it is suitable. Second suggestion is that several seminars, workshops, and mock drills should be started by the authority this evil of sexual harassment against women at workplace. Third suggestion is that several regarding the job opportunities and promotion law should be reserved for women so that they do not get emotionally dragged and should not be worried about their future. Fourth suggestion is that a committee or grievance cells should be set up internally in every organization, whether it is private or public sector organization, so that the cases against the sexual harassment can be dealt with. Fifth suggestion, the last one, is that several programs should be arranged and organized by all departments in government, public and private sectors to provide legal awareness, which can increase women's awareness regarding their rights and privileges. Coming to the conclusion, in India, the social evil of sexual harassment at workplace still exists today more than ever. Above factors has clearly stated that the sexual harassment, a social evil, in recent years has clearly emerged and is increasing with speed, with the number of cases lodged at organizations who have to deal with these issues. The current situations clearly states the reasons that has caused the increase in the number of cases lodged for sexual harassment against women at workplace. The first point, that is male dominance, should be dealt properly at the work locations by increasing reserving and giving an extra edge during appraisals and other privileges, as it can certainly bring down the number of cases lodged per year for sexual harassment against women. Apart from the second point, that is sexual harassment against the women with higher education background have to go through the sexual harassment by the men in chair. These women feel betrayed and are asked for sexual favors in return of jobs offered. This needs to be dealt with strictly by the organizational authorities. The current study also highlights the data presented by National Crime Records Bureau, which was released by the department in year 2016, and an extensive survey was performed on the cases reported in the report. In summary, we can say that the case against the women in terms of sexual harassment increasing on day by day basis, and there is a lot to be done to reduce these case of sexual harassment against women at workplace. Thank you, everyone.
With this, we end the third technical session of today's e-seminar. We now are moving forward towards the fourth technical session of the event on the sub-theme Rape and Physical Assault. The chairperson of this session is Ms. Sumitra Chaudhary. The speakers of this session are Ms. Garima Bharti of IPEM Law Academy, Mr. Prince Tomar of CCS University, Ms. Diksha Gabriel, academician, and Mr. Bihari Arora of CCS. I request Ms. Sumitra Chaudhary, ma'am, to start the session.
Thank you. I welcome all the participants for this session, and I look forward to hearing your views on the papers that you're presenting today. All the best. We can start with the first participant.
Yes, ma'am. I request Ms. Garma Bharti to kindly start your paper presentation.
Ma'am, please allow me for screen sharing. Am I audible?
Yes, you are.
Ma'am, please allow me for screen sharing.
Are you not getting the option?
No, ma'am.
Just a sec. Admin, can you please help me with this? Is technical help around? If you could just help me with the screen sharing settings of the participant. Thank you.
Yes, ma'am.
Ma'am, whether my screen is clear?
It is visible, yes.
Okay. Very good afternoon to one and all present here. So basically, my subtopic is molestation. Molestation is somehow hidden. Molestation is somehow hidden in our Indian society. Women and children does not came forward because of the word named shame. Now the question arises, what is shame? Shame is the core intense emotional bonding that women experience society even today. Women are accused of causing society their own victimization with common, what did she accept when she dressed like she does? National Crime Bureau represents only those cases which are even registered by the victim, which give only imagine with the number of cases. There are ample number of cases which are not even registered by the victim because of the compulsion behavior of the society and behavior of the law enforcement officer. If we talk about Indian society, its culture, tradition is different and blames a woman. Now my second slide represents what caused molestation. Now the silence question comes that what caused molestation, and the answer is every male does not have proper education, lack of respect for women, fantasies of sexual desire, sadism, gender-based socialization, poverty, failure are the cause of molestation. Suggestions for reducing sexual offenses. Strengthen of laws and implementing them should be done properly. There are several ways in which molestation problem can be removed from a society. Firstly, the meaning of molestation should be taught in school and colleges so that if someone tried to molest them, they can tell to the senior officers. Secondly, Ministry of Home Affairs should impose several guidelines to police department in which female officers should be in civil uniform at public places, whether it's a mall, shopping complex, public transportation, weekly markets. For such kind of efforts, more female officers are required. Posting female officers in such process should require more female police constable, and the duty should be done on the basis of regular, not on weekly basis. A committee should be made at police department under which there must be a senior officer who will supervise and guide them. CCTV cameras should be placed at such places where the culprits can be easily visible. Thirdly, awareness on molestation should be done at lower and higher areas in rural areas because of the word name shame.
people, especially women, does not complain because of the society, and the girl who gives complaint on molestation or any other sexual harassment is being threatened by life. Reason why India is not able to effectively address crime against women: lack of women in national political office. The population of India is 48% female, but women just have only 12% of seats in national legislature. According to the Georgetown Institute, ranking of women well-being, Iceland, Norway, Switzerland, Slovenia, and Spain are some of the safest all countries of women over 30% legislature seats. In New Zealand, where women hold 30% of parliamentary seats and the prime minister is also a woman. Having a woman in government can lead to more and far better laws for the safeguards of women well-being. I would like to suggest that Indian government should have more women in it so that it could protect Indian women by passing comprehensive laws. Now the question arises, impact of sexual abuse on a person. Sexual assault has number of potential consequences that can last a lifetime and generations with a serious adverse effects on health, education, employment, crime, and economic well-being of individual, families, communities, and society. An immediate psychological consequence of child sexual abuse includes shock, fear, anxiety, nervousness, symptoms of post-traumatic stress disorder, confusion, withdrawal. Sexual harassment in childhood is a major risk factor in development of long-term psychological and social problems. I would like to conclude by saying that molestation is heinous crime in this society and somehow it is hidden. One of the biggest problem and after an incident involving sexual harassment or molestation is the act of going to public station and file a complaint. This small steps is which are far bigger is ideally supposed to be gained leave for women. There are many reasons, specifically log kya kahenge syndrome and easy access to bail. Secondly, one of the biggest reason for a woman to keep quiet or to make hide the matter like this, fear of the assault is coming back, and maybe by using more damage, with which could be served as an acid attack in some cases, which have women back from reporting case of abuse. Thirdly, some lengthy legal procedures. The fact that there is a long follow up to the actual complaint filled with many legal procedure. It was make many think twice before filing a complaint, and there is a social stigma attached to someone who does too, irrespective of what they are fighting for. The attitude of the police is often discouraged right at the police station after gathering courage to go and file a case. The police counter questions women about whether they are ready to file a case and deal with, and often discourage them from following up for the same. Thank you.
Thank you, Garima, for finishing this in time and giving a short, crisp, and very focused presentation on this issue of molestation, which is definitely a hidden issue. It is not. It does not come to light very often. As in, we all know that molestation happens, but it is taken very lightly. So, very timely raised point and. I see that you've raised the concern of how lengthy legal procedures and how the attitude of the police is also responsible why women do not raise their voice against this. So that is very correctly pointed out, and thank you for the presentation. We'll move forward with the next participant, please.
The next participant is Mr. Prince Thomas.
Hello.
Yes.
Am I audible?
Yes, Prince, you're audible.
Yes, we can hear you. Please proceed.
Good afternoon, all. Myself, Prince Tomar. I am pursuing BLLB from Chaudhry Charan Singh University, Meerut. Today, I am here to express my view on this topic: molestation, a child sexual abuse, and the onset of puberty. For a long time, child protection has generally been regarded as the subject of professionals who specialized in social health, mental health, and justice system. However, this problem remains a concern for all, and especially the concern of other social scientists, political scientists, social scientists, and people who contribute to the understanding of concepts and strategies in the child protection and the responsibility of adults and institutions that play a role in ensuring the safety and personal care of child under their care. Child abuse, therefore, is when
Prince, please switch on your video.
ma'am, my camera is not working properly.
Okay. Okay, carry on.
Ensuring the safety and personal care of child under their care. Child abuse, therefore, is when harm or threat of harm is made to a child by someone acting in the role of caretaker. It is a worldwide problem with no social, ethic, and racial foundation. Child abuse can be in the form of physical abuse, child to violence or bullying or other degrading practice. All these factors can lead to disruption of a child's normal social and mental development, which leaves the child with physiological scars for life. Finally, child abuse can be in the form of child neglect, where a caring caregiver is unable to provide basic necessities, adequate food, clothing, hygiene, administrative accommodation, supervision, health care, and child support. It is often difficult to detect child abuse unless one has created an environment that will encourage the exposure of the abused child. Nevertheless, a good medical and social history can help uncover the problem. Signs and symptoms of child abuse often include overgrowth, head injuries and dental injuries, tissue injuries such as strokes and marks, burns, and bone injuries such as broken ribs, where there is no history of cause of trauma. The present case report described a child who was abused by a very close relative and who caused physical and physiological trauma to the young lad. According to Obadra, nursery and primary education occupies the first level of education that introduce formal education or literacy to the children. Primary education is the foundation upon which all other levels of education are built. It is therefore imperative to say that the background or foundation of any formal organization of knowledge or education is primarily education. Education occupies a significant position in the development program of any nation. It is the gateway to the future and the key to economic, social, and political advancement of the whole world. Education is an important tool for social and economic mobilization for any person and is a tool for social transformation at the national level. It remains a social process in skills building and social care as it is a tool for acquiring skills, relevant knowledge, and survival practices in a changing world. These have been the main reasons for the introduction of a Am I audible, ma'am?
Yes, yes, please go on.
Am I audible, ma'am?
Yes, we can hear you. Please carry on.
Hello?
You are audible. Yes, you are audible. I can hear you. I think he has left from the meeting.
The next speaker for this session is Ms. Diksha Gabriel. Diksha, please join us.
Diksha, are you here?
Good afternoon, ma'am. Yes, I am.
Yes. Please switch on your video, and if you want to share anything, then you can screen share.
Very good afternoon to all jury members, to all professors and entire people attending the seminar. I'm sorry, I'm outside. I had a working day. So I'll be taking this call from outside. Is it okay if I turn off the video?
Yes, that's fine.
Thank you. So my topic, I've written my paper particularly on the issue of rape. And I'll be reading out my abstract for this entire presentation. And before I start in, I'd just like to highlight one news article that I recently read. Very recently, I think day before or 2 days back, this happened, that where a woman coming back from work was dragged by the cab driver around, I think around MG Road somewhere, and she was taken to a Jhajjar farmland and raped. So this is the kind of terror that currently we are facing. Every day we all talk about empowerment and giving women the right that they deserve, and getting women into the workplaces. But then at the end of the day, when the clock strikes 8 or 8:30, that fear, I think, is installed inside each one of us, that if I don't reach home in time, God knows what's going to happen. So I am a woman, and I don't feel safe to roam about the streets at night or take an early winter morning walk. Why? Why do I have a fear? Why can't I just get up and walk to wherever I want, or whichever time I want to? Why can't I roam around freely without having the fear at this back of my mind? Why do I feel the need to be indoors surrounded by people I know I can trust? Why this insecurity and why this cautiousness? Like I highlighted just in the news before, this cautiousness that is there inside, this is the prime thing that needs to be addressed at this point. It is just because all of us being girls have been brought up by a family narrating tales of harassment and molestation, and we've been warned time and again that something fierce will happen, or that will hurt us or destroy us, and that we need somebody, or we need to take care of ourselves. Why not this choice has been given around to other people, to the other gender around us, that they should also understand? So this is basically the highlight of my entire paper, that this cautiousness, that this fear, that instead of this being installed within us, should also be installed into the lives of the other gender, so that they also respect and understand what we as women go through. The Indian society in particular, in the longest run, has ignored the need to understand and uphold the dignity and uniqueness of women's life. Her esteem in the past have been subdued at the hands of patriarchy, her body objectified, her voice muffled, her consent unidentified, crimes against her unreported, and families forced to keep shut. It was not until recent times that women decided to speak up for themselves and took hold of their own body and underlined consent as an essential factor. A lot of women came up to the front and spoke up about the harassments they have undergone with the dawn of the Me Too movement by Tarana, an American activist who in 2006 indicated the movement. And a decade later, in 2017, this movement took pace and became a tool for women to free themselves of the shame that they have been forced to deserve or forced to go through. If we look at the law has always been on our side. As a woman, I say us because we have so many laws and so many rules out there which are for our own benefit, but the sad point is that not a lot of us know them. So it is the time that we should know our rules and what what benefit the law holds for us, and not just sit back. Like Garima was telling in her presentation, that a lot of molestation just goes unreported. It is because we feel that this has happened because of our mistake, because of what we did, not realizing that this is not our fault. this happened because the other gender chose to take a wrong step that they were not supposed to take. And so we should definitely stand up for ourselves, know our rights, and underline the fact that yes, a woman is not a woman is not somebody you can objectify. A woman is not somebody you can say something to and just walk off. These are the things that we as women should also understand, and thus this sexual harassment will definitely fade away with time. If my paper is entirely about all the rape that has been reported and that has come to points, I have highlighted cases, the Mathura rape case to start with, and I have highlighted the Priyadarshini Matu rape case, and so on and so forth, including all the judgments that have been passed in favor or against. So with that, I come to the end of my presentation, leaving you all with this one note that sexual harassment or sexual offenses against women is not just a topic that only women have to fight for. It is something that we as combined society should work towards. And instead of us installing fear into our little girls, we should also take care and install that fear that if you do something wrong to the woman, the wrong will come back to you as well. That kind of a fear should also be installed in the boys. So yes, thank you so much.
Thank you, Diksha. Do you have any suggestions? As in, do you see there is a way forward to this in terms of some suggestions that you want to present?
A suggestion that I feel should be incorporated at such base levels, we as individuals, say for example, there are a lot of women groups and complaints as working, but mostly what happens is women are the basis. Women don't want to stand for other women. So as a little thing, as a small thing, we as women should now stand up for other women. So agar mujhe aisa kuch lag raha hai ki this is not happening to me, but if it's happening to somebody else, if that person does not have the ability or the strength to go forward and talk for herself, then I as an individual, as a random person, should take up that step and report, so that that I should be the person giving her the strength. So this could work as this could work that I as an individual can stand for some other woman who is unable to stand up for herself.
Got it. Okay. So great point raised, Diksha, that women should support the other women. And the other point that I understood out of your presentation is that you are saying there is a lack at the very basic family level. So family values being instilled in the boys of the family and letting them know at a very preliminary stage, as in very small age, would probably help them also understand. So
Yes.
sometimes what we talk about gender equality, we talk of the same thing, that gender
Yes.
equality cannot be instilled after a person has attained maturity or has gained that age of adulthood. It has to be instilled right from the time the child is born at
Absolutely.
family. So family is the first school where if these kind of values are instilled, then we don't need to train them at a later stage, and they will understand and accept the equality very easily. So good points. Legal awareness is a must, and of course rape victims keep getting victimized again and again by our system at each and every step. Women are being objectified, and I think that is where we need to stop, so that there is an equality that we achieve and we are not looked at as mere objects. So thank you, Diksha. We'll move on with the next participant.
Thank you so much, ma'am.
So the next participant, please.
Good afternoon.
Good afternoon.
Am I audible?
Yes, clearly.
So, myself, Bihari Arora from CCS University, Meerut Department of Legal Studies, and I am going to present my speech on the topic rape, its main causes, and its prevention. So, I would like to thank IPEM University for this event and all their friends who are for their presence. So firstly, I would like to inform all that sexual offense, particularly rape, it is the fastest growing crime. And statistically, every year there is about 5% increase in this crime than the previous year. And in the especially in the lockdown period, there were instances of marital rape even. So now why it is that we are developing in different fields like education, industry, services, etc., but we are failed to become a civilized society, a cultural society who respects women, who respects her wife, brother, mothers, sisters. So I would like to tell some reasons behind it, that we are becoming more educated than the ancient time, but we are transferring to an uncivilized society than the ancient India. So first of all, there are some points like which I want that everyone should take into notice. So first of all, there are 53 provisions which are dealing with the safety of women, which is the maximum which any society can give for the protection of women. But there is sharp increase in the instances of rape every year, and all phases of women, starting from infancy till her death, they are targeted for fulfilling lustrous desires of men. For example, Delhi, which is considered as the rape capital of India, it is really a bitter truth, because even an 8-month-old baby girl, she was allegedly raped by her cousin. And in spite of implementation of POCSO Amendment Act 2019, innocent children are targeted for sexual favors, and insensitivity of Indian judges towards giving justice to victims, as in the case where offenders unzip their pants and hold the hands of the minor girl. It was not considered as a sexual assault, and 50-year-old offender, he was acquitted from the charges uh, of aggravated sexual assault. And this skin to skin theory, I am telling about it right now. So that Bombay High Court judgment, it was, hello, I am audible.
You are audible. Do you want to switch on your camera, please? We can't see you.
Okay. 1 minute, please. Am I visible now?
No, you're not visible. Face the camera towards your side.
Now it is visible.
We can't see you. The camera is on the other
I
side.
don't know how. Okay, wait a minute.
Yeah.
Now it is visible?
Now it is visible, yes.
Okay, thanks. So I was telling about that Bombay High Court judgment, which was overturned by the Supreme Court. So what is the reason behind it? That the access of pornographic sites, the lustrous web content, exciting atmosphere in social media, it fascinates young generation to get an opportunity where they can actually experiment such things, either physically or mentally forcing women. See, sexual urge is a natural urge, but ancient India, the ancient people know how to very well how to suppress that desire by performing spirituality, by meditation, by realizing of one's own existence, expansion of level of consciousness. But today's generation, they don't know how to control their sexual desires. They just want to let that sexual desire to overcome their own mental and emotional feelings. So that's why we are becoming more and more developed, but we are becoming more and more uncultured society because we don't know how to suppress these desires. And one more reason is that about equality, that in in constitution it didn't give the exact meaning of equality, which was very well defined in the Vedas and in ancient India. These days you can also see that in a family system also, the girl child is given less preference as compared with the male child. So what are the reasons behind it? That from our very starting, we are preferring the males. So from these points, I want to picturize how our society is treating women as an object of desires, and instances of rape is continuously increasing. Now, I want to I would like to tell what are the solutions for which, how can we prevent these rapes. See, there are maximum legal protection in India, which any state can give for the protecting women from all sort of offenses. But sexual offense, it is not a legal issue. It is more a social issue, a more morality issue, a ethical issue. See, more laws and breaching the laws, it indicates the uncivilized state, that we are becoming an uncivilized society, not as civilized. So how can India become the civilized society as far as it was in the ancient time? So first of all, see, whenever the feeling of sexual desires, it overcomes an individual, he must know how to get through it by performing spirituality, by by realizing that aham brahmasmi, that was practiced by the ancient philosophers, that God exists nowhere else but it exists inside me, and the morals and ethics, values and ideals of God are inside me, and it is nowhere else. So I must realize that we all are the manifestation of God, and there is no difference between two human beings. Our pains and pleasures are both equal, and we must consider that if we are trying to pain any individual, the same pain will come back to me. And instead of, see, we are copying the Western culture, and their culture is what? Their culture is, we are the owners of the world, we can master everything, we can exploit, we can destroy, we can kill for my own benefit, for my own selfish motive. But what was accepted in Indian culture, we are forgetting our Indian culture, that Indian culture accepted that we need to copy the nature. And copying the nature means, what nature does? Nature believes in the art of giving. We need to give love, we need to give care, we need to respect, we need to perform our duty to every element of this art, instead of only concerning on our rights. So we should imbibe and evolve the characteristics of nature, which was very well accepted by Indian philosophy. So the only way how we can prevent the sexual desires of any individual is to make a society both more moral and ethical. So these moral values of societies can change our society from rape capital like in Delhi to a well civilized society. See, Delhi is most educated, most literate society in the whole India, and even in the whole world. Delhi is considered, but it is considered as the rape capital, which means that it is uncivilized. So we need to teach human beings how to control their desires, how to practice good things, how to realize his power as a human being, push his level of consciousness and realize that if I am inflicting pain, the same will happen with me.
Please conclude.
So, and also that women, yes, I'm going to conclude in a minute.
Yes.
See, women are considered as the creators. Women are considered as the creator because we all have born from the women. So every society has given the maximum respect to the women, but we are going to become a society where we are giving less respect as compared with men to women. So we are the extension of women, so we must respect the most to the women, because so it is expected that the only way out of stopping these sexual offenses of all these offenses is morality, upbringing and virtue transformation. So with this, I want to conclude with the last line, that yatra naryat pujyate tat devta navante, which means God exists in those places which respects women. If we want that divinity and powerful spiritual energy to blossom in our society, we should honor women. If in case of dishonoring or disrespecting women, our all actions, however noble it may be, it will always be remain unfruitful. Thank you.
Thank you, Mr. Arora.
Thank you, ma'am.
Very different perspective that you have given to this issue. that it is not just a legal issue, it is majorly a social issue, a moral
Yes.
and an ethical issue. I completely agree with you on that. The causes that you enumerated, yes, definitely, the society is moving from civilized to uncivilized, from uneducated to educated. So the it is a very reverse kind of a reverse kind of a relationship that the society has entered into. So with education it should have been more civilized, but it has become more uncivilized. And yes, civilized society does not only mean education, but it means the values. It is important that we respect relationships, we respect each other, we respect the genders. Um a lot of causes that you mentioned, I completely agree with. The lustrous web content, easy availability of the internet these days, the unregulated social media content, and drugs is another cause that I want to add to the list of causes that you mentioned. So, thank you for the new perspective. We have been talking about rapes and its causes and its legal solutions, but a very different perspective that I heard is suppressing and having control of your own feelings. That may be a very different approach to this issue of rapes. Thank you.
Thank you so much, ma'am. Thank you for your time and sharing your invaluable thoughts. Thank you for being with us.
Thank you. So the session is come to an end.
Yes, ma'am. Yes, ma'am.
Okay, wonderful. Thank you so much. I really enjoyed listening to all of you.
Thank you. The fifth and the last technical session of today's e-seminar is on the sub-theme, sexual assault. This session was scheduled to be chaired by Dr. Sushmita Malia. However, Dr. Malia is down with COVID and could not connect with us today. We pray for her speedy recovery. The speakers of this session are Dr. Monica Bhardwaj, Assistant Professor, Law School, University of Jammu; Ms. Anusha Agrawal, student of Amity University, Noida; Ms. Aditi Dhamdere of Modern Law College, Pune University; Dr. Sushmita P. Malia, Assistant Professor, and on behalf of her, Ms. Neeraj Nagar, Faculty of IPM Law Academy, will present the paper. Mr. Ashish Kaushik, Assistant Professor, the student Dev Yadav will be presenting his paper. Mohammad Akif Khan of CCS Campus, Mr. Abhay Arya of Institute of Legal Studies, Mr. Harsh Premi of Institute of Legal Studies, Anjum Saxena and Dr. Mohammad Imran, faculties at Shobit University. Their paper will be presented by Ms. Shimani of IPM Law Academy. Dr. Gagandeep Kaur, Assistant Professor at School of Law, University of Petroleum and Energy Studies. Mr. Yash Gupta, student of Institute of Legal Studies. Mr. Abhishek Kumar, former faculty at IPM, and will be presenting his paper along with Ms. Akriti Baksh. Now I request the first speaker's paper to be presented, that is Dr. Monica Bhardwaj. A video will be played for her paper presentation. I request the technical team to kindly play this video. some technical problem with the video. So let us move on to the next speaker of this session. Of Amity University. I request Ms. Anusha to kindly join us.
Am I audible now?
Yes, Anusha, you're audible.
Okay. Ma'am, can you make me the host? I want to share my presentation.
Yes. I request the technical team to kindly make Anusha the co-host.
Yes, good afternoon to one and all present here. I, Anusha Agrawal, student of LLM from Amity University, is going to present my paper on the topic cybersecurity and safety for women. I'll start with the introduction first. In today's era, the world become dependent on technology and become an integral part of human life. Things become meaningless if the technology is not there. But like every coin has two sides, similarly, technological advancement has both sides, positive as well as negative. The technological advancement leads to the threatening of human through cybercrimes, which have affected the people socially and mentally. It can be seen that the open and non-secured internet has created a platform where unseen harm can be done easily and can ruin one's life. Now, what cybercrime actually means? Cybercrime may be defined as any unlawful act where the computer or communication devices or computer network is used to commit or facilitate the commission of a crime. The word cybercrime is not defined by the Information Technological Act 2000. Lately, the wireless systems that may or may not have been protected by passwords have been used to hack computer systems or commit cyber crimes. For example, the Varanasi attack case. The terrorists hacked the Wi-Fi system to trigger the bomb blast. The existing criminal law is traditional law, due to which it seems to be ill-equipped to deal with these upgraded methods of committing a crime. Cybercrime has thus a reality in India as they are difficult to detect, hardly reported, and are difficult to prove. Now, the cyber crimes against women in India. The emergence of technology and the internet in India came late as compared to the world and gave a platform to share their views and information. Cybercrime is most popular in cases of women and made the cyberspace the most vicious place for them. The most common cyber crimes that happened are cyber stalking, cyberbullying, hacking, harassment via mails, etc. By the analysis during the time, it is found that due to lack of literacy, many Indian women are unaware of this alarming threat and didn't know the consequences of it. This makes the offenders use cyberspace for their malicious motives and victimize women for no reason. Now, I want to explain what actually are the reasons for the growth of cyber crimes against women in India. The unawareness regarding internet can be considered a threat in cyberspace. The main victims of this cruelty are women and children. The important information of the internet user can be easily disclosed and used for illegal activities by the people. That's why the reason for the increase in cyber crimes against women can be seen in two ways, and they are the legal reasons and sociological reasons. I'll talk about legal reasons. Cyber crimes are generally created for financial and economic benefits, such as hacking, fraud, email spoofing, etc. But due to lack of awareness, it leads to infringement of their privacy and safety. Most of the cyber crimes are dealt under Section 66, 67, and 72 of the IT Act 2000. Trespassing into one's privacy is very common nowadays, but the IT Act is not sufficient to punish such offenders. That's why the modesty of women and children are protected under provisions of various other laws. Now I'll talk about sociological reasons. The earliest cyber crimes remained unreported by the victims due to hesitation and the lack of redressal machinery.
But at present also, many victims are still unaware of the cybercrime department. Because of this, the offenders continue to threaten and harass the victim in many possible ways. Now, I'll talk about the right to privacy with reference to the Indian Constitution. In the present era, people join the internet to connect themselves globally by sharing pictures, videos, music, etc. But whatever we share affects our privacy directly. The more we share, the more we are close to the risk of infringing our own privacy. The probability of the leakage of information of the user. Protecting privacy isn't something in our hands, but also with whom the user is connected to. Therefore, the infringement of privacy is a violation.
Please conclude your paper now.
What, ma'am?
Could you please wrap up this?
Yeah, ma'am.
Move on to the suggestions and conclusion of the paper.
Yes, ma'am. Yes, ma'am. Okay, so I want to conclude here that the technology has emerged into a widespread necessity. Widespread necessity and is growing day by day. But the governing rules are not efficient to tackle such situation at a vast level. The crime against women is kept on rising in all the fields. Women are made the victims of cruel and traumatic situations, and so as the cybercrime has also done. From the Indian perspective, women are unaware of this bizarre situation, and become the victims of the offenders. Therefore, Indian laws must be enforced in a progressive manner so as to protect victims from cyber crimes. These laws must be stringent and rigid. Furthermore, women must be given the education and advanced learning of the security and the internet concerning their rights and remedies. This will help in reducing the cyber crimes in India. Thank you.
Moving on to the next participant, Ms. Aditi Dhamdere from Modern Law College, Pune University. I request Ms. Dhamdere to join us.
Yes, ma'am, I am there. I want to share the screen.
Yes, Aditi. I request the technical team to kindly make Aditi report so that she can share her screen. Aditi, you can share your screen now.
Yes, ma'am. Ma'am, is it visible? Hello? Ma'am, am I audible?
Yes, Aditi, you're audible.
Is my screen visible?
Yes, yes, the screen is visible.
Okay. Good afternoon, everyone. This is Aditi Dhamdere from Modern Law College, Pune, and I'll be presenting the paper on sexual offences against women, and the sub-theme is eve teasing. At first, we all should know what is eve teasing. Eve teasing refers to the public sexual harassment to a girl or a woman by a boy or a man. It is very common in India these days, and it includes whistling, lewd remarks, and wrong sexual contact. It is being treated as a serious problem and brutal violation of the human rights. Students of school and colleges and even the working women of growing age are not able to save themselves by any means from the terrific strike of it. This uncontrolled criminal action has become a normal thing in our daily life. The aim and objective of my research paper is to understand an experience of eve teasing by the adolescent girls, to know the psychological effect and impact of eve teasing on the young adolescent girls, to analyze the causes of eve teasing which are prevailing in the society, to promote the effective prevention and to increase the public's knowledge. The scope of research is to highlight the problem of eve teasing which the young adolescent girls face and they become the victim of this. Through this research, an effort has been made to highlight the various aspects of this issue. Moving on to the causes of eve teasing, the main causes of eve teasing are wrong mindset, which the male patriarchal society hold in their mind, the male dominant society, the modernization, the terrible effect of electronic and social media, lack of security for women, absence of punishment. There are not very so serious punishment for the crime of eve teasing, and the lack of family control on young boys. So these are the main causes behind the eve teasing. Then moving on to the impacts of eve teasing. Early marriage. The girls they get very early marriage at a young age due to this eve teasing problem sometimes, and especially in the rural areas. They even get dropped out from school and colleges. Some girls even commit suicide, and they had a very bad psychological impact in their young and innocent minds. Moving on to the ways to prevent eve teasing. Self-defense. Girls should learn judo karate for their self-defense. They should stay alert even when they are walking in the public area. And they should carry a safety weapon with themselves, such as small knife or the pepper spray or something. And they should learn the body language of the other person. Very easily we can come to know, and keep emergency contacts on speed dial like of your parents or very close friend or something. Then the constitutional provisions for women, which gives protections to the women. Article 14, 15, 16, 39, subclause D and 42. I will not explain these in details because we already are aware of these articles. Then provisions under IPC which protect women. Section 376 for rape, Section 363 to 373 of IPC for kidnapping and abduction, Section 302, 304B of IPC for the death due to dowry, and Dowry Prohibition Act is also there, and for torture and cruelty by husband and his relatives, Section 498A of IPC is there. For molestation, Section 354. For sexual harassment, Section 509 of IPC, and for importation of girls, Section 366B of IPC. Now some suggestions. Awareness. Awareness should be done, and mindset of the society needs to be changed for this perspective, and media should play a positive role. Moving on to the conclusion, it is increasing at a very alarming rate in our country. We need to take a necessary step to prevent eve teasing from the root, and proper laws should be made to stop this kind of harassment. Proper education must be imparted in girls and even in their parents, and this should be imparted in schools, colleges, and government must take some measures to curb this menace. Thank you.
Presented by Dr. Sushmita P. Malia, the Faculty of Law, Delhi University. On behalf of Ms. Neeraj Nagar, she will present the paper. I request Ms. Neeraj Nagar ma'am to kindly come on the stage and present her paper.
Thank you so much, ma'am, for providing me the opportunity to share a few words on trafficking of women. Human trafficking remains as a part of socio-economic offense and generally considered as a sexual humanity. Trafficking of women and adolescent girls, child, and its related to regulatory mechanisms has always been remained matter of interest in the debate and discussions in the social media. Many policies have been designed to combat and prevent the heinous social evils at national and international levels. However, the objectives of policies formulated in this regard hardly fulfill the expectations of practiced women, and lack of understanding of impact this crime is in their lives and society. In India, the legislation on the Immoral Trafficking Prevention Act, that is IPPA 1956, majorly focuses on prostitution of women and is silent on trafficking for sexual offense. COVID-19 pandemic might have increased the rate of trafficking of women and young girls for cheap labor work in different sectors, which got affected by the economic slowdown. It is to be noted that it is a complex crime of cross-border nature, which calls for the coordinated, multidisciplinary national and international responses. The paper will be discussing some of the issues emerging in the area of highlighting the lacuna and its existing legislative framework in India. Women are most vulnerable in trafficking due to the socio-cultural as well as economic circumstances prevailing in our country, where gender-based discrimination is there. Globalization added to the new dissemination. It also encouraged sex industry to flourish and point out the trafficking is not confined only to the sexual exploitation, but also to the branch as and making it the decent job education by organizing criminal networks. Some of them are sold by parents, husbands, and for making money and forced to sex trade. Few cases are there in Vishal Jeet versus Union of India. The apex court held pointed out and said that the appropriate government should ensure care, protection, development, treatment, and required rehabilitative measures for the victims of commercial sexual exploitation and directed the government to appoint the trained personal rehabilitation home. In Gaurav Jain versus Union of India, the apex court observed that state has a duty to rescue, rehabilitate the women and enable them to lead a life with dignity. However, its functioning remains in the papers and fails to address the real issues faced by trafficking women. At last, I would conclude with the statement that a stricter executive machinery therefore is required to cope up with the situation. Thank you so much.
Thank you, ma'am. Our next presenter is Mr. Ashish Kaushik, Assistant Professor at Institute of Legal Studies. The student Dev Yadav will present his paper. I
Yes,
will
ma'am.
kindly join us.
Ma'am, am I audible? Ma'am, am I audible?
Yes, Dev, you're audible.
Good afternoon, everyone present here. Myself, Dev Yadav. On the behalf of Mr. Ashish Kaushik, Assistant Professor, Institute of Legal Studies, CCS University, Meerut, I am presenting his paper titled Legal Terrorism, a Critical Analysis of Section 498A of IPC 1860. The status of woman refers to the position of woman in our society, together with the right and obligation, various roles she performs in our society as daughter, wife, mother, and career-oriented woman. In India, marriage is seen as a social institution. However, the problem arises when there is a demand of dowry on the part of husband and his relative. We heard or see many the situation of the married women who are harassed by the family of a husband for dowry. Central government has created a law to shield the woman from the ill effect of dowry. Dowry Prohibition Act was 1961 was launched to protect women and add a new section of 498A of Indian Penal Code came in force. Section 498A states that whoever bring the husband or the relative of a husband subject to such woman to cruelty will be punished for imprisonment for term which may extend to 3 years and shall also be liable for fine. So, what are the ingredients for this section of 498A of Indian Penal Code? Section 498A is the only section in the Penal Code 1860 that recognized domestic violence against women as a crime. Insertion of Section 498A was done with the idea of curbing cruelty against married women by her husband and in-laws. For commission of an offence under Section 498A, following necessary ingredients required to be satisfied. First, the woman must be married. Second, she must be subjected to cruelty or harassment. C. Such cruelty or harassment must have been shown either by husband of the woman or by the relative of her husband. So, now what does the cruelty mean? Cruelty is a wide term which include inflicting physical or mental harm to the body or health of a woman, including the acts of harassment. It was held in the Kalli Perumal versus State of Tamil Nadu that cruelty is a common essential in offences under Section 304B and 498A. There are various kinds of cruelty covered in this section. For cruelty by vexatious litigation, by deprivation, by persistent demand, by extramarital relation, for non-dowry demand, and taking away children also includes the under the cruelty. So now the constitutional validity of Section 498A. In the case of Inder Raj Malik versus Sunita Malik, it was contended that this section is ultra virus in Article 14 and Article 22 of the Constitution. There is a Dowry Prohibition Act which also deals with similar types of cases, but therefore both statutes together create a situation commonly known as double jeopardy. But Delhi High Court negated this contention and held that this section does not create for double jeopardy. Section 498 is distinguishable from Section 4 of the Dowry Prohibition Act because in the latter mere demand of dowry is punishable and existence of element of cruelty is not necessary, whereas Section 498A deals with aggravated form of the offense. It punishes such demand of property or valuable security from the wife or her relatives as are coupled with the cruelty to her. Hence, a person can be prosecuted in respect of both the offenses punishable under Section 4 of Dowry Prohibition Act.
Yadu, can you please wrap up your paper, please?
Okay, ma'am. This section give by discretion to the court in the matter of interpretation of the word. Conclusion: Supreme Court calls the Section 498 as a legal terrorism. The misuse or abuse of the law is mostly done by urban and educated women. Also, in most of the cases, the husband and two of his relatives are prosecuted. A violation of this section, its goal and its aim is on the rise with the women making false allegations against their husband within the purpose of getting rid of them or simply hurting the family. Thank you, ma'am.
Thank you, Dave. The next paper is presented by Mohammed Akif Khan of CPS campus. I request Mr. Khan to kindly join us and present his paper.
Good afternoon, ma'am. Myself, Mohammad Akif Khan, student Institute of Legal Studies, CCSU Merit, and I am here to present my paper on the topic stalking and unexplored form of violence against women in India. Meaning and definition of stalking. Stalking is defined in the Indian Penal Code under Section 354D, but firstly, it can be understood through continuous and repeated following someone.
Switch on your camera.
Yes, sir. Continuous and repeated following someone with ill intention of harming or causing fear to the person. Following is said to be stalking, a crime of engaging in a course of conduct directed at a person that serves no legitimate purpose and seriously alarms, annoys, or intimidates that person. The crime of illegality following and watching someone over a period of time. Stalking in India. Before the modification in criminal laws, there was no direct inclusion of the term stalking in penal law of Asian nation. The stalking was quoted below category of merely harassment like prevention, molestation against women, and it fully was quoted below Section 354 and Section 509 for victimization, words or gestures to insult a woman's modesty,
Because of the shortcomings at the intervals, the requirements of 354 and the section 509 of IPC, in most of the cases, the wrongdoer moves freely from the court as a result of its exhausting to prove the certain essential condition to present a crime. The attack must be against a woman. The offender must be use excessive force. The modesty of women should be offended. Therefore, it was needed for emergence of the separate law for stalking in India. The act of stalking, as of today, after the Criminal Amendment Act 2013, is a cognizable, bailment and non-compoundment offence with punishment up to 3 years and fine for the first convention. Secondly, up to 5 years and fine for the repetition. According to the section 354D of the IPC, stalking means and includes any man who follows a woman, contacts or attempts to contact such woman to foster personal interaction repeatedly despite a clear indication of disinterest by such woman. Second, monitors the.
Tell us the conclusion of the paper and the suggestions
Yes,
that
ma'am.
you have written there.
Yes, ma'am. Conclusion. In India, stalking is incredibly common and might either be done physically or through electronic medium in several modes, as detailed on top of that constitute to a criminal offense with associate imprisonment of minimum 3 years. In India, the operating skill students, homemaker, and plenty of girls get pendiculate on regular basis while not even knowing and not solely to the women, however, conjointly the men. And stalking and harassing isn't treated as a serious crime, and thanks to the concern of the being pendulate, many ladies avoid 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 opening out of their house so as to avoid stalking and attracting unwanted distress. The ladies care measure forced to decorate therefore known as modesty and to colleagues, neighbors, and alternative persons so that they don't attract unwanted attention even once the 73 years of Indian woman case measure is still caged. I have done.
Thank you, Mr. Khan. The next paper is presented by Mr. Abhay Arya from Institute of Legal Studies. I request Mr. Arya to kindly join us and present his paper.
Good afternoon, everyone. Myself, Abhay Arya from CCS campus, and today my topic on in this seminar is trafficking of women and childrens.
Mr. Arya, please click on your camera.
Yes, ma'am. Ma'am, am I visible? Hello.
Yes, yes, Mr. Arya.
Okay, ma'am. Ma'am, the United Nations defines human trafficking as a form of employment. In ancient times, there was a widespread practice called bonded labor or slaves. It involves transferring or moving people from one country to another with or without their permissions. It can be done by using force, coercion, or improper influences or intimidations. It for the purpose of exploitation or forced labor. The perpetrator of this process is known as traffickers. According to statistics, human trafficking in India could affect between 20 millions and 65 millions people. Women and girls are trafficked into the country for the purpose of sexual exploitation and forced marriage, especially for those places where gender equality is popular with men. In Vishaljeet versus Union of India, Supreme Court issues direction that all state government must direct their law enforcing authorities to take appropriate speedy steps against the evil, and directed to set up advisory committee with experts from all fields to make suggestions regarding measures for child prosecutions, for care and rehabilitation of rescued girls, for setting up of rehabilitations home, and for a survey of the jogging traditions. Furtherly, the victims in organ trafficking here in sexually active and without a difference in their age. It includes a person from a young child to an adult and even to dead pupils. It may or may not be without their consent. When a person is abducted or taken from his place without their knowledge, in some hospital, that will make a person believes that he has a certain diseases regarding anything.
All right, I think there's some technical issue. So let us move on to the next paper presenter, that is Mr. Harsh Premi from Institute of Legal Studies. I request Mr. Premi to kindly join us and present his paper.
Thank you, ma'am. Good afternoon, everyone. Present here myself, Harsh Premi, Institute of Legal Studies, CCS University Campus, Meerut, here to present my paper on the topic, if teaching a serious crime. Sexual harassment includes non-verbal, verbal, physical, or visual care or intimidation, coercion that unwelcome and unwanted, and infrequency includes a negative impact on the psychology health of the victim. Will the term if teaching in utilized in India legal code prohibits conduct such a ridicule in section 294 prohibits.
Mr. Premi, I request you to kindly switch on the camera.
Ma'am, camera is not working.
All right, think on it.
Section 294 prohibits making a woman or a woman a victim of sexual misconduct. Committing songs represents for UP2 their 3 months in prison in described by God as a moral code that is considered to be an insult and a dec- degrading act of feminism. If teaching in simply on in all may creates of rural Punjab woman participant described situation where present blockade girls in the house to protect them from sexual violence and in association relationship with boys or men. As a result, participants describe recurrence in the domestic sector due to technology, employment, and community service. Causes of Eve teaching, wrong mindset, modernization, fun, lack of security for girls, absence of punishment, bad impact of electronic and social media, family control, impact, early marriage, Eve teaching for the parents to do early marriage of girls, they need fear for their social status. Rather than opening to Eve teaching, they need to run away from the matter. To say choice option of early marriage of girl, as we know that the first marriage invests physical, mental, and health problems. Dropout on the reason behind the dropout of women from school Eve teaching. The happiness mostly in rural area. However, different studies suggest that drop out rate among girls increase with the increase of age. It is very natural the oldest wrote about the safety of the girls after they feel that their girls' safety is under threat by eve teaching. They create alternative thinking and like to stop education of their girls and confine them inside the house. Suicide. Mal suicide. There are some cases of suicide because of eve teaching. When girls face the eve teaching and they disclose the matter with loved and the parent blames to victim instead of teacher. Parents may have threats about the troubles regarding to the wedding proposal of the girls. In such situation, girls may attempt the suicide. Psycho- Psychological impact if teaching result into increase in disorder like anxiety and depression. Many something they are doing not get support from family due to mistrust of these causes and frustration ladies many girls towards committing suicide. If teaching causes different upliftment situation to women at individual and social level. Thank you.
Thank you, Harsh. It is indeed a very good issue that you've raised and shared with us regarding the increasing number of female students dropout. The next paper presentation is by Ms. Anjum Saxena and Dr. Mohammad Imran, faculties at Shobit University. Their paper will be presented by Ms. Shivani, student of IPM Law Academy. Ms. Shivani, I request you to join us and present their paper.
Am I audible, ma'am?
Yes, Shivani, you're audible.
Okay, good afternoon, everyone. Myself Shivani from IPM Law Academy. Here I am presenting the paper on behalf of Ms. Anjum Saxena, ma'am. The paper title is Cyber Stalking and Analyzing in Relation to Sexual Harassment and the Indecent Behavior. So let's start. In our changing world of the technology, use of the internet has penetrated every aspect of a human's life. It is pretty obvious that the technology has actually made easy as in communication is easy transferring data has become as simple as clicking a touchpad on a laptop or a simple tap on a mobile phone. What was once thought to be an impossible task had become a regular work for many. Technology has ascended boundaries, has crossed ocean penetrated continents, and made the world connected like none of the humans' invention has been ever able to achieve. We are living a seamless life thanks to technology, but like any other superpower, there are two sides to it, boon and a bane. We have already discussed the boon. Let's cover up the bane. Ever-spreading use of technology has made women susceptible to cyber crimes, or simply said, in the world of the technology, women are vulnerable to cyber crimes. 4 billion of the world population is online today, which is about half of the population the world. This has created a unique problem, commonly known as the cyber stalking. What is cyber stalking? Cyber stalking is a constant attempt by one person to contact another. The one commenting or attempting to connect is often known as the perpetrator, who using online or social network to stalk its prey. It causes immense psychological damage to receive or the prey. Nature of the such communication is often abusive of the obscene, although it could be direct. The author of the research paper had made a conscious decision to deal with this newly coined phenomenon known as the cyber stalking. Tools of cyber stalking can be either of the following: spamming, obscene messages, inappropriate behavior, hacking or tracing another person's online footprint. Due to lack of the social awareness, the receiver of the such attack is often with a permanent mental scares that could have to be depression and the sense of the victimization. India, being a developing nation, has a lot to catch up with the sense of develop in terms of the check and bounces measure legislature and social aptitude to understand the negative impact of the internet and the privacy cyber stalking. Now social networks have come up with the features where one can raise the issue of cyberbullying found by the accused. One can also ask the platform to block such evil minds. Social media has come up with a certain programs which can be creating awareness among internet users. India has a dedicated legislation which act as a countermeasure to such cyber evils. The legislation is known as the Information Technology Act, which should be read with the advent of the technology. People with the evil bent of the mind are prone to use internet as a tool to commit harm against the vulnerable of the for primarily these reasons. Firstly, to satisfy psychological needs. Secondly, for dominating. Thirdly, motivated by revenge. And fourthly, motivated to fulfill the need of fake relation with victims. That's it from myself. Thank you so much.
Okay, thank you so much. So now moving on to the next presenter of this session, that is Dr. Gagandeep Kaur, Assistant Professor at School of Law, University of Petroleum and Energy Studies. Ma'am, please join us and present your paper.
Am I audible?
Yes, ma'am.
A very good afternoon to all of you. My topic for the presentation is cyber stalking as a new tool and in a new era of stalking and legal implications in India. So the era of information and communication technology has actually changed the entire spectrum of it has chosen the nation. However, there is a dark side also. And the dark side is that where cyber stalking has taken a prominent role nowadays. Now, the problem is that the cyber stalking, talking in a digital, so there is lots and lots of comparison in the consequences, because when there is a cyber stalking in digital world, it has more serious effect on the mind of the victim, because it is occurred cross borders, and there are so much anonymity that is involved over there. Now so many people are in our contact list, and we are not aware that who is that particular person who is targeting us in that particular context. Now it has become a new way of online harassment, and I have mentioned in my paper so many recent case laws where cyber stalking occurred and the decisions came. So I will not repeat those cases over here. But I will just highlight that in India, there are many laws for the protection of women. But the problem is that even IT Act does not punishes it specifically. It punishes cyber stalking, but that is indirectly under Section 66E, that is fundamental right to privacy. There was Section 66A, but all of us, we are aware that it has been declared unconstitutional in Shreya single case. So as such, we do not have direct and clear-cut provisions for punishing this particular offense. So I just want to conclude by saying that laws are still there and amendments will come. Laws will be made more strict. That is not a solution. So the solution lies in the fact that we, the women, we need to become cyber smart women. We need to know about all the security parameters that we can take and how to secure ourselves in internet. So thank you so much.
Thank you, ma'am. A very good point indeed regarding the cyber safari. The next presenter is Mr. Yash Gupta from Institute of Legal Studies. I request Mr. Gupta to kindly join us and present his paper. I I request Mr. Gupta to kindly join us. All right. Moving on to the next presenter of this session, Mr. Abhishek Kumar, former faculty at IPEM, and Ms. Akriti Daksh. I request both the paper presenters to join us and present their paper. Sir, ma'am, I request you to kindly switch on the camera.
Hello.
Yes.
Ma'am, the presentation would be done by Abhishek Kumar himself, and I would be doing the conclusion part. So I would ask Abhishek to just come online.
Hello.
Yes. Sir, please come online.
Hello, Akriti.
Yes.
Please present your paper.
आवाज आ रही है मेरी?
Yes, sir.
हेलो, आवाज आ रही है मेरी?
Yes, sir, you're audible to us.
क्या स्टार्ट यार? हेलो, हेलो, आवाज आ रही है मेरी सभी को?
Abhishek, sir, you're audible to us.
हेलो,
I think there is some technical problem.
मैम,
Able to connect.
हेलो, हेलो मैम, आवाज आ रही है आपको मेरी?
Yes, sir. You're audible.
हेलो, एक्सक्यूज मैम, आवाज क्लियर है मेरी?
I think there's some technical problem. May I request Ms. Akriti to conclude and give an idea
Hello.
of the paper?
Yes, very sure. Thank you for everyone to come over here. The topic of the presentation is major causes of human trafficking and how it affects women. So the main idea of the paper was to highlight the causes which has marked the increase in the cases of human trafficking. As we all know, there are various amount of conventions and treaties all over the world. And this is indeed a transnational crime which cannot be confined into a state. So the state laws are very much not effective to deal with it. So what we did was to analyze the different causes of it and then suggest something which could be applicable to all the causes. So as we know, human trafficking refers to trade or bargain of individuals, which relates to their exploitation. So as we all know, am I audible?
एक्सक्यूज मी, आवाज आ रही है सभी को? Can I start my presentation?
Yes, sir, you're audible.
Okay, ma'am, my name is Abhishek Kumar. my topic is major causes of human trafficking and how it affects women. सबसे पहले हम इसका हिंदी में एक बार देखें तो ह्यूमन ट्रैफिक का मतलब होता है जहां पर हम ह्यूमनों को बेचा जाता है और इकोनॉमिक गेन के लिए, जहां पर उनका एक्सप्लॉयटेशन किया जाता है डिफरेंट तरीकों से। और मैं इसका हेलो हेलो जहां पर ह्यूमन को बेचा जाता है डिफरेंट तरीके से। इसमें मैन वुमेन चिल्ड्रन सभी लोग आ जाते हैं, डिफरेंट तरीकों से इन्हें लोगों को देखा जाता है और इनका पर्पस भी अलग अलग तरीके से किया जा सकता है, जैसे सेक्सुअल के लिए, बार्गिंग के लिए, बैगिंग के लिए और ये डिफरेंट और ऑर्गन ट्रैफिक के लिए। जहां पर ज्यादा बेनिफिट होता है ये लोग उसी के लिए वहां पर बेच दिया जाता है और इसका पूरे के पूरे इस तरह से ह्यूमन इंडिविजुअल की लाइफ, पूरी डिग्निटी और उसकी मोरलिटी पूरी की पूरी ये लोग खत्म कर देते हैं। इसके बाद ये लोग उसके बाद अगर इनके हम टाइप्स देखें तो ये डिफरेंट तरीकों पे से कराया जाता है इनका ट्रैफिकिंग। जैसे सेक्सुअली इनका ट्रैफिकिंग ले तो सेक्सुअली में ये लोग वुमेन और गर्ल्स को स्पेशली किडनैप करते हैं और अलग अलग जगहों पर देखते हैं। एक रिपोर्ट आई थी इंटरनेशनल लेबर ऑर्गेनाइजेशन एंड वर्क फ्री और फाउंडेशन, ये 2016 का सर्वे था और 2017 में पब्लिश हुआ। इसके अकॉर्डिंग 40.3 मिलियन पीपल्स और ट्रैफिक्ड हुए हैं और हमारे इंडिया में ही लें तो पूरे 2 लाख पीपल एवरेज हमारे इंडिया में एग्जिस्ट है और ये अलग अलग तरीके से इस्तेमाल किए जाते हैं। इसके बाद अगर हमारा एक प्रज्वाला रिपोर्ट की है, प्रज्वाला एक फाउंडेशन है जो एनजीओ की तरह है, जो पूरी ट्रैफिकिंग के ऊपर पूरा रिसर्च किया जाता है। पूरा ट्रैफिकिंग। हेलो, आवाज आ रही थी? आप आवाज आ रही है? हेलो
Sir, since we're running short of time, kindly conclude your paper.
जी हेलो
Sir, I request you to kindly conclude your paper.
कंक्लूड।
Yes, sir.
Yes, sure. Thank you. So the conclusion and suggestions, what we want to give is that that we all know that there is a lack of contentment and the understanding of the subject and not the information. We all know about the laws and we all know about the intricacies of the offense. So what we need to do is do more research, more groundwork on the topic, and more empirical research would obviously help the public authorities to deal with this topic very minutely. And the other thing is that we need to improve victimology so that the psychological impacts of the offense of human trafficking should be dealt in with very carefully, because we all know that there are various children who are sexually exploited also. So there needs to be a sensitization on that aspect of this offense. Thank you for your time.
Thank you so much, ma'am. With this, we end all the sessions of today's event. The event has reached its final stage, and for the valedictory session, I would like to invite Professor Dr. V.P. Singh Sehgal, sir, to welcome our guests for the valedictory lecture. The valedictory address will be given by Dr. Seema Singh, ma'am, and Sehgal sir will be welcoming.
afternoon, everyone. We are coming to the final stage of the seminar. Good afternoon, ladies and gentlemen. We are now coming to the final stage of the seminar, that is the concluding session. We had a very active day. We received about 51 papers, and most of the papers have been published. The quality of the papers was quite good one. The seminar started with a keynote address by Professor S. Srivastava from San Francisco, and the inaugural address was given by former Dean of German Media Studies, who presentation. These two addresses laid down the key which were to be discussed in the following session. It was really a pleasure to listen to Professor Srivastava and Professor Mandela. There were many queries also. Mandela was addressed in some of the which he addressed in a very fine manner, and the participants were highly satisfied. We also had some eminent speakers in the following session. We also deliberated on various themes of the topic, including Dr. Colonel Mahendra Jamsha from Nepal Army, from Kathmandu, then Professor Muhammad Ali from Rajshahi University, Bangladesh, then Dr. Seema Sharma, who is going to deliver the valedictory address just now, and then Tarannam, Dr. Tarannam and Sumitra Chaudhary. Dr. Tarannam is a women activist working in Canada, and she wrote a paper in collaboration with Ms. Chaudhary. It was very informative, and good data was supplied in this paper. Thereafter, technical sessions were started, where all the participants they presented their views on various themes of the seminar. It was quite academic free, and everyone enjoyed. I'm grateful to my faculty members who made all of this to make this program very successful. It was a pleasure to see that in this digital era, we had participants from various parts of the globe. One person was chairing the session from USA. The participants were also from different parts of the country and other countries also. So we have among us Seema Singh, a women activist and prolific writer on the women issue, and who would like and request to summarize the proceedings of the seminar and show light on this burning issue of the seminar. So I welcome Dr. Seema Singh and request her to address the participants who are online from various parts of the country and from abroad also. Thank you very much.
Thank you so much, Sehgal sir. I hope I am audible to all of you. There is some technical issues because of which I am not able to join from my system. Am I audible?
Yes, ma'am, you're audible.
Okay, then should I speak now or because I'm not very clearly, I'm not able to listen very clearly what you people are saying.
Now I request you to kindly click on the camera. I request Dr. Seema Singh ma'am to kindly connect with us on Zoom.
Thank you so much. Thank you. I'm sorry, there is some connectivity issue, so I was not able to hear very clearly. First of all, I would like to congratulate Professor Saigal, Professor Malhotra, and their entire team, all the learned members of IPM, for organizing such a successful international webinar on such a relevant topic, which is basically sexual violence against women. Obviously, this is something which is very relevant because it is talking, or it is dealing with almost 50% population of the entire world. And the issue is more serious because the women are facing different kind of problems, different kind of discrimination, different kind of violences, not only in India but across the globe. We have discussed so many things since morning, and obviously we have identified several problems which women are facing, problems which basically women are facing in different forms, like discrimination in family as well as at the workplace. They are victim of different kind of sexual violences and sexual harassment. They are the victim of malnutrition. They are the victim of sexual and emotional violences. They are still fighting for basic right of dignity and equality. And there are hundreds of international conventions and laws to protect them from all kind of ill treatment and discrimination, but still they are far away from the desired destination. So there are so many things which are basically going on, but at the end of any seminar, our duty is basically to come up with certain solution. I am wondering that most of the time we are not trying to analyze the reason that when so many international conventions are there, so many legislation within a country like India are there, dealing with the problem and rights of the women, then too why they are being discriminated. What I personally believe that we are not able to handle or tackle the basic reason because of which the women are going to face different kind of discrimination. As I told in my earlier address also, that once a girl child comes into the womb of a mother, from there till the end of her last breath, she is protected completely by different kind of legislation, but the responsibility of society towards a girl child, towards a married woman, or towards a woman, where the society is not ready to take up the responsibility. And this is something which is quite challenging, and we should all think very seriously about it. The second issue which we are discussing since morning continuously is the causes, the reason behind different kind of violences against women. Perhaps we have made laws, but we are not able to align ourselves according to the laws of the nature. You know, equality is a term which is very much celebrated. Equality is a term which is used very often in all kind of international or domestic legislation. But once we talk about defining the equality, perhaps we are not able to understand what is the real meaning of equality. Once you ask this question to anyone, either they will give the Dicey's theory, or they will say the absence of discrimination means equality. But the issue is, once you are trying to define equality, I am talking specifically about the gender equality, then none of able to give any appropriate answer. Why I am talking about the natural law of justice? Because once we read the laws of the nature basically works upon the theory of consciousness. And theory of consciousness is the basis of any legislation. You know, once we try to understand the development of law, which basically we are not discussing, one very important aspect of law is spirituality. Law has basically evolved from spirituality, and spirituality is something which connects each and every individual with the nature. Spirituality is all about the expansion of one's consciousness. Once I am saying or using the term consciousness, it means once somebody is going to elevate its spiritual quotient, then he will never discriminate between two individuals. And this was the basis of the evolution of the theory or the democracy of spirituality in India. There is no difference between me and you. What is the present problem in the entire world? The present problem in the entire world is when we talk about the patriarchal mindset. Why they want to discriminate against women, why they want to dominate women, why they want to cause different kind of violences against women, because they feel that their consciousness never realizes or never accept the existence of a woman at par to the existence of a man, and that is the main major problem. And the issue is when we are talking about the different kind of problem, one another important thing which we are missing, we are not talking about the corrective measures. Like few hours back I was discussing the reproductive jurisprudence, or the reproductive rights of women, and I mentioned certain judgments which are very important. You see how the law is going to affect the society. Once we talk about, even if we talk about the IPC, in original IPC, nothing like dowry, death, and cruelty is prescribed. It was subsequently added in the mid 80s. So what it means? It means whether at that point of time when the Britishers enacted IPC, dowry deaths were not there, the cases of dowry were not reported, or they were the part of the social structure in some different form, like in the form of stridhan. So when our society started deteriorating, this is something which is very much important to ascertain the reason behind rising crimes against women. Again and again, because I have analyzed and tried to analyze these things very deeply, and I came to know about certain things which is my personal understanding. One very important thing is obviously globalization is a reason. We created a society post industrial revolution which is totally money centric, so money is becoming the most important thing, because we are going to evaluate everything in terms of money. So we are not able to realize the importance of a woman which she is contributing in a family in the form of mother, or in the form of the sister, or in any other form, because we now started converting everything into the monetary terms. So if a woman is participating or contributing in terms of some kind of financial assistance, definitely she is more respected. But if she is not earning, then she is not receiving that kind of respect. And this is the reason, once we talk about the liberalization of women, or the empowerment of the women, her economic empowerment becomes very crucial thing to decide her repute or decide her place in a particular family. And that's why once we talk about the feminist jurisprudence, because I'm constantly writing upon it also, the concept of feminist jurisprudence, which we are basically copying from the Western countries. There, the meaning of feminist jurisprudence is you are going to create a contrast from the male. So what is actually happening there? In the name of equality, are we going to create another kind of discrimination? The problem which the Indian society is presently facing right now, we are not only adopting foreign laws, but we are adopting foreign interpretations also. In any society, family is the smallest unit, but the way the laws are going to be interpreted, our family system is going to face a very, very serious setback. I discussed the case of Notej Singh Johar, and I also discussed the case of Joseph Shine. And in the case of Joseph Shine, instead of saying that the woman must also get right to file a complaint against her husband if he is involved into extramarital affair, the vice versa thing was decided by the Supreme Court. So the Supreme Court is started promoting and identifying sexual autonomy or sexual privacy, which is in our mind that India is a country which is the originator of the family system, which is the originator of the marriage as an institution. But now the entire things are changing, because money has become more important thing. The role of women who are not earning, that has not been properly respected. The family system is breaking. Now the Late marriage is another reason of increasing crime against women. So there are basically so many things, and we need to address all these things, because I think there is lack of proper study that once we are going to adopt such kind of things in the interpretation of laws, which are basically more focused upon the individualization of a particular individual in a family setup, we are talking about disintegrating the family values. We are creating a society where the people are more isolated. We are creating a society where people are more self-centric. We are creating a society where the people are not bothered about others' integrity. We are creating a society where people are not bothered about others' dignity. And this is the reason that in this kind of society, the women are the biggest victim. So now, after the rigorous discussion in this seminar, I personally believe that it is high time to develop some kind of mechanism where we should focus more upon corrective measures, and this corrective measure should be adopted or included in our children through their education system. And I think this proposed National Education Policy 2020, which is talking about 3-language formula and which is talking about the indigenous knowledge system, that can play a very important role. Here, one important thing I want to bring to the notice of all of you. Even our Hindu Marriage Act has been adopted from British law. And you will be surprised to know that when the Britishers came to India and they started playing the role of the judges, they were completely shocked to know that two people who are totally unknown to each other, they are going to enter into a matrimonial affair and they are completing their entire life very successfully. And you know, those who cannot believe in this philosophy, we are developing our legal system, our legal interpretations on the basis of their judgments. So in the name of constitutional morality, we are doing so many things, and the judges are saying if there is a difference between the morality of the society and the constitutional morality, the constitutional morality should prevail. But again, I am repeating the same question: who will decide that whose constitutional morality or what is the constitutional morality? You just take the example of Sabrimala case. In Sabrimala case, one judge is saying that according to the constitutional morality, the women should not be allowed to enter into the temple. Others are saying, according to the constitutional morality, the women should be allowed to enter into the temple. Now, the important issue is everybody is defining constitutional morality based upon their own perception. So in the name of the constitutional morality, the matrimonial reforms which are going to be played by the Supreme Court, up to what extent they can be justified, because in a way, definitely they are also contributing a lot in disintegrating the family. And I am repeating again, if the families are going to be disintegrated, then at the end of the day, the whole society is going to face a lots of trouble. I have seen young generation, they are frightened of marriage. They do not want to enter into the matrimonial relationship. But we all are aware that marriage is a necessity. So if legally they are not going to enter into such kind of marriages, then the people are going to deviate and they are going to indulge themselves in many other ways which is not ethical. So in that way, are we going to promote unethical activities? In the future, are we going to enter into an era where the people are more isolated, where the people are going to face different kind of psychological problem? So I personally believe that a deep discussion over such things is required. Second important thing is, we are talking much more about the liberty. Now it is time to talk about responsibility. The issue is everybody is so individualistic. Either there is a male, there is a female, there is a family, there is a society. Whoever is in the position to dominate, that wanted to dominate the others. But the problem is, if as a society we are not able to take up our responsibility, we cannot work together, we cannot move together successfully ahead, because we should believe in this concept that according to the law of the nature, every living and non-living being, they are involved into some or other kind of duties, and their duties is basically to do something good for others. The human behavior, the human nature, we are working against this concept of the nature. We are becoming more and more self-centered. It doesn't matter when we are going to hurt the dignity of a woman. It doesn't matter to anybody if somebody is going to cause any kind of violence against a particular woman. And that is the reason this self-centric attitude, it is creating problem. We are reading natural law, we are describing a natural law, but basically we are not able to understand that what nature says. The nature says, the natural law says that everything should be so inclusive. There should be respect for each and every living and non-living being. And surprisingly, we all, as a human being, we all, either there is a male or there is a female, we grow from a single cell. A single cell is going to divide, is going to multiply, and subsequently we are going to change into a male and female. Our bodily structure are same, our process of development is same, but when we grow completely, we started identifying each other on the basis of different gender or different sexes. Now it is high time to talk more about human rights, because I believe that in the name of gender justice, are we going to create some other kind of gender discrimination? So once we are talking about the gender equality, the most important thing is equal respect for both the genders. The boys and the girls, they should be properly trained through the education system. They should be made aware about their rights and about their duties also, that what is their duty towards their family, what is their duty towards their society, what is their duty towards their nation. And these things are basically not the part of the curriculum. That's why our entire society is a very directionless society. Many times I ask a question to many faculty members that what is the purpose of education? For what purpose you are teaching the students? They don't have any answer. Once I'm going to ask the same question to the students that for what purpose you are going to study, they are totally unaware. So, we are following an education system where we are totally directionless. Education is the basis of character building. And once we start giving a morality based or character based education, I am very much confident that we will be able to produce more law abiding citizens, who will protect, who will respect the rights of the woman in much better way than anybody else. With this, I just want to conclude my address, and I want to give a big thanks to the organizer for giving me this opportunity to express my views. And I think a very serious contemplation is required, that in which direction we are actually going and in which direction actually we should go, where we are going to land up if we are going to follow the same procedure, because an impact analysis of everything is very much required. As per my understanding, what basically we are following, if something has been done in America, if something has been done in United Kingdom, if something has been done in South Africa, then same thing should be done in India also. We should not forget that we have a civilization which is 5,000 years old. So most of the things in this country we have tried and tested, but in our judgments and in our legislations, we are going to copy those countries who are hardly 200 or 300 years old, whose entire history is 70, 100 or 300 years old. So there the law, the interpretations, the policies, the jurisprudence which they are adopting, that is basically not time tested. So we need to think over it also. And that's why self-realization should be a very essential part of the curriculum, unless and until we are able to realize the purpose of our life, unless and until we are able to evolve our consciousness. Definitely this problem of offenses, sexual offenses against women, we cannot handle it, even if we are going to create 100 more legislations. So with this, again, I congratulate to organizers, and I give my sincere thanks to Professor Sehgal and Professor Malhotra for providing me this wonderful opportunity to share my views to all of you. I have some other assignments, because we have invited Solicitor General Mr. Tushar Mehta in our faculty. So in next few minutes, I have to leave, and that's why I am bound to close my address a little bit early. So for this, my sincere apology to all of you. And due to some technical reason, I could not join from my laptop. I am joining this from my mobile, and due to instability of the network, I am not able to switch on my camera. But again, sir, thanks to all of you, and my best wishes to all of you to organize such more successful seminars in the coming years. Thank you so much.
Thank you so much, ma'am. In the end, I request Dr. Meenakshi Tomar, ma'am, Principal of IPM Law Academy, to give the vote of thanks. Good afternoon, all of you. As the seminar is coming to a closing stage, it is my humble duty to propose vote of thanks. I express deep sense of gratitude to the international and national speakers who spare their time for the participation in our e-seminar. We are grateful to you all for giving valuable remarks and guidelines on the topic. I also take this opportunity to thank to all the participants who presented papers on different themes of the seminar. I'm grateful to all the delegates who have connected with us via Zoom or YouTube. I hope that in future also they will oblige us in such academic activities. Lastly and most important, it would not be possible to organize this seminar without the cooperation and support of the schedule of Law Academy. I express my thanks to all of them. I also express special thanks to IT department for their technical support. Lastly, I express thanks to all the staff of IPM group of institutions for providing all help in making this seminar success. Thank you. Thank you all. Thank you, ma'am. And thank you everyone for joining with us today. It is requested to all the viewers and participants of today's event to kindly fill the feedback form. The link for the same has been shared on both the platforms, that is Zoom and YouTube. The e-certificates for the registered participants